20?
28, serial number
1 minute, let that page come. Yes.
My lord, 23, my lord, I appear for the appellant. Next week, please, my lord, I shall, and the interim order has to be.
Next week, they filed a.
I understand, it had come up before the last earlier roster. The matter was taken up and the honorable.
Where is the other side? Have
I
you
shall
informed
inform
him?
you. I shall inform you.
No, it is not about you shall, you must have informed by this time. We will see when the matter reaches, yes.
serial number 28.
Serial number 25, my lords. And for,
25.
please,
No.
my lords. And for the respondent, the counsel who is on record, he's unwell, my lords.
Then counsel, it is submitted, the counsel, the
Lords,
respondent.
any
is
date in the
unwell.
next week, my lords.
Post this matter next week. Have you informed the other side?
Please, my lords.
Post this matter next week on 6th of August.
Grateful, my lords.
28,
Yes.
6 or 7. 28,
Why adjournment?
email is outside station. That's right.
You appear for the petitioner.
Yeah, petition.
Post this matter on at the request of non-counsel, the appellant post this matter on 8th of August.
Amartya.
Yes.
Appearing.
33. So, serial number 33, appearing for the respondent. 3 days time I can file the objection.
Report from NIMHANS is received. Have you informed the other side?
I will inform the others.
No.
Over the phone.
In my court, without informing the advocates, please don't make a
I
mention.
shall inform.
Again, they'll come up.
I shall inform. I'll undertake.
No. You will inform, but they'll come to the court because they must be having
Please.
their urgency.
Just I rest.
Let it be. When it reaches, you can make a
Please.
mention. Yes.
Much.
Serial number 38, my lords, appearing for the petitioners, my lords. I request 2 weeks of adjournment. The matter may kindly be listed on 12. The senior counsel is out of town.
Appearing for whom?
Petitioner, my lords. Appellant, my lords.
Have you informed the other side?
Yes, my lords.
Let the counsel for the petitioner submits that, seeks a week's time. It is submitted that she has already informed the other side counsel also. Post this matter
On
on,
12th, my lords.
huh?
12th, I request on 12th, my lords.
Post this matter on 12th of August.
IO may be kindly extended.
Huh?
IO may be extended, my lords. Serial number 38, my lords.
Interim order earlier granted, if it is there, just look at
It's
it.
there.
Then extend it.
The ladyship, serial number 44. I am appearing for the petitioner. There's only one minor office objection that requires me to stitch a page the other way around. If I may be permitted to do so in the court, and if the matter may kindly be taken up tomorrow, your ladyship.
Let it be. When it reaches or not reaches, then if it doesn't, then we'll see. Give him the file. Yes,
Much obliged.
yes. Yes.
And for the
What
respondent,
is, what are your submissions?
Your Lordship, my only submission is regarding the interim maintenance that was ordered in the MC petition, Your Lordship. And the original MC petition that came to be dismissed for non-prosecution was challenged in the miscellaneous. And in that, it was also dismissed for default for not paying the arrears of the interim order, and was ordered in the miscellaneous petition that the arrears should be paid. Until date, nothing has been paid, Your Lordship. And we do agree that there has been circumstances and days where it has been paid, but only 60,000 has been paid, Your Lordship. And I've been taking care of the children who attained majority now. I've taken.
He was submitting yesterday that he was taking care of the children. He was
He
paying
has,
everything.
he has taken care, but only in certain intervals, Your Lordship, not entirety of the, he's not taken care of.
And how it will be calculated now?
He's only, the only calculation that we have is he's paid 60,000 of amount, Your Lordship. That is That's the only measure, that's the only money that we've received, but nothing to me, not a penny has been paid to me, Your Lordship. I'm not working. I've been taking money from my father and I've been leading my life however possible, Your Lordship.
Yes.
This is a matter, my lord, in which it is better if the parties are directed to be present in this court any date after 2 days, because the other side did not cooperate with mediation center. Report is there.
If she is not coming, what is, why should we call her? This is a writ petition of 2011.
May I make a mention? Your
No,
Lordship?
we have to, we'll pass orders on the merits of.
May I make a submission on the 2 days of the mediation center? I have the advocate, that being me, I have appeared and I've made a mention that my client does not want to come here because she has her own hardship and she's under depression and she doesn't want to attend the mediation proceedings, Your Lordship. I've made my mention, I've even informed.
How can she say that when the court refers her?
I agree, I understand that, Your Lordship, but I've even spoken.
She doesn't appear there.
I've even spoken to her. I've made her understand that, you should come because you should adhere to the court order. You should respect the same. But somehow she is not in the condition to come here and appear in the mediation proceedings, Your Lordship.
Then we'll allow the writ petition.
And please, that is not my submission.
No, this is a writ petition of 2011. What will happen now with all that? How much was the amount till that time?
That was ordered for 4,000 per month and 5,000 towards her minor daughter then, and 2,000 towards her son. Now they've attained majority. They are of 27 years. The daughter is of 27 years and the son is 23, Your Lordship. This was ordered on in the year 2009.
But anyhow, it is not that MC itself is dismissed for non-prosecution.
Non-prosecution.
So as on that day, she is entitled till such time. So when was the petition? When was that dismissal?
Petition was of the year 2005, Your Lordship.
Dismissed on?
Dismissed on,
Order was, when was the order?
please, one second.
When was the dismissal?
The dismissal was on 21/10/2009 for 21/10/2009 for non-prosecution, And this was challenged in miscellaneous.
So
Please,
from 21/10/2009, that is petition is 2005.
please.
The date of the petition?
Thirty-three, 2005.
33/2005. What was the amount you said?
4,000 towards to the wife and 2,000 per month to the respondent's minor daughter back then, and 2,000 to the minor son, Your Lordship.
Another 4,000.
Please, Your Lordship.
That is another 4,000.
4,000, please.
How much he paid?
My calculation is from the petitioner, from the respondent, is that I've only received the amount of 60,000 back then, Your Lordship.
What do you say? He says that they have received only 60,000 from you.
Yesterday, I will come to that. Yesterday, I requested this honorable court to read para 17 of my petition. Para 17 at page 8, which has not been controverted. In other words, I am looking after the interest of the wife, giving her groceries, and in the residential premises she is living. I am informed that she has let out one portion to some tenant. I could not get the particulars. If I get the particulars of letting out, that will be not less than 25 lakhs.
Not less than
25,000. That rent she may fetch.
that, that you're paying.
Your Worship, he
I'm not
submits
paying.
that the house that I'm staying in is the property of the husband, and I've also let it out for rent, and I'm getting 25, I don't know the amounts. Yeah.
You must know.
I'm not aware, Your Worship.
If that is calculated, including what I have stated, I am supplying everything to her. And the children are majors now. They are with me.
Where is she residing?
She is residing at that house, which belongs to me,
Hmm.
which belongs to me.
What about the rent you are shifting to? Renter. 25,000. According to you,
She,
uh,
the other side says, she has let out a portion of the.
I don't see it.
it is not. She is telling the court that you said so. She understood it like that. According to you, you are residing there in the house. It would, she is residing in your house
Yes.
and it will fetch 25,000 rent according to you.
The portion, if let out, will fetch 25,000. It's a
Yeah.
big house. He's an architect.
Regarding the groceries, that's not true, Your Lordship. I take money from however means I get from my father or my relatives. I have brothers who help me in ways. I take groceries. I help my children from 8 to 10 years. I've been helping.
That is one that you have given the house for house
Living.
free. Then what about the other expenses that you have bore so far?
I have stated groceries, supplying groceries to her. The son and the
You should
daughter.
have filed your objections.
I have
In
stated,
2011 matter, you people don't do anything and no representation. When the matter comes, client is not interested to pursue the matter, then why are you will allow his writ petition
Your
then?
Lordship, if I make a submission, our names are not shown whenever it's called. The name Nagraju is called out, and we are on record. Guru Raj R and Aishwarya Hegde, we are on record, but somehow it doesn't show, Your Lordship. Nagraju is an old colleague, but he's not with us anymore, and we don't get this notification. It's on us. I agree, Your Lordship.
So
That's
how
the
do
only-
you decide it now, 2011 stage? What has happened after that?
If I may take instructions from my client, how much she's received in actuality, I'll make a submission on.
Not further adjourn, get
Please.
call her and find out, pass over.
instead of Passover, Lord, may be taken up 2 days since. Not well.
They have posed this matter on
4, 8,
on Thursday, on Friday. Friday. Heard the land counsel for the petitioner, the respondent in part, land counsel for the respondent seeks time to get instructions.
Your Lordship, one request, if the name of Guru Raj R may be shown in the cause list, that'll be helpful.
You see that, it shows name of, write and give it on. Yes. We'll take up your matters at 2:30.
2:30.
2:30 will take
I have
time.
another matter.
After that you come.
Oh.
Madam.
Yes.
You have responded, my lord. I filed application seeking to recall the order brought by this honorable court, my lord, whereby the interim compensation is, my lord, enhanced from 15,000 to 40,000, my lord, without serving notice on me, my lord. But the notice has been served on the trial court advocate, who was not at all my advocate at that point of time, my lord. At that, I took NOC, my lord. It has
Let
not
us
been
see your
informed.
affidavit.
Kindly see, my lord.
Where is the affidavit?
Application para number 3, kindly see, my lord. It is submitted that due to shock and surprise of the respondent, during the last week, the petitioner demanded to the respondent to pay a sum of rupees 40,000 as per the order passed by this honorable court. And on inquiry, it came to know that this honorable court by the order dated so and so was pleased to modify the order passed by the family court by enhancing so and so, so and so. Well, kindly see the WhatsApp chat, my lord, where she only informed the respondent. Sorry. Madam, kindly see the WhatsApp chat, my lord.
Para 4 also, your lordship.
I'm looking at.
Okay, listen.
4 is important, my lord.
Yes. That being a case, she would have informed the same, my lord. the filing of the petition. Madam, kindly see the WhatsApp chat, my lord. Where through only I came to know that the passing of the order will it is between the respondent and petitioner, my lord, where the petitioner herself informed the respondents. Kindly see, my lord. My lord. He informed, mail you to please check. Above that, my lord, there is attachment of this order for this honorable court on 20th March, my lord. On 28th 3 March, I filed this application, my lord. And also next page, my lord, this is a male correspondent, my lord. She only informed. She informed the passing of the order, my lord, but she has not informed the filing of the writ petition challenging that order, my lord. Madam, may I make a submission, my lord?
Then what is his chat for that when an order is passed?
No, my lord, the thing is, my lord,
No, you file the WhatsApp chat as far as the order is, she said, High Court has passed an order. Where is his chat subsequent to this? In reply to this?
in
What did
reply
he
to this,
say?
my lord, it is WhatsApp chat between the husband. She is not disputing.
Correct, I'm saying, the wife said the order, High Court's order, please check it.
Yes.
He is not aware of the High Court order. What was his reply to this?
Well, for that, my lord, there are to be inquired in the
He
website,
must
my
have
lord.
replied her too, no? He must have replied her also, saying something.
No, my lord, I have not challenged that order, my
can
lord.
choose
My lord,
WhatsApp.
my lord,
Please
I am,
understand, I'm not
I
saying
am, I
all
do agree,
that.
my lord.
No, please understand what I said. You filed a chat saying that the wife had forwarded the High Court order.
Yes,
Then, once you see the High Court, you have only filed the WhatsApp chat, right?
yes.
So once you have seen it, you should have said something. You must have replied to that saying that, oh, is it so that I didn't know when this happened?
My lord, I think,
What did he say?
my lord, for that it's not relevant, my lord.
It is also necessary
No,
because
no, no, my lord, the
just
thing is,
like
my lord,
that, now this process of serving the notice on the lower court counsel, then we should stop it now. With these
No,
kind
no,
of
my lord,
applications, if the respondents are coming, now the
And-
whole
my lord,
purpose
my lord,
is
if the trial
so
court
that you
advocate.
can have a effective disposal or
Yes.
a speedy
Yes, I
disposal.
do
for
agree,
the-
my lord, I do agree.
May I
I'm not
submit, my lord?
disputing, my lord.
I'll just
Madam, I do agree, my lord.
few minutes.
Let him come,
My lord,
please, when you
I
can
do agree, my lord. Only thing is, my lord, by believing the version of the petitioner, my lord, this order has been passed, my lord.
What about the
No, no,
believing
my
the
lord, let me clear, my lord.
We'll come to that later. First step is court, it is not an ex parte order. Court has issued a notice to your, is he not your advocate as on that day?
No, my lord.
No, that's false.
When did you?
That's
then
a
for
false
that you
statement.
file an affidavit.
No, my lord, that's a false.
You file an affidavit before.
15,000 and the maintenance granted, he has argued it. Mr. Sebastian advocate has argued. They are making a false submission.
You engage the other advocate, please tell the.
No,
court.
let
I
them
only
say when
filed
NOC
wakalat,
is
my lord.
taken.
I only filed wakalat, my lord. I
No,
only filed
NOC
wakalat.
to file the
Subsequently, my
wakalat.
lord.
When?
30th of March. Ma'am, I was in Netherlands. She sent me the mail. I have taken the first flight and I've come here and I have spoken to 3 lawyers. Sir has agreed to take it.
What has happened to the other lawyer? The one who is
They
there?
did not appear. I was in India during the family court order was passed. I was in India. I have given them call. I have messaged them. No response to it. I have gone back on after celebrating Sankranti. I was there for 25 days here. Okay. Even I have met my daughter on Sundays. I have not been informed of the family court order. Then on February 28th, this order has been passed. I got to know on March 20th, when I reside in Barcelona, I was in a conference, 3-day conference in Amsterdam. I have left the conference in the middle. I can show you the email group. I have left on the first day and I have come flying here and have tried to reason with my lawyer why they did not appear. And my lawyer called the junior lawyer and said, hey, why did you do this mistake? And I knew because they had not appeared on the previous time also when the visitation was granted and I was made to run around. It's been, anyways, I do not want to talk about it, but yeah, this is what happened. It's been 2 years since I've met. Client is, my ex-wife is living in the house where I paid 54 lakhs. Everything has been given in black and white. It's in my bank account. My father's PF I have taken out. I borrowed money. My 40 lakhs worth of jewelry is with her. And 2 lakhs I've given day before yesterday as per the I was picked up from the house saying that I'm not paying. We have gone 3 years for the mediation, tried to reason with her to come to a settlement. She's left the kid with me after the divorce when school fees is pending, and I have paid 2 quarters fees. I have paid without the direction from the court. I have also paid school fees. Only when she has filed this court, she's changed the password, so I cannot pay the fees. Until then, without direction, 2020, 2021, 2022, 2023. I have paid the fees. In 2023, before filing this, I was jobless. I was doing my master's, 17 months, no movement on the case. When I finished my master's, the first month I get my salary, there is a movement. I have spoken to my lawyer. I have tried to consult him. There is no response. I have been here. I have tried to reach out to them. There has been no response.
Whatever you stated, all are lies. Till today, not even 1 penny has been paid. What he is talking about, 54 lakhs, is the house which he is owning, 2-bedroom house. Which is owning.
Joint ownership.
When he is submitting, I have not spoken. All false submission. 12 years old child is there, my lord. Not even 1 rupee has been paid. All dramatic, nicely they did in the trial court. This maintenance application has been argued by Mr. Sebastian. I have one more writ petition order where Mr. Sebastian appeared for him in High Court for the Christmas vacation. He was the lawyer on the date of arguing the maintenance application when we came for enhancement. And he is the one advocate on record. No advocate will receive if they are not advocate on record. Your lordship may kindly see their own affidavit, which is contradictory to what they say. They clearly state here in their 4th paragraph, your lordship may kindly see the of their affidavit, my lord. It is submitted that the petitioner, though in continuously contact with the respondent virtually, suppressed the filing of above writ petition, got obtained the order of this honorable court by suppressing the true facts of the case only in order to make wrongful gain. And also the advocate who is appearing on behalf of respondent before the family court has not informed the receipt of the writ papers. So he admit that Mr. Sebastian was their lawyer. NOC was obtained after this order, my lord. After this order. And they are making a false submission before the court that the lawyer did not inform. Did they plead anything to that extent? Did they take an action against the lawyer before the bar council? If at all he has been their lawyer and he has not appeared. This is a false submission, which is unwanted allegations on the lawyer, which may not be accepted. Your lordship may kindly see the order. In the order, the court has verified it, that the copy is served, and then only the order on merits has been passed. Your lordship may kindly see the order passed here. In the order, your lordship has recorded that, yes, ma'am. Your lordship may kindly see para 5 of the order. Enhanced order, my lord, enhancement. This court has perused the memo filed by the petitioner wherein they have served notice on the counsel appearing before the trial court. Considering the memo, notice to the respondent is held sufficient. It is only after the direction of this honorable court we have served. And the same lawyer has argued for the maintenance. Now, after the merits order has been passed, now they cannot come and file a NOC vakala. It's taken after this. Is it permissible under law, my lord? On merits, the order has been made. Your lordship should see the ingredients of this order. 12,500 is the school fees. Your lordship may come to the previous paragraph, which is recorded that it has not been paid. Your lordship may kindly see paragraph 4 itself. He doesn't file assets and liabilities. He takes an ex parte decree of divorce, which I have got it set aside by this honorable court, staying with the wife. He takes an ex parte decree. He is expert in that, your honor, your lordship. Para 4, your lordship may kindly see. How much EMI she is paying. The learned counsel appearing for the petitioner, para 4, my lord, of the order. Yeah. By way of memo has filed assets and liability statement as well as supporting documents. As per the statement, every month she is paying an amount of 72,000 towards EMI, rupees 12,500 towards the school fees. It's submitted to maintain herself and her daughter. She requires 40,000. As such, she has filed an application seeking maintenance because 15,000. Your lordship may kindly see this complete recording has come. I'll read further also. Learned counsel submit husband has failed to take care of the child, and also in spite of service of notice on him, he has failed to appear before the court. It submitted that on last occasion when the matter came up before the court, this court has permitted the petitioner to serve notice on the counsel who represents the respondent in the trial court. Accordingly, notice has been served on the counsel, also filed a memo in this regard. It is submitted respondent husband has a duty to maintain his wife and children, and which he has neglected to do so, and also has to pay EMI of the house loan availed by them jointly. And if EMI amount of 72,000 is not paid, the same would be auctioned by the SARFAESI. She submits at the court below without considering all this aspect, has granted only 15,000 rupees. Then the court has perused it. Then the next paragraph, your lordship may kindly see. Even the order passed by the court below, the income of the petitioner is 97,000, and she filed a statement affidavits showing her assets and liabilities. The husband, for the best reasons known to him, has not filed assets and liabilities before the court. The learned counsel, by way of memo, has filed all relevant documents before this court, along with assets and liabilities and her bank statement, which shows that every month 72,000 is deducted from her EMI. Her salary is 97,000, and if the EMI is deducted, she's left with another 25,000. In that, she has to pay the school fees, take care of the other requirements of her daughter, and has to maintain herself and her daughter. The court below, having considered all these facts, has granted only 15,000, an amount of 15,000, which will not be sufficient for both the wife and the daughter. In that view of matter, considering the affidavits and assets and liabilities filed by the petitioner, and also the school fees and other requirements and assets of liability, statement shows that she's paying an EMI of 72,000. The order by this court below is modified. If your lordship may see the trial court order, assets and liabilities, he doesn't file. He has 2 lakh rupees. She could have even asked for 1 lakh rupees as maintenance, but she only asking the amount what she requires to maintain the child. She has declared everything. What is her salary? Everything she has declared. He is not paying even 1 penny. He is gone and sat off in Spain. He's telling, I am aramse enjoying my life. If your lordship may kindly call for the entire records. In the Instagram page, it's only with the girls. With so many girls, the child refused to go and stay with the father because he's having another women in the room, and he puts the child in between. All this is instance which is before the trial court on evidence. Having done all these things, he takes an ex parte order also. Staying with her, she gets aborted. And then he goes to America and he sends a message, I've taken ex parte decree order. I got it set aside by this honorable court. All these things he having done, till today, after we filed our execution petition, my lord, after he was picked up from the home, the honorable court said that you have to pay this maintenance amount, what has been ordered by the honorable high court. He has paid 2 lakh rupees and he has got the order modified, and they submitted the matters before high court. So we will argue after this. This is the attitude and the conduct of the party, man. How she is going to survive with a 12-year-old child, and her entire salary is only 97,000. She has declared everything. 72,000 rupees EMI, my lord. She's literally in tears.
First thing, my lord. Being a client, he can make allegation against the advocate, my lord. He can make allegation against the advocate, conduct of the advocate, my lord. But being a brother colleague, my lord, I don't want to make allegation against the advocate who is
No,
at the court.
let's-
No, that's the one thing, my
Let's
lord.
have the matter.
One thing, my lord. Second thing, my lord, what she
Why
said.
did he not file his statement of
My lord,
assets and liability?
my lord, the allegation is that, my lord, the trial court advocate is not informed about the case status, my lord. What was transferred in the case? He's working in Spain.
No, tomorrow, no, please understand this. No, we'll pass an order now. Then the same allegations on you also,
No, it's not like that, my lord. Not like that.
saying
That's
that he has not properly argued, he has not properly brought it to the notice of the court.
Well, he is before the court,
No.
my lord. My lord, he is before the court, my lord. How can he?
So you're,
My lord, my lord.
no, so you're secure.
No, my lord, my lord. Only one submission, my lord. I don't want to argue on merits, my lord, without filing objections, my lord. Let the order may be recalled, my lord. Let us survey copy of
No,
petition.
we
My lord,
will-
one submission, my lord.
Please prima facie show what is your case. We'll not recall the order without that. You please show the court what
My lord,
is the
without
prima
filing
facie
the
your case.
objections and documents, my lord. How
You
can?
file the documents, you will see then.
My
No
lord,
order will not be
my
recalled.
lord, submission, my lord. Till then, let them not precipitate the execution petition, my lord. Let it have next week.
Not file the documents, file it tomorrow. File it tomorrow, we hear
I
you.
want some time, my lord. 3 to 4 days, I want time, my lord.
When
my lord.
when did you file this application? Please tell the court.
I filed
Is
it.
it not something like, no, how will the
My
wife
lord,
survive?
one thing, my lord, I don't know what was the ground urged in writ petition, my lord. I don't have a copy of writ petition. What are the documents produced by the petitioner, my lord?
You do it, but we'll not.
No,
grant
my
any
lord,
interim
let us
order.
have a copy of the writ petition, my lord.
No,
Without copy.
let him pay. No, when was the order passed by the court below?
Maintenance order was passed, my lord, on
That's on 14/12/2023.
When was the petition filed?
petition
14/12/2023, my lord. Petition is filed.
Can I just say one thing,
20.
if you can permit? I have bought the house. I have everything in black and white. I bought it because she asked for it.
There is no EMI to the house.
Ma'am, I have paid for 3 years. I have paid 3 years. This.
No, we are not concerned about what have you done earlier.
Ma'am,
No, is
she
is she not paying?
It's a 3-bedroom house. She has given 2 bedrooms for rent. She is getting 40,000. It's a 1,700 square foot. Okay, and it is 3-bedroom, 3 attached bathroom house. If you go there are cupboards filled with somebody else's stuff. Okay, she's taken my daughter from the, I bought that house because she tried to commit suicide. That is what has
Sorry.
happened in Canada and also here.
Yes.
In HSR police
Minister
station, I
petition
I
filed.
registered this.
It is on 12/3/2000. No, it is Guardian and what side?
2020, ma'am. The application is filed.
That is GNWC.
Yes, GNWC.
So where is the IA for this?
IA is, not should be gets it in.
Date of filing of petition 18/1, my lord, 18/1/2024.
IA is on page
Petition, date of
71,
filing
my
of
lord.
Petition.
71, my lord.
Petition.
Maintenance petition.
71 page of the petition.
See?
71 page, annexure D, my lord. Maintenance
Filed
application.
on
22/12/21. The very next document is the objection filed by the advocate, my lord.
Where is that document, objections?
Next page itself, the next annexure itself, page 75, annexure E, my lord. Just one more submission, my
No,
lord.
1 minute. No, till now, how much he has paid?
He's paid nothing except last week when he was forced to pay 2 lakhs.
My lord,
He's
please,
paid
1 lakh.
nothing
No.
from the date of,
1 minute, 1 minute. That 15,000 which was granted by the court, you have not questioned it.
No,
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 he
you're
has
not
not.
questioned.
They have questioned it.
My lord,
yes.
Please understand.
Yes.
No, from that to till now, it is 32 months
Yes, my lord.
from the date. It
Yes.
would come to 4,80,000. Let him pay 2,80,000 by tomorrow. Then only the court will grant the time for
My
you.
lord, apart
And
from-
not to,
my lord,
not to
apart-
precipitate
my
the
lord,
matter.
pursuant to the passing of the order, my lord,
Huh?
apart from 2 lakhs, my lord, he paid another 50,000 as a cash and also 70,000 towards the school fees, my lord.
No,
That
it's
will be
not
taken
true.
into account. It's my submission, my lord.
All without
Then
any
the
documents.
Show to the court will pass over, show to the court whatever it is, then otherwise, unless and until you pay 2,80,000, the execution will not be stopped.
This will also become a bad precedent in future, my lord. When an order is passed on merits, if your lordship may kindly see the lower court order, court has appreciated the application as well as the objections. And after considering, she has passed 15,000 rupees, which was not reasonable. So she came before this honorable court and that was seen by this honorable court.
Ma'am, apart from those 2 lakh, I've given 1,20,000 directly to the school. I am showing the receipts that I've paid. 2 lakhs I've paid last week. I paid 1,20,000 directly to the school. I have the receipt. I have the net banking transfer.
Give it to your advocate.
I have given it. I have everything as a proof. I have mail also. So I'm
Then
just telling.
please get all those documents. We'll have it tomorrow. Then basing on that, we will see what is happening. Please.
Really pass over, otherwise pass over.
Pass over. Yes, next matter.
Is it passed over, my lord?
Pass.
Part of.
And beforehand, give the documents to her. Copy of it to her also,
We'll hand
so
over.
that she'll get instructions. Yes,
I'm appealing on behalf of the respondent number 1 and 2.
appearing for the respondent. You there?
Here, the order was passed on 11th August 2022, my lords. So as per the orders, the lower court has directed the petitioner to pay 20,000 every month as maintenance from the date of the application. So according
Also,
to
the petition is present, no representation for the comes for the respondent is present. No representation for the petitioner, post for dismissal on 6th of August. Yes, next.
In this case, I appear for petitioner.
Yes.
The annexure H is challenged. There is an order passed by the family court, my lord, with regard to that restraining me from contracting the second marriage. My contention is only this. At the time of filing an application, that he have produced certain 2 photographs.
What is this order?
That, pardon,
What is the order impugned?
the order impugned, my lord, is that the family court has directed me that I shall not go for a second marriage. But my contention before this honorable court is, at the time of filing an application, that he has produced 2 photographs showing that 2 girls, I am with the 2 girls, that they have already married, that I have brought to the notice of the trial court with regard to the date on which
Let's
these.
see the order. Please come to the order state.
Please, annexure H, you lost some times. At page 84. May I read the reasoning?
You obtained a divorce.
No, my lord, I have filed. My divorce petition is still pending.
And then how can you go, how can you marry?
No, that I am not having any such intention, but the application is filed in the petition, filed by the respondent under section 9 of the Hindu Marriage Act, Restitution of Conjugal Rights, that in that proceedings, she has filed an application that she produced. With regard to that filing an application, that there is no problem. But they are bringing those 2 girls who have already married, that as if it is there, impliedly they are saying that I am having some extramarital affair with those girls. That the trial court has made an observation that I have not produced any documents to show that the photographs which they have produced are the earlier one. That now I have already produced those documents also. In another proceedings that they have initiated under the Domestic Violence Act, she herself has stated that the girl, that Kavana, is already married. That in our dispute, why the other girl should be named, and based on that, they want to get an order.
Anyhow, you cannot get married.
No, I cannot get married during the pendency of the proceedings. That in our proceedings, that why it should be.
You, which part of the order you are agreed by?
That
Please read
the page 91, Milon,
it. Yes, please read.
91, that from so as to get your lost blood. So as to get this order, and he has also specifically mentioned the dates of the photographs. Annexure D1 was taken on 15/2/2019 at 11:47 p.m. and the same was uploaded to Instagram story on 2/11/22. On the occasion of the birthday of the said lady,
And he has also narrated annexure D2 photo also taken on 23/1/2020 at 5:47 PM. And the same was also.
Particular observation that you have not produced any contra
Yes,
evidence.
ma'am. That I have now I have already produced that particular photograph. In another proceeding, she has also admitted that that particular lady was already married. So under in our dispute, our contention is only this. In our dispute, that let there not be any observations with the other ladies. Why? Let them obtain an order that I shall not marry and all other things, that they can hesitate.
It is
That
all
based on
unnecessary,
this.
it's all unnecessary discussion.
Unnecessary discussion.
Where is the counsel for the respondent?
For the respondent, my lord.
Yes,
My lords, I would like to bring to your honor's attention when the proceedings was pending before the Honorable Family Court, and I had filed a petition seeking a prayer of restitution of conjugal rights. And I see that on very specific previous dates that these two photographs surface on the Instagram stories. Now, my reasonable apprehension is I've nowhere stated that he is going to get married to this woman. And these are very much, I was aware they were friends of my husband. Now, however, surfacing these photographs on when the proceedings were going on, and I also get some other intimation, through the circle of friends that it is spread that the father of the petitioner is trying to get his son married before the proceedings, the matrimony proceedings could get completed. I have nothing against these two women, my lords, but the time in which these photographs surface, and that too at midnight when the proceedings were going on, and I had a faith that I can still restore my marriage. And if at all, by chance, if he gets married to any other person, the prospects of my marriage getting restored.
as far as that order with regard to what is ultimately the order is passed.
Ultimately, that I shall not
The
marry.
order has been stayed.
I am not on that, but.
As far as these observations are concerned,
That-
they are not necessary, should have not made by the court. Please come. The present writ petition is filed, agreed with the orders passed in I number
3.
I number 3. I number 3 in MC number 5499 of 2023, dated 4th October 2023. The petition before this court is a husband. Husband has filed. What is your MC number, divorce?
That MC number.
5499 of 2023, my lords.
Then what about your restitution? You filed a counterclaim in that.
Yes, my lords. 5499 of 2023 is my MC petition for restitution.
Their petition for divorce?
Their petition for divorce is.
Both the wife and husband have filed. Husband and wife had filed MC 5499 of 2023 taking restitution of conjugal rights. But husband has also filed MC seeking divorce. The IA numbers 3 and 4, 3 and 5 are filed by the wife. She has filed IA number 3 under order 39 rule 1 and 2 that the marriage is that the parents of the parents of the husband taking an interim direction not to contract second marriage till dispose of the petition. And the court had granted an ex parte order of injunction. Then an application that is IA number 5 was filed by the husband stating that the petition is filed by suppressing the material facts and misleading the court and got an ex parte order. The same is liable to be vacated. It is the case of the wife that she has produced a photograph where the husband is along with the other women. According to her, she's getting or he already got married.
So she was already married.
No. What is the case of the wife?
That the case for the wife means by producing those documents, that I am preparing to get married.
They're going to get married. The court had to dismiss the application filed by the husband and allowed the application filed by the wife. While allowing the said application, the court gave a finding that according to the husband, the photographs at exit D1 and D2 are taken prior to marriage, and they are the colleagues of they are his colleagues, and the wife had made false allegations misusing those photographs, and he had mentioned the dates of the photographs as 15/2/2019 at 11:47 p.m. and the same was uploaded in the Instagram story on 2/11/2022 on the occasion of the birthday of the said lady. And according to him, D2 photo was also taken on 23/1/2020 at 5:47 p.m. And the same was also uploaded to Instagram story on 17/7/2020 on her birthday. The court observed that though it is stated that on so and so dates those photographs are taken, the husband has not produced any such alleged photographs, much less annexure D1 and D2 with specific date and time. Therefore, whether the photograph at annexure D1 and D2 are taken before the marriage or after the marriage can only be gone into at the time of trial. And this stage, court cannot say anything which is not before the court, and therefore the sworn testimony of the petitioner, along with IA number 3 and the protection of annexure D1 and D2, makes out a prima facie case in favor of the petitioner, and in order not to believe these photographs, there is no contra evidence, and accordingly, the court felt that the wife had made out a prima facie case and granted injunction restraining the husband from getting married during the pendency of the petition. Land counsel appearing for the petitioner submits that the petitioner has no intention to marry during the pendency of the proceedings, and unnecessarily the photographs are filed before the court, and the people who are unconnected with the litigation between the wife and husband are being dragged to the court, and the court gives an observation that will be gone into during the course of trial. He submits that those are in that manner, court cannot look into court cannot consider those photographs. Where is that your file is saying something?
That the photographs that I have produced at page number 80 from 78 is transmitted, along with the marriage certificate, with the photographs when they were taken.
17?
78, that's the marriage certificate of the girl.
He has produced the
Annexure F.
He has produced a marriage certificate of the girl with whom the petitioner with whom the husband was seen, and according to the wife, he is going to marry that girl. That the marriage was solemnized on 2019. Correct?
Yes, on 1st June 2019.
19. And what about why you have filed these photographs?
That the other photographs, my lord, that when the trial court has observed, that when actually that it was snapped, that 2019.
He has also filed the photograph to show that they were taken in February 15th.
15 February 2019, and another one is that 82, that is on January 16, 2021.
And also he has filed the marriage photographs of the lady. Basing on this, land counsel submits that those remarks passed by the court are most unwarranted, and the application filed is liable to be dismissed. Learned counsel for the respondent submits that when the wife had filed a petition for restitution of conjugal rights, she want to join the husband. If these kind of petitions, these kind of petitions cannot be, and if he gets married, and she has reliable information that the husband is going to be married. She had filed the application and court had rightly granted has passed an order restraining the husband from getting married. Next part. Having then counsels on either side, there is a material on record. Wife had filed a petition for restitution of conjugal rights. Husband had filed a petition for husband has filed a petition for divorce. The wife that they are going to get married, that the husband is going to marry a girl in the photographs which she's seen, that is her information. The wife, the husband stays before the court that he is not married, and as the matter is pending during the pendency of the petition, he cannot get married. Just because some photographs are filed, when the wife files a petition before the court, relying on some photographs, the burden lies on her to prove that when the photographs are taken, but not on the husband. If the petitions of this nature are entertained, and wherever, if the wife comes before the court, relying on the photographs, which are relying on the photographs which appear on the social media, and everybody is dragged into the matrimonial proceedings, it would have unnecessary. It will have it will have an effect on the family and the personal life of the other person. The claim of the wife is that he shouldn't get married. Husband is also saying that he has not got married, and during the pendency of the case, he will not get married. All these photographs and all these things are not relevant for this particular dispute that is pending between the parties. In that view of the matter, the order of the court, as far as pertaining to those photographs and consideration of those photographs is concerned, is set aside, and considering the submission made by the husband that he is not going to get married. Accordingly, the appeal is partly allowed. Reconfirming the same, the appeal is partly allowed.
Obliged.
Yes.
Correspondent.
I have complied with the order, Your Lordship, and 49,000 is paid to the account of the respondent.
Yes, here. What is the order?
The impugn order is, this order dated 16/3/2024, passed by the learned principal judge, Family Court, Shivamogga, on higher number 1 filed by the respondent for the interim maintenance.
How much is claimed?
It's 12,000 euro.
Was claimed.
She claimed it's 40,000 and the
40,000.
court was passed at 12,000. Because the
Agreed by that. What is your income?
so only 17,000. I am getting the rental income of 17,000.
Let's please come to the order.
Connection A, page number 16 to 32. Your Lordship, this
How much rent you are getting?
rent is 17,000.
What
And-
have you filed your statement of assets and liability?
Yes, I have filed.
Then what is the finding of the court?
This, the court is considered only the educational qualification of the petitioner. Means he is completed his BA, LLB, MA in English. The last page of the order, Your Honor, there's a page number 31, paragraph 22. .
In the affidavit of disclosure of assets and liabilities, he has
Did-
not stated anything about his employment, monthly income. But in part G of the said affidavit, he stated that he has purchased share of elder brother in the ancestor property. He is not having any joint property. He is presently residing in the, he is giving 3 houses rent so and so on lease for rupees, and he has availed loan of so and so.
It's 20.
Any piece of document in support of his contention.
Yeah.
Even he has not produced. Now, without producing anything, how should the court take all their statements as a gospel truth?
Yes, I agree with your lordship, but she has deposited her evidence on main
First
matter.
of all, let us come to your case. You
Yes.
are, when you have when you're supposed to file all the documents without filing anything, whatever you say, why should the court consider it?
This is the last paragraph of the, this one, 22 paragraph.
What do
But
you
I-
say about 21? What do you, please tell on 21 first.
Yes, I didn't get the opportunity to file
Not
because I was,
produced- He has not produced the copies of bank statement for the last 3 years to know his financial status, which is required as per the judgment of the apex court.
I have filed my assets and liabilities, but I have not produced that,
Having done so, you should know that.
She
you
was
have
also
to-
not produced, Your Honor.
Huh?
Your lordship, she was also not produced.
What she has not
The
produced.
bank statement she has not produced. She has given a false evidence before the court. She's earning 60,000 per month. She's working in the Reliance Insurance Company. She has not disposed in her assets and liabilities also. She has not stated one word about her employment. But in the cross examination, she was admitted that she was
No,
previously
both of
working.
you- No, both of you will not do anything before the trial court. You will come before the high court. Now, high court either has to do the work of a trial court or send it to back to the trial court. Why?
Your lordship, it is not fair because only based on the qualification, the court has come to the
And
conclusion
how are
that
you
yes.
fair without filing any document? When first you be fair, then tell the court that the court is not or the other is not, other party is not fair.
But she has not produced any material documents. She has adduced her evidence on merits. She was
What is to
falsely
be done?
cross-examined.
So both of you are now equal. What is to be done now? And why should the court's time to be wasted?
But I will produce my documents at the
Why
time
you
of,
have not?
because she was adduced her evidence in the, yeah. So I didn't get the opportunity to produce. But the same day.
Not about the opportunity.
Because,
The honorable
Your
apex
lordship-
court judgment clearly categorically says what are the documents to be filed. That you have to file irrespective of whether what the other side has done.
Your lordship, 3/2/2024, I have appeared before the court and filed my wakalat. 17/2/2024, I filed my objection. Same day, she filed her evidence and she argued on the high. And 2/3/2024, I was partially cross-examined her. She admitted her previous employment. Then same day, this matter was posted for orders on high. And
You're
60,
filing your objections, part of it you filed, part of it you are not able to file. How is it? Part of it you are filed.
because that time I didn't get my bank statement because I have filed my assets and liabilities and I accepted because I have this much of income and I have the liability of 20 lakhs.
Court can't take whatever you say. Court
It's
can't take
assets
into
and liabilities,
consideration.
Your Honor. Because
No.
she has filed, she is,
It is supported by the documents.
She
If
has
you're
not-
saying that I am taken loan, which loan you have taken, how much you are paying. If you say that this is, no, about the bank, unless and until you show the bank statement, court can't consider whatever you say on oath or on an affidavit.
yes, Lordship, she has not produced any material document to show that I am earning 2 lakhs per month.
Forget about her. Forget about her. You tell the court, what did you do?
She didn't admit, she didn't tell the truth in her assets and liabilities. I have stated in my assets and liabilities, I have getting this much of income and I have the liabilities. And except I have not produced only bank account.
Case is that living in a rented house, having a seven.
You have not filed your statement of assets and liability.
I have filed my statement of assets and liability, which has been filed. Their case is that I'm still working. According to the wife, she has discontinued her wife work from the year 2019. Now she is staying along with her parents in a separate house. She has
You filed your
worked-
bank statements also.
Bank statement I have not filed.
Why both of you are, there is any immunity for both of you not to file? No, this is what is happening is every time this is waste of court's time. in every case. You have to, you don't do it. No, from now onwards, I've decided that wherever you have not filed, both of you have not filed the statement of assets, whatever is the order of the court, this court will confirm. That's the only way, because the court's time is very valuable. No, it's pending from 2023 in this court. It's an order passed in 2023.
It's a December 2023, 14/12.
So why, when both of you, when you are not raised these objections before the court, when you are not doing what you are supposed to do, why should this matter be again remanded? Why should this not be confirmed? For the lapses on your part, both your part on his part.
She admitted this because she has reposed a false evidence before the court. Though she is working, she is not admitted that in the.
Where are your objections? In your objections, where did you state it? Let us please come to that. Let us see.
Because this is not the first time she is filing the.
Please come to the. We are looking at your statement of objection at 47. Please tell the court.
It is annexure.
Let's see.
Page number.
This is the main petition.
Annexure C. Statement of objections.
This is to your,
It has been adopted with objections also.
no separate.
Yeah, I have filed a memo before the
Order,
court.
the learned judge mentions it. It has been adopted, objection statement is adopted.
How can you adopt your objections to the, in the main petition to the IA? In IA is specific to the income and other things. Please come. Agreed with the order passed in. I number 1, in MC number, in criminal miscellaneous number 335 of 2023, dated 16/8/2016 what is the date?
16/3 order is
16/3/2024. The petitioner, husband is before this court. Parties are referred to as wife and husband. The wife had filed the petition under section 125 CRPC claiming maintenance of an amount of rupees 40,000. Stating that the husband neglected to maintain the wife and the child, though he is having sufficient income. According to her, he is running a coaching tuition classes, English spoken classes, and also counseling center at postpaid and earning rupees 2 lakh per month from his all ventures. He has let out his six houses on rental and earning more than 70,000 per month. And she has no income of herself, for herself. And she is also taking treatment. And sought for the maintenance. The husband has not filed separate objections to the IA filed by the wife. They have adopted they filed a memo adopting the objections that are filed to the main memo, main petition. It is stated that due to COVID-19, the spoken English classes were closed down. Hence, he faced several financial issues. He is not employed anywhere and is getting only 17,000 from house rent, wherein his sister is also having share. And out of his meager earning, he is paying hard loans and it is difficult for him to maintain himself. And due to harassment, torture, mental agony, and filing of cases by the petitioner, he could not able to find any job. And according to him, he never failed to discharge his duties as husband or as father. And he has showed all his love and care and affection towards wife and daughter. The court had considered the evidence, the case of both the parties, and observed that the wife had filed her disclosure of assets and liabilities, stating that her qualification is BA. She's residing in a rented house along with the child. She has no job, she has no income. But the qualification of the husband is BA, MA, LLB, BAd. The court what is the age of the child?
He is now studying in the seventh standard,
Sixth standard,
age of
12. Years.
The court has also observed about the qualification of the wife. And the respondent husband has produced a salary certificate in the name of the wife. The same is for the month of November 2016. He has not produced a salary slip of the petitioner, number one, for the wife for the relevant period. So at this stage, it cannot be considered that the wife is having the earning capacity. But though the wife has earning capacity, but she has no job and no income. The section 125 of CRPC is conceived to ameliorate the agony and anguish financially suffering of a woman who had left her matrimonial home. And the suitable arrangements could be made to enable her to sustain herself and the children. And it is the sacrosanct duty of the husband to provide financial support to the wife. So unless wife gets a job, it's a duty of the husband to provide maintenance. And also court has observed that the husband has not stated anything about his employment, monthly income. But in part G of the affidavit, he said that he has purchased share of elder brother in the ancestral property. He is not having any joint property. He is presently residing in the ancestral property. He has given 3 houses on rent for rupees 17,000, 2 houses on lease for rupees 8,25,000. And he has availed loan of rupees 20 lakhs from his sister, brother and friends, but he has not produced any fees or document in support of his contention. Even he has not produced the copies of the bank statement for the last 3 years to know his financial status. And the wife has also not stated about her bank statement and also not produced a bank statement for 3 years. The material so far placed before the court shows that husband is having income and capable of maintaining the wife. But the wife failed to make out prima facie case that the respondent is having capacity to pay 50,000 per month. But considering the qualification and he is getting rent from the rented house and where the wife and the child have no independent income to maintain themselves. And considering the cost of living, the court had granted a monthly maintenance of rupees 12,000 from the date of application till disposal of the petition. Next, land counsel appearing for the petitioner submits that the wife is employed and in fact, he has placed before the court to show that the wife is earning the wife is earning in the year 2016. Land counsel submits that the wife had not produced a bank statement and all the details to show what is the income of the husband. And just because he is qualified, that itself cannot be a ground for the court to grant maintenance. Land counsel submits that the court has failed to consider the facts, all the the contention of the husband and the relevant factors for granting maintenance. The wife who is a BA graduate and who is capable of earning cannot seek maintenance from the husband. Next, and accordingly, the order is liable to be set aside. Then counsel for the respondent five also do not dispute the fact that they have not do not dispute the fact that the wife had also not filed her statement of has not filed her bank statements. It is submitted that she is living in a rented house and she's not having any other income, court had rightly granted the maintenance. Next, coming to the, and having heard the learned counsels on either side, peruse the material on record. The undisputed facts of the case are that both the wife and the husband are qualified. And also, the salary slip of 2016 shows that the wife was employed and was earning. The child is studying 6th standard, and for a child of 6th standard, there cannot be any compelling reasons for the wife not to work. And why, when she was working in 2016, why was she not working in 2023? Nothing has been placed on record. Had the bank statements of both the parties are filed before the court would have got a better picture to understand what is the income of the wife and what is the income of the husband. Now, in all these cases, when they have an opportunity to file all the documents and the Honorable Supreme Court judgment, as per the Honorable Apex Court judgment in Rajneesh versus Neha, mandates that they have to file their, what are the documents to be filed along with along with their petition. Conveniently, the parties are not filing those documents before the court. And after spending a long time on hearing the case, on the evidence and passing an order, whenever the matters are coming up before the court, now at that point of time, like in the present case, the wife would say that the husband had not filed his bank statements, and the husband would say the bank have the wife has the other spouse has not filed the bank statement or the other documents which are as per the judgment of the apex court. Again, the matter pending for several years before this court. Again, that order has to be set aside and the matter has to be remanded to the court below. This has become a very routine exercise. In all the matters, this court is of the view that when a sufficient opportunity is given to both the parties, this court, this court again, when consciously, when they have not filed the documents, question of granting another opportunity to the parties would not arise. Hence, in this case, this court is not inclined to remand the matter as rightly pointed out with the learned counsel. The both parties have not filed their bank statement for the last 3 years, for the best reasons known to them. Then coming to the wife, when she is educated, when she is already working, why she is not working, why she has not got the job, and what is her the difficulties? Nothing has been placed before the court, before the family court. Family court has not discussed the same. Then coming to the child, it is a responsibility of the husband to maintain the child. Considering that he is studying in 6th standard and he requires maintenance, it's a duty of the father to maintain the child. Accordingly, the petition is partly allowed by reducing the amount and by partly allowed, holding that the wife is not entitled for maintenance, and for the child, it is reduced from 12,000 to 10,000. Accordingly, it's supposed to.
Maybe only interim state, binding regarded Parties may be kept open.
No,
Visitation.
with regard to these
Disposal
are
of this.
any of the observations that are made by this court or for the purpose of deciding this interlocutory application. And both the parties are at liberty to advance their arguments on the merits of the matter, and the court shall decide the same, uninfluenced by any of the observations made by this court. Yes.
Number 7. M.
Yes.
Krishnappa for petitioner, G.M. Srinivas Reddy.
I am appearing for the petitioner, my lord. My lord, I have filed.
This non-pay filing of receipt
Yes,
for having made payment by advocate for respondent.
your lordship may kindly peruse the order sheet, my lord. On the last
Today we-
occasion,
Today we are paying the 50,000 rupees, my lord, by cross check.
Nothing lists this matter on 29/5.
yes, my lord.
What is earlier order? Then counsel the respondent, submit today the respondent going to pay an amount of rupees 80,000 by way of demand draft and an amount of rupees 20,000 by way of cash to the petitioner. Will pay the remaining amount. What has happened? You're not paid.
Today. paying
Today he is
50.
paying only 50,000, my lord.
Mr.
The
Case,
balance is
kindly-
4,65,000
kindly
rupees is the.
No, what we will
Maintenance.
do is we will decide the writ petition itself.
My
We are not-
my lord,
whatever
my-
is
my-
available.
my-
So,
my lord.
kindly say, I have filed the objections, my lord, 10 days time, my lord. In the meanwhile, my lord, they have not filed the liabilities before the trial court, my lord, regarding
I
that.
think you've seen the other order now.
Ah.
If you have not filed, anybody has not filed, not filed at
My-
their risk. No, the
that-
matter will not be remanded for that, and in a writ petition, no objections are required to be filed. The court is alone looking at the order of the court, trial court, and nothing else.
Kindly 10 days, my lord,
Why
today
should
we
it?
filed the, regarding the remaining amount, my lord. and
That both of you take care. Now the court is
Yes,
not
yes,
concerned
my
about
lord,
how
my-
you pay and how
also-
you
Kindly
receive.
say the, now
My-
we have filed the petition before the family court regarding the dissolution of marriage, my lord. Now they are came before this court and got the stay pertaining
Hey,
to
we'll
further
hear it
proceedings,
at
my lord.
We'll hear it.
We
and
are ready
dispose
to
of,
pay the entire amount within 1 month, my lord, before the trial court, we deposit it. Let us consider by the trial court itself, my lord, entire matter, my lord, regarding the maintenance as well as the main petition, my lord,
But which year is the main petition?
regarding MC petition.
Which year is that?
2020. my lord.
23,
2020.
There is no urgency for it to consider now.
because my
So
lord,
it will take its own course.
we sought for, we got the application before the trial court, my lord, regarding calling up some documents from the hospitals. After filing up that application, my lord, they came before this court for filing this petition for
But
enhancement
in
of.
MC state,
Hey, you what?
Yes, my
MC
lord.
state, my lord, that is not proper.
Further proceedings.
That's why, my lord,
Because
we sought for the
without
permission.
considering my case for,
let us see the order. Where is the order? Who passed? This court has passed.
yes, my lord. Further proceedings are stayed.
Therefore, my lord, from kindly 10 days accommodation, my lord, today we have paid the cross check for some of rupees 50.
No, why do you want accommodation? You want the matter to be proceeded before the court below.
How
Now, if
goes-
the stay is
What-
vacated, it will be done.
Much obliged.
Argue.
My
Much
lord,
obliged.
my
And
lord,
also they are not
I-
filed the
Yes.
assets and liabilities.
yes.
my lord, the wife, this is the wife's petition. Wife is not working. She is only a housewife. She is staying with her father's house, my lord. His father is a retired stenographer in State Bank of India. He is maintaining him. In fact, the husband has neglected her and deserted her, and therefore she had to forcibly leave the
How much
matrimonial.
is the maintenance granted to her?
Only 20,000 rupees maintenance is
Roma,
granted,
great.
my lord.
1 minute, 20,000 is the
Yeah.
maintenance. Who filed the MC?
Husband filed the MC
Mm.
under 13(1)(a) on the ground that the wife has deserted.
Please
Is
listen
it-
to the court. Now we will decide this petition. We'll decide this petition and till he pays the maintenance, whatever is the arrears, the court will not go ahead with the MC. That I will pass a order.
Yes.
I am seeking also enhancement in this petition
That's
before
why you
this.
argue, we will
before,
decide it.
before this honorable court, my lord. My lord, my lord, the respondent,
You kindly say this, she was employed.
Minute, you will get your turn, let the petitioner argue.
my lord.
Yes, please come
The-
to the order.
Yes, my lord. Annexure A is the order, my lord. It is at page number 12. It is dated 5th December 2022, page number 12, my lord.
Yes.
My lord, the petitioner was the respondent number 3, and she has filed an IA number 3
for maintenance under section 24 of the Hindu Marriages Act, my lord. In fact, she has claimed maintenance of rupees 50,000 per month, that is 35,000 for wife and 15,000 for the child, my lord, and litigation expenses of rupees 1 lakh, my lord. The trial court has granted only 20,000 to both wife and child, my lord. The wife is not working. She is a housewife. She had the minor child of about 3 years when she was driven out of her matrimonial home, my lord. She had to look after the child. In fact, the child is a very bright child, my lord. Just 1 minute, my lord. I am producing here with the certificate. She has earned in her age of 7 in music gold medals, my lord, just for a while, my lord. She is not in a position to go for any employment, though she is depending upon her father, my lord. In fact, the child is also suffering from lung infection and chest congestion, my lord. I have produced the certificates. About 3,000 rupees is required every month for consultation and lab charges, my lord. In fact, she is taking her every day to music classes and to the school, my lord. She has spent entire time for the education and for the well-being and to look after the health of the child, my lord. 20,000 rupees is very meager. My lord, the husband is getting about 1,62,500 rupees per month, my lord. His net income, as observed by the trial court in page number 19, is about 9 lakh.
95,000
already.
95,000.
Yes. That is net income. Net income. Gross income is 1,62,000 and odd, my lord. The trial court considering, in fact, he has left the job in Bangalore, my lord, and now he is working at Chennai in a multinational company, Vestas, my lord. In fact, she is ready and willing to go and join him in Chennai, my lord. He is not permitting. He is compelling her to be with his father and mother. My lord.
No, what are the expenses of the child?
Child, about 3,000 I have produced along with the IA, my lord. Page number 9, my lord. In High Cloud Hospital, every month she is taking the child. Your lordship may
Where do you get?
Certificate produce school certificates, my lord, participation in the
No,
some
in the
programs.
IA, my lord, along
That
with
is
the
the document they
IA,
have produced.
along with the IA, as per annexure G, my lord,
Yes.
page number 5. This is the receipt or appointment bill issued by the Cloud Hospital, my lord. For each time for consultation 1,150, my lord. Next, your lordship may kindly peruse page number 9, my lord. About 2,360 this medicine and laboratory expenses. Laboratory, this one, everything I have given, my lord. Though child is having such a problem, she is very bright student and she needs constant attention of her mother, and therefore she is giving her entire time to the child.
What are the educational expenses of the child?
Educational expenses about.
They are not produced any iota of material before the trial court regarding these aspects, my lord, and other things. Now they have come up before this court by way of producing the
every year about 60,000
And
rupees
also-
is the school,
Yes,
school fees,
60,000 school fee.
fees every year.
What are the actual expenses for her extracurricular activities?
Extracurricular activities, yeah, approximately 10,000 rupees.
Where from
because-
she is paying all now?
Yes,
Who is supporting her for all this?
our father only.
Yes, what do you say?
Your Honor, kindly see the page number order, the trial court order, my lord, para 8. She was working, we are stated that, my lord, she is working as a trainer at Vishweshwara Industrial and Technology Museum, drawing sum of rupees 14,000 per month. And also they are having the
Now,
properties.
if at all she is doing it, you can file the relevant material and for suppressing the facts before the court.
They are not,
Please listen, for suppressing all the facts before the court and filing an affidavit before the court, let the court take appropriate steps. That I'll record.
they are not filed the liabilities before the assets and liabilities before the
only
trial court,
housewife.
before filing a passing of the order, my lord, that they are admitted. They are not produced any item of material. Your Honor, kindly see, she is studying in
Study standard.
Acharya Pathshalas. Your Honor, that amount was,
You can straight away pay to the court. No amount is required to be. Whatever the educational expenses of the child are concerned, straight away you pay to the school.
yes, my lord.
Actual.
Yes,
you don't have
yes,
to give to her.
yes, my lord. To the effect, my lord, regarding the some disease and other things, they are not produced any material before the court.
As far as educational expenses are concerned,
Yes, my
straight
lord.
away pay to the school.
Yes.
Regarding her ailments, my lord, every month, she has to be taken, that she has to be.
There is no any material
My
before
lord,
this
By
court.
the amount granted is
Yes,
very
yes,
meager, my lord.
Will be.
It is for enhancement, your lordship, may kindly
File the
enhance.
orders. Please listen to the order.
In the
The-
meanwhile, my lord, vacate the interim order passed.
Now, what the order would be is, whatever is the amount now that is going to be decided by this court, you will be paying it within 1 month from the date of,
1.5 months, my lord.
then only the MC will start.
1 month.
Once you pay, then the MC will go, then the court will go ahead with the MC. No, otherwise, no. The agreed with the orders passed in I number 3 in MC number 4204 of 2020 dated 5th December 2022. The wife is before this court. The husband had filed MC seeking divorce. In that she has filed I number 1 seeking maintenance of an amount of rupees.
IA number 3, my lord.
I number 3 seeking maintenance. She sought maintenance of an amount of rupees
50,000.
35,000 to her.
Yes, 15,000 to the child. my lord.
35,000 to her and 15,000 to the child. It is a case of the wife that that the husband who is financially sound, who is drawing a salary of 1,15,000 per month, is not maintaining her and the child, and she has to depend upon her parents to take care of the child's day-to-day necessities and also for herself. In fact, the wife is ready to join, not, here it is not, submitted that, it is stated that in spite of being qualified and earning sufficiently, he is not taking care of the child. It is a case of the husband that the wife is highly qualified and she can learn, she can earn, she can get a good job and earn, and she can support herself. The wife is adamant and refused to join the husband to lead the marital life. In fact, she is demanding the husband to leave and abandon his ill health and old aged parents. It is a case that the wife is gainfully employed before marriage and also continued after marriage. And she has concealed the said fact. She is also harassing the husband and not showing the only daughter from the past 3.5 years. Accordingly, sought to dismiss the said petition. The court, considering the statement of assets and liabilities filed, wherein he stated that he is M.Tech graduate and resident of Tikvalapur, and he had ₹50,000 expenses towards household, medical expenses, food, transportation, etc. Working as a lead engineer in Vestas, Chennai, and his net salary is 1,19,915.
1,95,000 net salary, not 1,50,000 rupees. That is not correct.
No, I'm from the order, I'm dictating it.
Kindly see the,
Para number 8,
other kindly see the.
1,19,915.
Net salary income is 1,90,000. To obtain 5,000 personal, you regarding our, we are also look after the parents as well as the, but regarding the salary.
That's what I'll
His
dictate.
parents is a retired tahsildar and
19,000.
Our
He is a
father is
retired
also
teacher.
a retired bank manager.
Stenographer.
No, don't
That's
prejudice
it.
the court.
No, I am not prejudicing. I am telling the facts before the honorable court.
They had obtained 5 lakh personal loan and paying EMI of ₹23,766. The court has observed that the income tax returns for the year 2018-19 shows that the total income is 9,23,827. And the 2021 discloses more than 9 lakh per annum. And accordingly, court granted an amount of ₹25,000 to the wife and the child, and ₹25,000 towards the litigation expenses in lump sum, and allowed the petition. Next paragraph, when counsel appearing for the petitioner submits that the petitioner's father is a retired employee and she is completely depending upon them. Both the wife and the child are depending upon them for their day-to-day necessities. It is submitted with the learned counsel of the petitioner that the daughter is a very bright child and she is getting in the school and the extracurricular activities. Is faring well. And she also has some ailment with regard to she's also recurrently, she has to be taken to the doctor as she is having some issue with her lungs. And for that, for the extracurricular activities, for the treatment and for the school, she alone, with the support of the parents, has to maintain the child. Husband is not taking care of the child and the wife, which she is obligated to do. It is submitted that earlier when the matter came up before this court, it is submitted that you would deposit an amount of rupees
1 lakh earlier paid, and before this
1 lakh.
honorable court, 1 lakh has been paid.
said that he would pay an amount of rupees
4 lakhs.
18/4/2024, when the matter came up before this court, it is stated that he'll pay an amount of rupees 80,000 by way of DD and an amount of rupees 20,000 by way of cash to the wife. And counsel submits that today he has given a check for 80,000.
50,000.
Has given a check for only 50,000.
50,000, yes. ma'am.
And before that, how much you received?
Before 2 lakhs,
Before this, he has received an amount of rupees
2
2
lakh,
lakh. from
and
the-
now 50,000,
2 lakh from the husband total. As of now, they have received an amount of rupees
2
2
lakhs
lakh
50.
50,000.
Out of 6 lakhs 60.
But we are not concerned.
Out of
2
6
lakh
lakhs
50,000.
65.
He submitted that the husband has to take care of both the wife and the child. And in spite of being educated and getting a handsome salary, and also saying that his monthly expenses itself for 50,000, he has failed to pay. He has failed to take care of the wife and the child. It's parallel and counsel appearing for the respondent, husband submits that.
We announce, yeah, we will pay before the court itself, my lord, all the amount
Before the,
for trial court.
it is submitted that by the counsel for the respondent husband,
Enhance amount regarding.
that
enhance.
the counsel for the respondent husband submits that the wife had failed to file her statement of assets and liabilities before the court. She is qualified and she is earlier working, and now though she is working, she has suppressed all the facts. As such, she has not filed the bank statements and other statements of assets which are relevant for the court to consider. It is submitted that the maintenance that is granted by the court is reasonable, and further, whatever are the arrears within a matter of 1 month or 1.5 months.
1.5 months.
1.5 month, he would pay the same before the court. He submits that they have come before the court and obtained stay of the MC proceedings. Now, by virtue of this, the entire proceedings before the trial court or stay.
2020 matter, my lord.
It's a matter of 2020 and the proceedings are stayed before the court. Next part. Having heard the counsels on either side, there is a material non-record. According to the husband, the wife is working, and according to the husband himself, he is getting a salary of 1,15,000 and odd. It is stated that his personal expenses, where he is staying in Chikballapur, would be around 50,000. And it is also a fact that so far he has not taken care of the school expenses of the child, except the 2.5 lakhs he has paid to, as per the orders of the court. He has no other amounts are paid. When the wife is not employed and when the wife is not employed and the
2 lakhs. Total, we have previously 2 lakhs, my lord, now 50,000 rupees.
That has been recorded.
What did you write? While the wife is not employed, it's a duty of the husband to take care of the wife and the child. Unfortunately, in this case, the husband has failed to take care of the child and the wife. The court had granted an amount of rupees 20,000 per month towards the maintenance of wife and the child. The child now is studying 5th standard.
Now it's third
Third
standard.
standard.
Third standard.
The child is studying
Fourth
standard.
Third standard.
Mother is here, she will know better.
Fourth and not yet.
The wife is the daughter is studying 3rd standard. And also it appears from the record that she is having health issues also. In the considered opinion of the court, the amount that is granted by the trial court, considering the financial capacity of the husband is not proportionate and proportionate. Considering the same, the writ petition is disposed of in the following manner. The husband shall take care of the entire expenses of the child. And
Kindly fix the amount, my lord, you will
pay
pay.
to the school.
Whatever
Whatever are the actuals paid to the school, he has to take care of the entire.
It may be
APS
difficult, it
school.
may be difficult, my lord. Since husband is not here, he is in Chennai, my lord. He cannot come and pay
Transfer to
the
the school account, give the details,
Yes,
bank
yes.
details
Correct.
shall be furnished.
If
Yes.
he fails,
Huh?
if he fails,
Not necessary.
it may kindly be included in the maintenance itself, my lord. So
Not
that
necessary.
I need not depend
He
upon
will
him,
do
but
it, he has to do it. If he is not doing it, whenever he is not doing it, the MC will not go further.
if such an observation.
He shall pay the school fees of the daughter. and
School.
directly to the school.
She is
and the
studying
wife
in APS,
The wife shall
APS.
produce the wife shall give the details of the bank account and the relevant particulars of the fees to be transferred to the school. Next. As the educational expenses of the wife are taken care of by the father. The maintenance-
Extracurricular music classes, etc.
Maintenance that is granted, the 20,000 maintenance. This court is of the view that an amount of rupees 20,000, the wife is entitled, and another amount of rupees 10,000 for the child and her extracurricular activities. Next, at this rate, the entire arrears of maintenance, not at this rate, the entire arrears of maintenance from the date of petition till now shall be paid by the husband within 1.5 months from the date of receipt of the order, order. Till
Like
the
interior-
amounts are,
Interim maintenance, my lord, from the date of application,
From the date of petition.
from
it has to be from the date of application.
application,
petition.
not petition. my lord.
Application,
They are,
application, petition, everything is the same. Application is when she has. filed
interim level,
It is from the date of
commencement of the evidence, my lord, that there's a filed this
The-
application and other things.
Unless and until the arrears of the entire maintenance is paid to the wife. The court will, the family court shall not go ahead with the MC.
Till number 8.
And
Regarding.
equally, the wife is at liberty to file the EP also.
Please.
Yes.
Till number 8, Readiness for petitioner, Siji Malay.
For the petitioner in this case, my lordship,
Yes.
we filed this present petition, my lordship, seeking to set aside the impugned order of visitation, my lordship, by the land trial court, my lordship. Our main contention was, my lordship, parties married in 2010, child in question born in 2015, my lordship. To the October 2018, the parties, the petitioner and the respondent have been living separately, my lordship. My lordship, thereafter, the child has been constantly been visited by the respondent father, my lordship. There was no issue. But thereafter, my lordship, may peruse page number 6, my lordship. We have moved certain applications before the DV court as well as the MC court, seeking maintenance because we were unable to maintain the child owing to certain financial exigencies, my lordship. During the pendency of that case, my lordship, the respondent went to the school and misbehaved with the teacher, my lordship, and the headmaster. My lordship may peruse page number 91, my lordship, which is the letter given by the respondent father to the school. It is there in the objections, my lordship. It is not in my pleadings. It is in the respondent's pleadings, my lordship, which goes on to say he has gone to the principal and asked why the report card should be given to the mother and not the father, etc. At that point of time, there's been an altercation between the principal as well as the respondent here in my lordship. After this incident in March 2023, there is some bitterness in the mind of the child, my lordship. My lordship, after filing this present writ petition, the impugned order was stayed for a short period. My lordship called the parents, spoke to the parents, and thereafter the child has been speaking to the father. So my lordship, in view of all this, we have filed for memo of withdrawal, my lordship.
Let us see that. Where did you say all that?
All of it, my lordship, whatever I just told right now. My lordship, peruse page number 6, my lordship, of my petition. Page number 6, para number 8. And even before that, my lordship, before March 2023, there was no issue of visitation, my lordship, from October 2018 to March 2023, my lordship. Para number 8 of page number 6, my lordship, of my petition.
Objections to that withdrawal, but where is that?
Objections to the main petition is also there, my lordship.
No. Where are your that? I'm permitted to produce. Withdrawal petition, where is that? They say that they have filed a memo for withdrawal.
Give my office copy, my lordship.
Hmm.
I have the office copy, my lordship.
Pass.
My lordship, in my petition, as well as in the memo of withdrawal, in both places, I have told my lordship that the petitioner is a firm believer in joint parenting and the principles associated with joint parenting, my lordship. My only issue with the entire order, my lordship may peruse page number 91 of the objections filed by the respondent, my lordship. Page number 91, my lordship. Which is the letter, my lordship, where he creates a certain issue in the child's school, my lordship. That is my only issue, my lordship.
Please come to your petition. I'm looking at your petition. Then you.
My petition, my lordship, page number
Then
6,
you
my
say
lordship.
the petitioner states that after the aforesaid interaction, the minor son of the petitioner and respondent is disturbed and the same is taking toll on the child's education and extracurricular activities. The petitioner is distressed to see her minor son visually disturbed and therefore intends to withdraw the present petition out of concern for her minor son.
That is right, my lordship.
Yes.
That's about it, my lordship.
My Lord, the statement of objection which I filed it for a moment, Lordship may kindly see the para number 9. Oh, sorry, para number 5, my Lord. 6/4/2021. There is order passed by the trial court, family court, giving a visitation with certain terms and conditions, which he doesn't comply. And Lordship may kindly see even court direct by order, not orally, the direct by order, with order on 30th/6/2022, 23/9/2022, and 28/9/2022. All these days, specific direction by the Honorable Court to produce a child before this Honorable Court. They doesn't do that. And there was an opportunity, was 6-time opportunity was them to file an objection statement of objection. That also they don't do it. Thereafter, Lordship may kindly see this present impugned order was passed. That is on 2/6/2023. Now, Lordship may kindly see this here immediately from 3/7/2023 till today. I have been able to meet the child only for 4 times. That too, the intervention by this Honorable Court. And Lordship may kindly see there are two incidents they are talking about. One incident, Lordship may kindly see talking about an incident happened in the school. He went to the school, being a father, he went to the school. He asked about what child's welfare.
No, that when
Yes.
I've interacted with them, I know what has happened.
So,
And even
and
the
given a
boy
letter
said-
also, that's.
No, even the boy said, like, if he comes to the school and says sorry to the.
I have
teacher,
no.
He has no objection. And that day was
Please.
okay.
Please, madam.
Hmm.
Second incident, Lordship may kindly see, there was a specific direction by the Honorable Trial Court in respect to visitation was picking up the child from the residence of the petitioner. He contrary to that, she asked him to come to the hospital where she's a doctor, she's her own clinic where she's a dentist, she is a clinic, where she's purposely created because circumstances wherein which it is as if it is some commotion and child is going to take away by forcefully another thing. Obviously, child will get offended or something. This is only 2 incidents where happened. Lordship may kindly say, otherwise the child was during the COVID, child was with my exclusive custody because during the child period, I was taking care of the child. Thereafter, she took the child, came back to Bangalore, immediately she filed discipline. That is how the thing. Otherwise, there are absolutely, it is also not in dispute. They also admit that we had a good relationship with the child, absolutely. Thereafter, Lordship may kindly say during interaction also would have noticed the child was brainwashed to such an extent, stating that this is as if he is a monster kind of thing. The picture that has been painted and that has been day in and day out tutored to them. She is just using the child as a tool for her matrimonial dispute, nothing more, nothing less. Now, Lordship may all this exercise past 21 onwards, child has been denied the right as a thing. So now they filed a petition, almost more than a year, they kept this matter pending. All of a sudden, drop of a hat, they just file a petition and withdrawing it. This is nothing but a abuse of process, a classic example of abuse of process. A litigant cannot take the scrupulous manner to take the law into their hands. That should be, these are the cases, classic example should be send a message to society. That is my number one, respect of. Lordship may kindly see child at this point of time requires some sort of counseling is required. He cannot just withdraw and go back to the court and make an allegation saying that he went to the court, we all argued the matter. Court did not any pass an order. Now we are coming back. I will do whatever I want to do. This is the attitude. Normally, it has been case in classic examples we have seen in other cases where they take advantage of this situation. Court, we all argued the matter before the court. The court did not make any observation. Court did not do anything. Therefore, I can continue. Like this. They were even trial court also, and the threat. This is a kind of thing litigation. This cannot go on like this, my lord. This is a message somewhere that is to be got. You cannot take it. One person cannot take this kind of litigation for their whims and fancies and make use of. The moment they find that the court is not in certain things are came on record. Now at the convenience, they cannot withdraw the petition, just walk out of the situation. This is my respect. This is a classic example. There should be, if at all this honorable court is allowing in withdrawing the petition with the exemplary cause, there should be message sent to the society. This is not a day in and day out this process is happening. There should be some message to be sent to the society in terms of this is example. So far as my rights is concerned, lordship, some certain direction may be given to the trial court for my visitation to be continued, that whatever the things happen to be restored at this point of time. If it is, this is damage is permanently, there are some damages will happen. Let the child be sent for some counseling, or it has to be examined by the doctors at this point of time, because what is gone inside the.
In these kind of cases, counseling will not work because he'll be with the counselor for half an hour, 1 hour. The remaining time is with the mother. So how does it work?
There should be some solution, my lord. This is not the case which is happening, because there's a series of cases. The intervention of this court should be there in this type of matters. That is my respect to submission. Some guidelines should be laid on this type of matters. They should not be allowed this type, because child should not be taken for a person's personal litigation. This is a classic example. There should be some laws to be laid on this type of situation, my lord. Lordship, the records clearly shows that their own cases that child was in. What is the difficulty? Just because the father goes to the college, means to the school, and make a submission, that too my instruction is that child itself was not there. And they to pick up some isolated situation, if at all for an argument's sake, let me admit that it has happened. That cannot be a reason for denying a child's rights. A father's visitation. These are all constructive. What type of societies we are building up and throwing out? What happened to the child's mind tomorrow? So that is the reason why, even though so many visitation rights were granted to me, I could not exercise, because I just laid back, because I don't want the child to suffer. And that should not be an advantage for them to take it forward further. That is my respectful submission. So rest of the thing, I leave it to your lordship for appropriate order, madam.
What are your submissions?
My lordship, there is no stay on the impugned order from the very beginning, from 2018 till now.
What is the confidence of the mother that even there is no stay, still he can, anyhow, the boy is
They
not
can
going
visit,
to-
can visit, my lordship. They've been in communication by email throughout. From 2018 till now, they're in communication through email. In fact, there are lengthy, voluminous emails by exchanged between the parties, my lordship. There is no stay in proceeding for the last several months itself, my lordship.
No, ultimately, how many times the father could see the child?
My lordship, on every Sunday, my lordship. On every Sunday, the father is permitted to spend time with the child.
Permitted, but what was it happening?
My lordship, he needs to drop in a mail and come and pick up the child. They have been doing it all throughout from 2018 till now. Nothing has stopped him from doing it now. My lordship, also the other submission I need to make, my lordship, is that from the initiation of the proceedings before the DV court till now, my lordship, he has not paid a rupee of the arrears, my lordship. And also at least a child's fee, my lordship. My lordship, whenever he wants to.
So had your client been more fair in the system, in all this process, the court right now will also direct him to pay the school fee. But the fairness of your client, the court is not able to see.
My lordship, after the intervention of this court, I've also advised my client to permit the visitation, because there is no stay by this honorable court.
One thing is, I'll tell you, in one interaction, the boy had specifically stated about this, what has happened in the school. Then I said, can he come to the school and say sorry to the teacher? He said, yes. Then he said, no, the holidays, after holidays you came. Then when I see the boy, again after that day he spoke with him also. Then after that vacation or whatever that, after 1 or 2 months, when he came back, where this court has permitted him to leave to his, is it the case that her grandparents' place?
Please, ma'am. Please, ma'am.
They went to the grandparents' place in Kerala and came back, my lordship.
Then this court has permitted him to go and come back. And after that, when the court meets him again, he was there was difference. Then after that, he is completely, how a boy can be brave. And that is something which this court can't just let it like that. It is it's a case of complete parental alienation. He is all referring to what has happened when he was 2 years old. 2 years old, and he shouts at the father, and he never calls the father by name. He calls the father Sarath. He doesn't take he takes his name. Don't even call him daddy or whatever they call that. And how can she take advantage because the boy is with her? And this is not the way. And you can't make the other party so helpless.
My lordship has made these said observations, my lordship. I have also instructed my client never to do this, my lordship. And
That tell her she will, I'll just pass over this. There are two things. Either it is that she'll come she'll come fairly to the court, or else this is a case where the court has to observe that it's a parental alienation and the custody has to be shifted to the father.
my lordship, from the date of the order, impugned order, my lordship, we have been abiding by the order till the date of that incident, which they call isolated, my lordship.
What is that abiding? The boy doesn't even speak to him. And when the boy is shouting at the father, which is not supposed to be, and if she is really a dutiful mother and who feels that her duty is to the discipline him or whatever to take care of his life, she would not have let him to speak like that to the father. In fact, she was encouraging it and also saying that but the father should be sent out because the boy is not he's shouting at him.
I concede to the submission of my learned friend where he says a counselor may be used to intervene and set things right between the parents, my
Your
lordship.
client is a big counselor. No counselor can do anything to the client. Tell her, definitely in this case, though it is not, this court has never done, but it's a case where the custody has to be shifted. If she feels that she can just happily come to the court, seek a matter to be pending before the court for a year, and when the court feels that what she is not doing right, now she wants to withdraw the petition, no. But it could be like in any other property matter, in any other thing. Not in the case of this children, where this court exercises a parent patriarch jurisdiction, court will pass appropriate orders. Tell her that. I'll pass over this. Only after the matter comes at 2:15, only two things. Whether she wants to be fair to the court and even about the maintenance and all other things also, court will pass an order. Or if the manner in which she wants to go ahead, then we'll pass an order.
My lordship may give a date where I'll have the party present before this court, my lordship, because it's an extensive instruction to avail as well, my lordship.
Don't have to interact.
After the
She's an educated woman.
That
She
is right,
knows
my lordship.
everything.
That is right, my
And she
lordship.
thinks that she can, just like that, she just go away with everything like this.
I have instructed my client on the last occasion very clearly, my lordship. For all custodial matters, I tell both the parents that there shall be no parental alienation before me, my lordship. That is what I have told.
It's a clear case of parental alienation.
I very clearly
And
told my client as well, my
but
lordship.
because there are proceedings on every date of interaction, this court has recorded. In all the interactions, how it has transferred, I have recorded it. So there is nothing that she can't even deny that. And now if she by this order, I'm telling you that I will pass an order, the changing the custody to the father.
My lordship, my only submission, my lordship, is that the impugned order that is there is now reverted back. There is no stay on it. The father may exercise his.
What I understand.
The father may exercise
Maybe
his
you're trying to
visitation.
tell the court that the scope of the writ petition.
No, I'm not, my lordship. I'm only telling my lordship that for the welfare of the child.
Even if this matter, if this is withdrawn, it goes to the trial court, again, another several years it will take. By the time this boy will turn into something else. He will even say one day that who is this Sarath, I don't know.
The father already has visitation. Let him exercise it is what my submission is, my lordship.
That's the whole thing. It's
No, my
not
lordship, it has been happening from 2018 to 2023, my lordship. It is one incident that has
If
changed it.
that stay incident can't be a reason for the mother because that's how she is treating him. And it requires to be changed. And he needs to know that he has a father and father also loves him.
My lordship make the necessary observations and allow the petition to be withdrawn is my submission, my lordship, in the interest of the child, for the welfare of the child, my lordship.
Instructions from your client and tell her that this is going to be the order. I'm very much like whenever when I last met them in the chamber, I felt very bad. This is the way how a mother leaves a son to behave with the father. And how is she taking care of him? Is she really like going to be a good human being with her, with her, brought up and all? At least she's not even stopped him. On the top of his voice, he shouted. He was saying that when he was 2 years old, or you did this to my mother, you did. How will she remember what has happened at 2 years age? So he's completely tutored by the whole family, not only the mother, along with the others also. So then now she was telling all about the Bhagavad Gita, all about the things like, I am not this child. Let her now understand how Bhagavad Gita works and how the sermons works.
I may seek instructions from my client, my lordship.
Please
A
seek
date
the
may be
client.
given, my lordship, because she'll also be in clinic. A date may be granted. I shall seek instructions from my client, my lordship.
Now we'll do one thing. Now we'll post this matter by this weekend. This is also one more, like the court is giving her a very long rope. Now we'll post this matter on Monday. This weekend, the interaction and the visitation should go on normally, not with all her ifs and buts and all that clauses. If it goes on, then we'll think about it.
Absolutely, my lord. I shall give the necessary instructions.
Post this matter on Monday. That's on 5th of August. And on Saturday, 3rd August and 4th August, the father can exercise his visitation rights between what was the earlier arrangement
The earlier arrangement was 11 to 5 on Sundays, my lordship.
on Saturday and Sunday between 11 and 5.
Saturday school is there. Saturday school is there? Saturday school. Huh? Saturday, the child may have school, my lordship.
Sunday 11
Sunday,
to
my
5.
lordship.
Instead of Saturday, say 11 Sunday, between 11 and 5, the father shall pick up the child from the mother, or no, wherever the father is.
Mutually
let the
agreed by
pro-
email, my lordship.
Huh?
Mutually agreed by email. They've been doing this for 6 years, my lordship.
No, now it's a court order. Now the father, where shall the mother drop the child?
Clinic, my lordship. Clinic, my lordship, because the mother comes to work in the morning, my lordship.
For another,
Nothing at all. Nothing happened last time, my lordship. Nothing.
it is on a Sunday also she has.
Yes, my lordship. She is a single mother. He's not paying any maintenance. She has to work on Sundays, my lordship.
Decide. Tell your client, that also will decide.
My lordship.
That also will decide in the petition. Tell your client.
Oblige, my
Yes.
lordship.
Where?
You can go also pick it from near the house.
Pick up from the school, the father shall pick up the child from the clinic of the mother and drop the.
House only.
Huh?
My lordship, but I will be in clinic, my lordship. From 10 o'clock in the morning, I'm at clinic, my lordship.
I'm seeing from the clinic. From the clinic of the mother, and she'll drop the child back where to the.
At the
house
clinic
or-
only, my lordship. She will continue to be there in the night.
She shall drop the child back at the clinic. This court, on the last occasion, there was an interaction with the court. And this court, by way of an elaborate order dated 27/6/2024, has recorded what has transpired. Thereafter, the petition is filed seeking to withdraw the writ petition. And the counsel for the respondent father has filed his objections. The manner in which the entire things, the things were going on, and the manner in which the boy is reacting to the father. Then several orders passed by this court has recorded. Before passing a final order on the withdrawal and also the objections that are raised by the respective counsels, this court deems it appropriate to give a last opportunity to the mother to see that the father can exercise the visitation rights. This should come below the last arrangement. And the mother shall cooperate with the visitation, and basing on how the visitation went on, this court would pass appropriate orders on Monday.
Oblige, my lordship.
Tell her the court has indicated that if this doesn't go well, then the custody would be shifted.
I shall instruct my client, my lordship. Oblige, my lordship.
Still number 9, Hemalata Mahishi for petitioner, Jagdish Gundappa for respondent.
I beg to appear for the petition.
Petitioner. This
Even
is
in this
also
case,
related to the visitation.
visitation rights notes has not been excised. Not provided an opportunity for the last 4 weeks.
What is the order, let us see?
Order is giving the visitation right from morning 9 o'clock to evening 6.
It's order
6
dated
PM.
2nd May 2024.
Share the custody of his minors and once in a week from 9 AM every Sunday.
And this honorable court modified that just to give him an opportunity again from morning 10 to 2 o'clock. Modified that order.
This order
But
is dated.
still, I will submit what has happened in this case. It is not a normal case.
normal case of just differences between the couple. It is not that. There is lot of violence in the house. And this respondent is a violent person. Every day on the basis, everyday basis, there used to be physical violence, abuses, and all those things in the house. And petitioner is also working. She is a government employee. She is an engineer in the PW department. It is every day's affair. Child has seen it, this violence every day. And he also used to get beatings and everything. And even abuse, verbal abuses. And he was not calling his son by his name. He was calling him Koja, like that. Every day it was that affair. And child
What
was...
does it mean?
Koja means not a male, like that. So not a man. He was, that means he was abusing the child in that manner. And as long as both the petitioner and the child lived there, he used to be disturbed in the house, depressed.
What is the age of the child?
14 years.
He's in 8th standard.
No, he is with the mother.
He's with the mother.
With the mother. And now what happened was when they were living together, mother somehow she was managing, living, suffering, all those things, because she did not want to go out of the house and all those things. But son did not, he did not want to suffer. In September 2022, he came out of the house, went directly to the police station, and he himself gave complaint. He wrote a letter, kept it in the house, left the house itself, went to the police station. He called his mother also there, and to the police, he gave the entire details of what is happening in the house, and he refused to go back to the house. She also tried to persuade him and all that, pacify him and all that, but he completely refused to go back to the house. And police also advised her to set up a house for some time, a separate house for some time, because the child was scared of his father and he was disturbed a lot. And therefore she set up a house, a separate house near to his house, just 100 yards from his house.
So the visitation couldn't happen. He didn't come.
Pardon?
Lords, it was excised for some occasions, but then for the last 4 occasions, Lords, they are not allowing the child to.
Yeah, for the first 6 weeks,
This interim
this
arrangement.
honorable court modified it with the persuasion of the mother. He went there. But even during that time, that was an opportunity for him to get the affection of the child. But instead of that, more and more, he estranged the son by his behavior. Once he spat on him, and normally his behavior was to force the child to get the consent of the mother for divorce. He will bring a new mother to him. He was showing him the pictures of girls to show, you select one of them. I will bring a new mother to you. This was the behavior. Even during this 6 weeks, he went there.
Yes, this court has on 2/5/2024 had passed an order. Whereby
Lords, the application is filed by me now, which is posted. The application.
what is
which
that you have filed?
Lords, I have filed an application to modify this order, what is granted from 10 to
This is
2.
before that, we'll see that the court had modified the order on 2/5/2024, whereby on every Sunday from 10 AM to 2 PM, the father was permitted the father to exercise the visitation in a park near Pairati. Today, when the matter came up, land counsel for the father submits that the visitation could not take place. And from the last 4 occasions, the father could
4
not,
Sundays.
on 4 Sundays, the father could not meet the boy. The land counsel appearing the mother has stated several things about how the father's behavior is towards the boy, who is aged 14 years, and how reluctant he is to meet the father. And in fact, he has gone to the police station and given a complaint against the father. Considering all this, this court deems it appropriate to interact with the boy. What's this matter? When?
Lords, tomorrow itself, because for the
No.
last 4 weeks.
No, no.
It happened.
Lords,
How
It did come after.
all that is said is not gospel truth, my lords. I
I
need,
wanted to talk to the boy.
lords, let it be, happen, my lords. But then last 4 weeks, my lords, they are not allowed.
He is refusing to go and he says.
If it can be posted tomorrow.
If she forces him, to
When
go.
can he come? Please tell the court.
It is
Please
all
have
that,
an
all that they are saying is, all that they are saying, they have taught the child in such a way that hatredness develops against the father. But at the same time, in the interest of the child, let there be opportunity to develop that relationship. They are not allowing the relationship to be developed at all. And all the allegations are made against the father, and they are not, let there be an opportunity to develop that relationship. Let them spend some time together. In fact, the father is not residing alone. He is residing with his aged father. Let the custody be given to the aged father, at least visitation rights. Father and his son, the grandfather and the father, let them take the child for at least 3 hours, 4 hours every Sunday. And they say that it should be given in the park. Park is closed at 10 o'clock. They say park is closed, will not allow.
That's why. Now, if the court interacts, it's good for your client.
Let
But
it
an
be.
order would be passed because the 14 years boy need not be at the park. It can be at home.
It can be definitely at home. That's the reason I have
Interacts,
my
that's-
modification application is
It
also
is
for.
just one day. You're saying that from 4 Sundays you have not exercised it. How does it matter on one day? On one Sunday?
It doesn't matter,
Yes,
All that I'm saying
Let-
is,
let the-
the matter has been
These
going
kind of
on.
Cases, in these kind of cases, it is not some issue that just like that the order would be passed.
It is
When
not, I am not
something is
saying
placed
so.
Before the court has to satisfy itself before.
Definitely, my lords,
That's why
definitely.
when can he come?
But now
To
he
the
is
court.
having exams.
Until what?
For
till
one
when?
more
And
week he is
for the
having
last
he
week
is
also,
having
they said he has
One
exams.
minute, 1 minute.
He is having exams.
Till
For-
when?
Till,
Next 2 days.
and only after Monday he will be free.
Get him on Monday.
Very good.
My lords may have it on Friday at least, because
No, no,
my lords, the father is made to suffer.
Please
Because my lords,
understand.
if they are obliging with the court orders, my lords, let them first comply with the court order. Then, my lords, they could have moved an application. My lords, it's upon my application, moving my application. My lords, they come out with all these
Mr.
allegations.
Counsel, all
Kindly
this-
see this conduct, my lords. If the child was not willing,
See,
they
all
could
the
have filed an
conduct-
application for modification of the order.
We'll see all the conduct
That
of the
is true, my
parties.
lords, but then they
on
have been
Monday.
successfully defeating the interim arrangement at least for the
Monday
last
can
4
come.
occasions.
Pose
For
this matter on Monday.
For 6 weeks, my lords, they have been avoiding this.
Yes.
They don't move an application for modification, saying that
5 o'clock in the chambers.
But
5 o'clock in the chambers.
5 o'clock.
Yes.
Friday, my lords, can have it at least this Sunday I can have.
Having a school, how can you expect? him to
They
come
say
to the
only
court?
2 more days, 2 more days.
School day, why should a boy in 14 years old studying in a higher class should come to the court? Let the father.
My
be
lords,
more
again next
reasonable.
Monday they will come. Then again they will postpone it for, we have been suffering for last 4 weeks, my lords.
In
Yes.
chamber.
In chambers.
Lords, they are making all these allegations, but then they didn't move an application to cancel these visitation rights.
Yes,
It is my application when I seek for extension, lords, they make all these allegations against the father.
yes.
And they don't make a single effort to see that a good relationship, healthy relationships is developed with the father. And all through, lords, morning till evening, the child is with the mother. Everything is tutored. Everything is tutored. Lords, how can a 14-year boy, lords, go to a police complaint, and it is only at their instigation all this is happening.
We'll see.
They want to create all these records.
On
And then, lords, 4 weeks they don't send, because the reason is park is closed. We will not allow you. And this approach, lords, with this approach, can there be any chance for the father and the son to establish a healthy relationship?
If you give a chance to the court at least for a week, then the court will tell you.
No, that's true, my lords. But then kindly see
Wait till Monday. It can't
for the
happen.
last 4 weeks, what the father has suffered.
All this anxiety, wait till Monday. The court is telling that it is not possible now. Please understand. Monday, once the court interacts, then an order will be passed. Yes, next
Serial number
matter.
10, MB Inamdar for petitioner Kumar MN.
Yes.
Your Honor, I have filed an application for recalling the order. dismissed
Where
for
is
default.
application?
Application.
When is the order? When was the dismissal order?
My lord, it was.
I have furnished it.
10/1/2024, my lord.
No, this is a MFA of which year?
Your Honor,
MFA of which year? 2013.
2013.
When was it dismissed?
so dismissed on
10 January of 2024.
Huh?
10/1/2024.
10/1/24.
2024.
When this application came to be filed?
This was filed on 27/2/24.
27/2/24.
24.
Now, what is the stage of this MFA?
Final hearing.
Final hearing.
Huh?
Final hearing.
Now, what we'll do is, we'll hear this matter, then we'll set aside, then we'll see about that IA. When are you ready?
Final hearing.
When are you, when will you argue?
Any date can.
Pose this matter on 13th of August at 2:30.
Please.
Cell number 11. Siddharth Muchendi, petition appellant.
I appear for the appellants in this matter, Your Lordship.
For respondent number 8.
Yes.
Matter is listed today for the hearing on those IAs, Your Lordship. The first IA being the IA for condonation of delay of 8 days.
When was this earlier listed?
On 23/7/2024.
Oh, a needful, yeah, has been done in 2023, 24/11/2020.
24/11/20.
MFA of 2014.
It's OS of 2011.
Huh?
OS, original suit of 2011, suit for.
Early, MFA is very early coming up for hearing.
That's substantially the trial court have, that's recorded the evidence. Maybe disposed of directing the trial court to expeditiously.
What is the order?
39 rule 1 and 2.
There are two.
That application is pending here. 39 rule 1 and 2.
That application was pending before the trial court. Trial court passed an ex parte injunction order. We came on record. We filed an application for vacated the interim order. Thereafter, they have filed.
Now the proceedings before the court are
Yes,
stayed.
going on.
Now
Going
it's-
on. Evidence has been.
It is listed today for the service of summons on the LRs of the defendant number 2. That is what is the instructions that I received today morning.
Lots evidence has been led.
Oh, 2014 interim injunction petition. Now we are in 2024. What is the significance of this?
That is.
No, you want, now that is something, that application is something to immediately take care of the, whatever is going to be the
Certainly.
eventuality or your injustice, prejudice, whatever. Now, why should we pass any order in 2014? Let the court go on, let the trial go on.
Yes.
Please come. The present appeal is filed. Read whether orders passed in IA number,
IA number 1 and IA number 13. It's a common order, Your Lordship.
in orders passed in IA number 1 and 13.
IA 1 is for 39 rule 1 and 2. IA number 13 is for vacating of the interim order.
By order dated the order dated 2nd January 2014 by so and so. The present petition is filed. The petition, the present appeal is filed. The appellant before this court is the plaintiff in the suit. The suit is filed for
A partition.
Partition and separate position.
partition and separate position. In that, he has filed an IA under order 39 rule 1 and 2 CPC. And initially, IA number 1, the stay was
allowed.
granted.
Ex parte ad interim.
An ex parte injunction was granted. Thereafter, the respondent herein was a defendant in the
number
suit,
8.
defendant number 8 in the suit, had filed IA number 13 to vacate the said order. And the court had dismissed IA number 1 with cause and allowed IA number 13, agreed thereby the plaintiff is before this court. This, the suit is filed in the year 2011. Now, after more than 10 years, now the matter is coming up before the court, and the plaintiff never had any injunction in his favor. Considering these facts, without going into the merits of the matter, this court deems it appropriate to direct the court below to dispose of the pending suit as expeditiously as possible, but not later than 6 months.
Grateful.
Accordingly disposed of. Yes, next. Both the appeals are disposed of. How much delay?
Two appeals. One is with respect to IA number
The
one, other
delay, how much is it?
8 days.
Huh?
Delay of 8 days.
IA number so-and-so is filed to condone the delay of so-and-so for the reason stated in the accompanying
Yes, correct.
affidavit, the delay is condoned.
One is
Yes,
with
next.
IA one,
Cell number
8,
12,
Correct.
12,
Happened in this case. Victim began to take steps to LR. File application to necessary application to an LR application. Victim may be granted.
When they have died,
24/6 intimation to collect.
24/6?
24/6, 24.
A week's time is granted
Yes,
for
ma'am.
filing the LR petition. By the time the petition is not filed, the appeal shall stand dismissed without further reference to the court.
Interim order may be extended. Interim order may be extended.
Look at it, if the interim order is there, extended till the next date of.
What's up, please?
Yes, next.
cell number 13, Ravi B, party in person. Ravi B, Sadashiva, respondent.
What is that, for this party in person? I think there is some procedure. What are they doing? Find out from the RG. Post this matter tomorrow, no representation. Yes. 14.
Cell number 14,
My lord, I am appearing for respondent number 2 in this case, my lord.
No representation for the petitioner, for the appellant. Pose this matter for dismissal tomorrow. Yes.
My lord, I have to file my objections to the IA filed by them. That is for condonation of delay.
First of all,
That
they
is-
have to be here when the
Please.
matter is called.
Please.
Yes,
cell number 15,
Petitioner, my lord.
yes.
Marriage in 1996,
Hmm.
as per annexure invitation card at page 9. Then in the year 2008, a joint petition was filed.
When was the marriage?
Marriage on 15/5/1996.
15?
5/1996.
Now, what is this impugned order first? Impugned order is what?
Impugned order regarding maintenance of
How much is granted?
5,000 has been ordered. She has demanded 20,000. 5,000 is ordered from 2018. But that is impugned order is at page 72.
What is the income of the husband?
Petitioner has no income. He is a private tuition teacher getting hardly 3 students. Already whatever she is entitled, it has been paid. Kindly paid page 15 for a moment, kindly be looked into.
Yes.
15 is it is a joint petition filed during 2008 because it is a point of no return. Then there are 3 in that petition at next page 16. It is submitted. Petitioner
Paid
1,
3 lakhs? You have paid 3 lakhs?
I have paid that amount to her.
The judgment and decree basing on this compromise memo?
Allah, she has taken the money by selling the site. She has not come to court. So because she has not come to court, petition was automatically dismissed. Then I filed petition seeking divorce because of the cruelty. That petition was rejected. And in that petition, there was maintenance of 5,000, amount was ordered. In that, this was not brought to the court's notice. And thereafter,
Why it was not brought?
that I can't explain because I was not on the scene.
Because the difficulty is what you have brought to the court is notice. that only
But
court
what I
will
say, my
decide.
lord, fact remains same that she has agreed.
The land council, the petition submits that as per earlier, when an arrangement was entered between the parties, the husband had paid an amount of rupees, 3 lakh rupees. Later, she has not come forward for the settlement. Now, in a petition that is filed by the husband seeking
is she-
divorce, the wife had filed an IA seeking maintenance, and the same is
Well,
allowed. It is submitted that the husband is not is not earning anything, and whatever is the settlement and whatever is the amount that has to be paid, he has already paid. This aspect was not brought to the notice of the court. Considering the submission of the land council to the petitioner, there should be stay of all further proceeding.
But-
Pursuant to the order dated. It's only not the MC, it's only pursuant to the order dated so and so.
But till such time,
Petitioner.
she has filed execution petition, kindly.
It shall be stay granted.
I'm grateful.
Petition is permitted to take out notice on the counsel appearing for the respondent before the trial court, or trial court or the executing court, and shall file a memo to that effect by 3rd of August, and rest this matter on 8th of August. If the memo is not filed, the stay granted by this court.
May I
stands-
take notice on the advocate appearing in the court bill?
That's what I'm saying, yes.
Bill number 416. Arun Govindan, 16.
Appearing for the petitioner in this matter, your ladyship. Petitioner wife. Parties have been married for about 16 years.
What is impugned order?
The impugned order is one of maintenance. I had filed an application.
How
for
much is granted?
maintenance. 20,000 is granted while I
He's
had
seeking
sought.
enhancement.
I'm
She's
seeking for
enhancement.
enhancement, your ladyship.
Notice, the petition is permitted to same.
The
No notice on the trial court advocate and shall file a memo to that effect. Memo shall be by same like in the earlier case. Yes, next.
Much obliged.
Bill number 17.
May it please your lordship. Lordship, I have filed this writ petition challenging the order passed on IA number 5. IA number 5 is the application which I have filed seeking custody and visitation rights of my children, minor children. Since 2019, your lordship, I have been.
This order passed by the court.
Your lordship, the order is at Annexure A, your lordship.
Page number.
Page number 33, your lordship. It starts at page number 33.
Your application is rejected.
Yes, your lordship. The application is rejected mainly because the previous to that, the respondent has.
Notice on
filed-
the council will hear.
I have sought interim.
Interim relief in
trial,
this
your lordship.
custody matters. Land counsel for the petition is permitted to take out notice on the council appearing for the respondent before the trial court. Same on 3rd, and you should serve the notice and file a memo by 3rd.
Please.
And it will come up on
18.
8. Yes,
Bill number
next.
18.
18 also same, your lordship. In this, I have challenged the application filed by the.
Notice.
respondent.
Yes, next.
Bill number contract matter, cell number 19. Suresh K. Petitioner.
Respondent,
Again.
lordships had substantially heard this matter.
We'll hear this matter at 2:30, 19 and 20, 19, 20,
Lord,
and 19 and 20. yeah?
Lord, I have got a matter before the division bench. Kindly be have posted on any day.
No,
Not
we'll
today.
hear then. Please, Arun.
Today, not at least tomorrow, my lord,
Why?
because I got a matter.
Today now you are free right now.
I'm.
Yes, we'll hear it. Yes. Yes.
Lordship had heard this matter in the Lord.
The only point for lordship's consideration wherein your lordships had indicated to them was to show any piece of document which shows that they are in possession of the property. That's all the matter wherein your lordships.
Now he is the plaintiff in the suit.
Please, my
Yes,
lords.
my lord.
And the suit for, what is the suit?
Declaration
for?
and
Declaration
injunction,
and
my lord.
injunction.
Yes, my
Mm.
lord, there have been, by the virtue of the revenue entry, they got this property, my lord.
No, let's understand this. Now suit is for declaration and injunction.
Yes, my lord.
Now, according to you, what is the source of your title?
My title is I have purchased a property way back in the year 1965.
1965.
65. And I've just given the brief dates and events to the lordship, my lord. It's there in the
It's
file.
there.
Date and events, continuing.
You have given it.
Yes, my lord. In the year 1965, Bairaya alias Pichaya alienated the social property in favor of the Kadapa, son of Kullappa, and subsequently in 1972, Kadapa and Kullappa alienated the property to Mudegoda. Mudegoda is none other than the petitioner's father.
Yes. What is the extent of land?
Extent of land is
16 guntas.
16 guntas, my lord.
Yes.
In the year my lord, the social property was mutated in the name of Mudegoda, that is the petitioner's father. The revenue records reflected the name in the petitioner's father since 1984.
Yes.
After that, Mudegoda deceased on 1994. That is the petitioner's father deceased on 1994. In 2005, this property was the R3 and R4, the respond number 3 and 4, mutate the property by the virtue of a false partition sheet. They have some properties in their name. In that partition,
This is included.
this is included.
Mm.
And they mutated this property in their name.
Mm.
In 2005, my lord, the same property, R and R4, other than the included partition deed, and in 33, 2005, there is a
R and R4 are purchased to an extent of 8 guntas each. By the virtue of the mutation entry before the Tahsildar, what they do is they alienate to extent of 8 guntas each to respond number 3 and respond number 4.
No,
Yes, my lord.
right from 2005, when the property is standing in somebody's name and the revenue record.
My lord, revenue, the Honorable Supreme Court has said that revenue.
It is not about that. I'm just asking you, what did you do? It will not confer any title.
No, they did not disturb my position at all. They did not disturb me. Even now I'm in position. They were there.
Nobody knows about
No,
the revenue.
my lord, what has happened here
What
is,
did you show that you are in possession of the property?
my lord, to show that I'm still practicing agriculture, I'm just growing ragi there. And they have not disturbed my position, and they have not filed any suit for possession. Even before the trial court, the first and the second
Is
defense.
the case that they are in possession of the property?
But not,
We are in the possession of the
no,
property.
if
We
they-
are.
my lord,
Let us see the written statement. What did they say? Page number.
Annexure C, page number 58.
Lord, the respondents 1 and 2 are the subsequent purchases.
Let's see.
Lord's para number 4.
Lord, subsequent.
At the
respond
end, my
number
lords,
one-
actually after the.
Respond number 1 and 2 are the subsequent purchases of the, based on the revenue entry, they have purchased this property. And I did not execute a sale deed in their favor.
No, the fact is, you are relying on some sale deed. He is relying.
No, I'm not relying on something. I'm relying on the sale deed where my father has purchased it.
You're, according to you, your father is the owner of the property, you have inherited it.
Yes, my lord.
You're relying on that.
Yes.
No, according to, they are also relying on. a
No,
sale deed.
they are.
We are relying on a part.
They are relying on the, first of all, what they do is they mutate the property in their name by the virtue of the revenue records. Revenue records cannot be considered as a title at all. After entering their names in the revenue
Any
records.
document.
No, nothing, my lord. I did not execute a sale deed in favor of the anyone, A, B, C, none, or my father has not executed a sale deed. What, by virtue of their revenue records, what they do is, they have some properties. In that property, they include my property also, go to the Tahsildar, mutate their names, stating that they are the absolute owner of this property. By the virtue of that revenue entries, what they do is, they execute a sale deed in favor of R1 and R2. They did not have a title at all. Virtue of the revenue entries only, they have executed a sale deed.
To say that it's a joint family property, what is their, what do?
No,
they say?
if it was joint family property, I have the absolute owner. My father, Mudegoda, has purchased this property. And if it was joint family property, my Mudegoda's legal heirs should have purchased, filed a partition suit, or there should be a mutation entry in name of.
Between whom this partition had taken place?
Partition has taken place, who is nowhere concerned with the property at all. He's a third party. He's not a,
They are
he's
not your
not,
family members.
he's not my brother, sister, or anyone else. He's a third party, my lord. A third party includes my property in their partition deed. There is a concept called Panchayat Parikat in Karnataka. There's no need to go to the sub-registrar office. By the virtue of the Panchayat Parikat, they go and hand it over that Panchayat Parikat before the Tahsildar. Tahsildar, based on that Panchayat Parikat, he mutates the property in their name. After getting the property mutated in their name, by the virtue of their entry in the revenue records, they execute a sale deed in favor of R1 and R2. They did not have a title at all. That is my humble submission, your lordship, my lord.
Yes.
My lords, the defendant number 1 and 2 who have sold the property to me were brothers. They entered into a Panchayat Parikat. It is nothing but a.
They're not for that Panchayat Parikat should have a basis.
They have done it based on the property, all the properties.
It has to be that. Where is that? No, according property right from 1965, a particular piece of land is in the name of the petitioner, the plaintiff's father. They have been in possession of the property. No, somewhere in 1992 or when is it? 2000. 2005, I think.
2005.
2005, there is a Panchayat Parikat. No, we can understand at least those people are related to him or his family members, or they have done something. They are outsiders completely.
In respect of the petitioner, they are outsiders.
No.
But my lords, the property which comes from the ancestor of the defendant number 1 and 2 who has sold it to me.
Where is that? There should be some basis for that to show that,
Which- which is-
this property is like belongs to my so-and-so.
Which
Where
is-
that?
which is- which
Where
is
is
part of-
defendants 1 and 2's written statement?
They have never.
No, they have been placed expertly.
They have not come.
They did not come and appear.
Without verifying all that you purchased the property.
My lords, in the Panchayat Pal Parikat, my lords, the petitioner's husband, father had signed it in the year 2005.
Where do you get that?
It is recorded.
Let's see that.
MA order sheet.
In MA order sheet, my lords,
Not the order sheet.
MA order,
No, from the statements or something.
in the written statement.
My
also.
lord, I'll just clarify that out also. They've been claiming that the petitioner's father, Mudegowda, has signed the Panchayat Parikat. Panchayat Parikat has taken place in the year 2005, where the petitioner's father, Mudegowda, died in 1994 itself. That is there already.
Exactly,
it
my
is
lords.
there.
That-
In 1994, my father dies. They take it, they make a Panchayat Parikat stating that this is a family partition, and they say that my father also has signed in it. They go and give it to the Tahsildar. Where my father died in 1994 itself, they have given the Panchayat Parikat before the Tahsildar in 2005, stating that Mudegowda has also signed it. That is also fraud. That has been established. My lord, if that is the case,
Please, my
Two that
lords,
can
plain,
take,
my
two
lords.
that it can take.
My lords, plaint, my lords. Plaint para number 5. The plaint is filed by the petitioner herself, my lords, where she clearly says he has died on 21/2/2014. Where what they claim is of 1994 is.
My lord, I'll
not true.
just draw your lordship attention, page number 43. It has been recorded by the lower court stating that
My lords, it's the
as per
admission
the death certificate, Mudegowda died in year 21 to
As per
1994.
Death certificate, Muddegowda
Died
died
in-
on 21/2/1994, page number 43.
43.
The admission of the plaintiff herself, my lords, is that he has died in the year 2014, not in the year 1994. Para number 5 of the plaint, my lords.
No, finding of the. court,
Finding,
page
it's not-
number 43.
MA,
The learned trial court draw the findings on point number 2. The plaintiff pleaded after death of her husband. She became owner of the scheduled property. So and so, previous owner so and so. These facts establish balance of convenience. It reveals now that both plaintiff and defendants produced death certificate of Muddegowda.
Yes, my lord.
Both of you have produced. As per the death certificate, he died on 21/2/1994. Then how will he sign it in 2005?
2005, my lord.
My lords,
That is not at all
In respect
possible
of that,
by
my lords.
virtue of the.
1 minute, let you
Yeah.
have court heard you, let him continue. Yes.
my lords, short accommodation, my lords, I will see the death certificate and I'll do the thing.
It's a finding. How can?
My lords,
how can
my
you
lords, is the
deny
admit, no,
finding?
the
You have
point
not
is that,
preferred any appeal.
my lords, the admission was on the part of the plaintiff was that, my lords, in the year 2014, yes, exactly. Yeah.
Please understand, the court observes that both have you filed the death certificate.
certificate.
Basing on that, that's a finding.
My lords, tomorrow, my lords, I'll clarify with you.
Now,
Please,
this
only-
pattern,
only-
how many days should go on? Finally, tomorrow,
Please.
at 2:30?
Please.
Yes. Next matter,
Then number 20.
20 is.
Lord, there is an
Paying for respondent, madam.
interim stay in this.
Civil Prasad
19th
Payat.
matter.
Earlier matter, if there is interim order, extend. Yes, please. Yes, 20?
Appearing for respondent, my lord.
Yes.
For the petitioners, my lords,
You have not filed your wakalat? In 20, Mr. Anil R. Is directed to take notice as he has filed an appeal on behalf of the respondent, that is in WP number 20410 for 2023. Yes.
my lords, I'm filing the affidavit. My lords, this is a matter of maintenance, my lords, where amount of rupees 12,000 was directed to be paid to the wife, my lords, and 5,000 to the child, my lords. So my senior had argued the matter on the last occasion, my lords. This honorable court directed us to file an affidavit stating that, my lords, we will pay 8,000 per month and total settlement, my lords. This is affidavit in that respect.
Leave that.
My lords, we have deposited, the total payable balance would be, my lords, 2,07,742 rupees, my lords, up to date. From the date of the application for interim relief.
You want to go through this?
Yes, my lord, because I'm seeing right now only they served the copy.
Yes, tomorrow,
No, no, after 2:30.
post on Monday.
No, my lord,
No.
because urgency matter.
That's
On-
what, when do you want?
No, on first,
Post this matter on, first is
day after tomorrow.
Thursday. Yes, post on Thursday. The request of plan comes to the respondent. Yes. Next matter.
21.
Trial court, my lord, dismissed the appeal, my lord, on the, on default, my lord, due to non-appearance of the parties, my lord. Thereafter, my lord, we have filed the miscellaneous petition before the trial court, my lord, under order 9, rule 9, my lord. That miscellaneous petition came to be dismissed, my lord. On that, my lord, we are before this honorable court, my lord, seeking the restoration of the appeal on merits, my lord.
First, let's see the order of the trial court.
Page number 7, my lord. Earlier, my lord, we have filed the LAM is 11 of 2012, my lord.
What is the suit of which year?
2012, my lord, year.
2012 suit. When were you set ex parte?
2018, my lord.
There should be a date for that.
It is not a suit. It's arising out of land acquisition proceedings.
Land acquisition proceedings. When was it? When was he set ex parte?
9/2/2018.
9/2/2018 is
Please.
the order.
Please, my lord.
When did you file the petition?
My lord, petition filed on, my lord, 13/3/2018, my lord. Miscellaneous petition for restoration of the
Date is when?
13/3/2018, my lord.
Why it is dismissed? Let us see now. Where is the order page number?
Page number 9, page number 10, my lord. Relevant portion.
Petition was filed on 9/2/2000 to pay to direct the respondent to make reference under section of the act.
Land which is acquired, my lord, 3 acre, 10 guntas, my lord.
No, please come to
Won't it
para
be-
number 7. Para number 7.
As
Page
per,
number 10.
as per the order sheet in LAM is 11 of 2012, the respondent has filed the objection 16/6/2012. Thereafter, the petitioner has failed to lead evidence from 23/6/2012 to 9/2/2018. 48 dates of hearing. The conduct of the petitioner is in prosecuting the LAM is 11 of 2012 shows he was not interested in the prosecuting the case. The petitioner has not made out any reasons which prevented him from the leading evidence in LA miscellaneous number 11.
What
of
is wrong with the order? Please tell the court.
My lord, there was some communication problem between the council and party.
No, when you
Not
filed a
that,
petition to set aside this order, where is the IA? Where is that affidavit? You must have filed an IA law for that condemnation petition. Where is that? What was the reason to set aside that? What are the reasons you have stated? Oh,
Council was not in station, no, and there was a communication problem with the party
for
and
48,
council.
on 48 occasions. No, the court had recorded the reasons why it has dismissed.
Lord, the appellant is the village dweller, my lord, he could not understand, my lord, he is a poor person, my lord, could not understand the proceedings, my lord. For that reason, my lord, he could not appear, my lord.
No, court officer, how this MFA, there is no other papers, how this MFA is numbered? We just filed 2 order copies, with that the MFA is numbered. Insufficient. IA, nothing is required. No, yes, fine along with the IA and other things. And an order is there, for that you must have filed a petition. That petition should be there, objection should be there, nothing. Sufficient. You shouldn't file any other thing.
Lord, this appellant has examined, my lord, page number 11, may kindly see, my lord. But the finding of the trial court is that, my lord, he has not
No, your
led the
petition is
evidence.
here, I'm looking at it.
Seventeen 2019, my lord, evidence, the appellant has been examined, my lord.
So award was passed in the year 2003.
Please, my lord.
This reference in 2012.
11, my lord. You have made a letter to the land acquisition officer, my lord, for the seeking to make the reference, my lord, but they are not made the reference. Thereafter, we have approached the court, my lord. Not only thing is that, my lord, on merits, my lord, the opportunity may be given to the appellants, my lord. It is only on DNP, my lord, not on merits, my lord. Prayer before this.
Entire proceedings, every time you are absent.
My lord, prayer before the Psalm court is only to restore the matter, my lord, not otherwise. my lord.
Why should it
On
say-
merits, my lord, we
why-
can,
Why should it be
the
restored is the
the
question.
party can establish the case, my lord, on merits. Because
What do
only,
you say?
my lord, only 3 lakhs has been awarded, my lord. 3 acre, 10 guntas of land, my lord, it is adjacent to the district area, my lord, Shumaga. It is more than crores together, my lord. It is only 3 lakhs awarded. For that reason,
Stopped you from pursuing the matter.
this is
From
the,
2000, the court records it on 48 hearings, you have not proceeded with the case.
there is
Why
a
should
mistake,
that
my lord,
be shown?
admitted, my lord, there is a mistake from the parties, my lord, but it is the thing is the, my lord, rights of the parties not to seek enhancement of the.
Party should
compensation, my
also
lord.
think about his rights before doing all this. Yes,
With all this exercise, there is no purpose because even making an application under section 18(1) of the Land Acquisition Act. As per the Karnataka amendment, it has to be filed within 90 days from the date of receipt of the notice of award. Notice of award was served on the petitioner on 2/8/2011.
Hmm.
90 days will come to 1/11/2011 or 2/11/2011 because 1/11/2011 was a holiday. So I will take it as 2/11/2011. But application has been filed before the land acquisition officer on 11th of November. beyond 90 days.
Hmm.
Therefore, application seeking for reference under section 18(1) of the Act itself was beyond limitation. So no purpose will be served even if the matter goes back. No purpose is going to be served.
No, award was passed when?
Award was passed in 2003 itself, 22/7/2003. And he was intimated about the passing of the award on 2/8/2011.
That itself, there itself, there is about 8 years.
No, that's one aspect. But he was informed. He was informed of the passing of the award on 2/8/2011. 90 days will come to an end on 2nd of 2011.
There is no time limit to
No.
inform the notice, inform the award.
It has been informed that so much of amount has been awarded and he has been asked to receive the compensation amount.
No, I'm saying award is passed in the year 2003.
Yes.
When the reference has to be made in the same way, what is the time limit for you to send him the notice? There is no time limit.
There is no time limit.
Many years. So now that years has taken place in this.
Yes. Now he has made an application under section 18(1). Kindly see section 18(1) of the Land Acquisition Act. With Karnataka amendment. ಅದೇ ಬೇಕಾಗಿದ್ದು. Any person interested who has not accepted the award may, by written application to the collector, require that the matter be referred by the collector for the determination of the court, whether his objection be to the measurement of the land, the amount of the compensation, the person to whom it is payable, or the apportionment of the compensation among the persons interested. The application shall state the grounds on which objection to the award is taken, provided that every such application shall be made if the person making it was present or represented before the collector at the time when he made his award within 6 weeks from the date of the collector's award. In other cases, within 6 weeks of the receipt of the notice from the collector under section 12, subsection 2, or within 6 months from the date of the collector's award, whichever period is first expires. Now, Karnataka amendment.
I've seen 90 days.
Yes, 90 days. So therefore, he has to make an application within 90 days from the date of receipt of the notice of the award. Now the application is filed, section 18 application is filed beyond 90 days. So no purpose will be served even if the matter goes.
We'll dictate the order after that. Yes.
My presence may kindly be excused.
My lord, item number 42, I am for the petition appellant. I am filed the withdrawal memo. I am seeking permission to withdraw the.
You want to withdraw?
42, I want to withdraw. I filed the withdrawal memo also.
Huh?
I have filed the withdrawal memo also.
40?
42. MFA number 2992. It may be disposed of as withdrawal.
Take out that, we'll look at the withdrawal memo and dismiss it as withdrawal. Take that file out.
Madam.
ಅನಿಲ್ ಅವ್ರೆ ನಿಮ್ದೊಂದಿದೆ ಅವ್ರದ್ದಿದೆ ಯು ಆರ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಟೇಕ್
2011, my lord. It was on 12/7/2003 itself. That's the only clarity. Please.
My lord, on submission, my lord, in this matter, my lord, the on technical ground, my lord, it cannot be because this is the my lord beneficial legislation, my lord, Land Acquisition Act, my lord. My lord, the only land which is the belongs to the appellant, my lord, that same land, entire land has been acquired by the authority, my lord. He has deprived all the land and also only source of income, my lord. That is the problem, my lord. He could not pay the court advocate fee also before the trial court. That is what the reason, my lord. The advocate may not appear in the trial court also, my lord. That may be the problem in appearing in the matter, my lord. And also there was some communication problem, my lord. For that reason, my lord, it is only an opportunity may be given to the appellant, my lord, to contest the matter on merits, my lord, whatever it is, my lord. If there is a delay as per the submissions made by the other side, my lord, if there is a delay, my lord, definitely we will file application for continuation of delay before the trial court, my lord, section 5 of the Limitation Act.
Present appeal is filed. Agreed with her. Order passed in miscellaneous number 25 of 2018, dated 27 September 2019. The claimant is before this court. A reference, the lands belonging to the petitioner were acquired by the respondents and a notice under section 16(1).
16(1) is the award notice. My lord, preliminary notification is dated.
That is not required. Under section 16(1) of the Land Acquisition Act, a notice was issued and award was passed and award notice was issued on 12/7/2003.
Normally, my lord, 22/7/2003.
22/7,
2003.
22/7/2003. Thereafter. According to the petitioner, he has made an application for reference. And as the same was not done, he has filed LA miscellaneous 11 of 2012. On 9/2/2018, the court had dismissed the court had dismissed the applicant, the applicant filed under section 18(3) of the Land Acquisition Act, the petition filed under the Land Acquisition Act. While dismissing the said petition, the court had observed had dismissed there as there was no representation. Where is that order? That order also need not be filed along with the appeal.
It was not produced along with the.
No, my lord, on miscellaneous order only we have produced, my lord.
No, first of all, it is dismissed. Thereafter, you filed a level. First, where is that first order?
My lord, the record of trial court records called for, my lord. That's the matter.
I can understand for
May not be
something as
necessary.
basic order, why it can't be filed. For that, why trial court record? Even on the facts also, nothing is clear on in this appeal. What is the date of dismissal?
So 9/2/2018, my lord.
Dismiss.
The trial court by order dated 9/2/2018 had dismissed the petition filed by the appellant herein, observing that after appearance, the respondent filed objections on 7/6/2012. Since then, case is pending for petitioner's evidence. On 13/3/2013, respondent has filed an application under section 151 CPC and prayed for an order to dismiss the petition. The court has observed that there is an inordinate delay in filing the application, and the award was passed on 10/7/2003. And the petitioner was duly informed of passing of an award. Even after lapse of more than 9 years, petitioner failed to lead evidence. Hence, no grounds were made out to adjourn the matter as prayed for in the IA. Hence, and accordingly, an order is passed wherein the petition filed by the appellant herein under section 18(3)(b) of the Land Acquisition Act is dismissed. Thereafter, the present application is filed to set aside the said order. That came to be dismissed by order dated 27/9/2019. While dismissing the same, the court has observed the manner in which when the notification is issued and when the award is passed, and how the position, when the position was taken. And also the award notice dated 17/7/2003. And court has also observed that these are the matters on the merits of the case. Even whether the section 18 application is filed within 90 days from the date of service of the award notice. But the court, considering the fact that right from 2012 till 2018, on 48 days, the petitioner has not conducted has failed to lead evidence, and the conduct of the petitioner in pursuing the matter shows he was not interested in prosecuting the case. He has also not made out any reasons which prevented him from leading evidence from 16/6/2012 till the case was dismissed on 9/2008. And the court felt that the petitioner has failed to make out any grounds much for sufficient reasons for restoration of the case, which was dismissed by order dated 9/2/2018, and accordingly dismiss the application filed under order 9 Rule 9 CPC. Learned counsel for the petitioner, except stating that the petitioner is the appellant, not the petitioner. Appellant is a rustic villager. He do not know all that. He is not aware of all these the technical aspects. As he is not in a position to engage the advocate has not appeared before the court, and counsel submits that these are all on these technical aspects. He can't be non-suited. And the Land Acquisition Act is a beneficial legislation. As such, his case the court ought to have set aside that order. Next, then counsel appearing for the respondent submits that the award notice was served on the petitioner on
22/7/2003.
22/7
2003.
on 22/7/2003, as per section 16(1) of the Act, and as per the Karnataka amendment, the reference has to be sought within 90 days from the date of receipt of the award notice. Even if this matter is remitted back to the court, no useful purpose would be served. as the petitioner cannot maintain such an application before the court. The next para, court and this writ petition is liable to be dismissed as no sufficient grounds are made out. Next para. The court below had not dismissed this application, had not dismissed the case just because on a particular day, the advocate was not present. But in fact, the right from when award notice is received in the year 2003, this the land acquisition case is filed in 2012 until 2018, when they have failed to adduce evidence and looking at the manner in which it is pursued, that is 48 times the court observes that they have failed to let the evidence. The court felt that there is no necessity to adjourn the matter as the petitioner is not evincing any interest in proceeding with the matter. This court had perused the petition that is filed to set aside the ex parte order.
Thirteen 2018. 2018.
Yes. The petitioner has not stated, has only stated about why the council was not present on that particular day, but failed to state why from the whole basis for the court to pass such an order is that if for the last 48 on occasions, he has failed to let the evidence. Unfortunately, in the petition that is filed, except stating that on that particular day, why the advocate was not present, what was happening from the day the petition is filed has not been stated by the petitioner. As submitted by him, whether the reference was within the time as stipulated under the act and all those things or the merits of the matter, which are necessarily to be considered by the court basing on the merits of the matter. But in this case, it is not about the non-appearance of the advocate or seeking an adjournment on that day, but it is about the conduct of the petitioner who was continuously not pursuing the matter. And coupled with that, a notice that is issued in the year 2003, he come before the court in the year 2012, filing this petition also shows that how the matter is pursued. And admittedly, in the year 2003 itself, even the position was position was taken by the respondent in the considered opinion of this court. Considering all these facts, the court below had rightly passed an order, and this court finds no reason to interfere. Accordingly dismissed. Yes. Yes.
Last over matter, cell number 2. Ashtavardhan.
Where is the other side?
There is no representation.
Let's see.
Purposefully they are not.
No, 2 you have filed.
Yes, ma'am.
2.1 they have filed.
Only one I have filed, madam. Writ petition number 3337 of 2024 filed by me, my lord. I am for the wife.
2.1 is filed by them.
Yes, madam. 2.1.
And what about 2.2?
2.2 is also filed by them, madam.
What are those orders?
Actually,
What you have questioned?
my lord, actually, interim maintenance of rupees 30,000 was ordered by the Honorable Family Court
To the wife.
to the wife, my lord.
You are for the wife.
Yeah, I am for the wife, my lord.
You want enhancement of compensation.
Yeah,
And the
for
of
enhancement of,
maintenance. They have questioned the maintenance. In which case, in WP number,
WP number 3337 of 2024. I am seeking enhancement, madam.
1 minute. No, you are seeking enhancement.
Yeah.
Where is their petition questioning the quantum of maintenance?
Their petition is 28807.
288
07 of
07 of 23.
23.
Then
In-
what about this?
8083 was filed against the execution petition, madam. Arrest warrant is issued in the execution
In both
petition.
these cases, interim orders are there?
Yes, my lord. Actually, they have suppressed the material facts before this, my lord. Before this honorable court.
No, give this order sheets on 2.1 and 2.2. These three writ petitions are, the one is filed with the wife questioning was seeking enhancement of maintenance. The one petition is filed with the husband questioning the quantum of maintenance. And the other writ petition is arising out of the execution proceedings. On 25/4/2024, this court had passed an order. By the next date of hearing, if the amount of rupees 75,000 is not paid to the wife, the stay granted earlier will stand automatically vacated. Paid?
It is paid, my lord, but they have not complied with the order of 19/3/2024, my lord.
And the same was paid 19?
Order dated 19/3/2024, my lord. Actually, they were directed to submit a affidavit, my lord.
18/3/2024.
Para 2, my lord. Para 2.
What is para 2?
My lord, it is submitted by the learned counsel appearing for the petitioner wife that in fact the husband is running two beauty parlor. Learned counsel for the petitioner has drawn the attention of this
So, listening to.
19/3/2024 in writ petition number 28807 of 2023. Paragraph number 2, my lord, has drawn the attention of this court to the bank statement.
Ask husband to file by order dated 19/3/2024. An affidavit to be filed with regard to the present earning and also about the bank transactions that were filed before the court, that were filed before this court.
One more submission. They have not submitted even a single document before the trial court also and this honorable court also. In the entire three petitions.
The
As per
petitioner,
guidelines of this.
and later on 15/4/2024, another order is passed by this court. That by the time the matter is listed, the husband shall file the statement of assets and liabilities
That is the old one.
on 23/4/2024. And on 29/7/2024, as there is no representation on behalf of the respondent, the counsel for the petition is present, considering the submissions and about the urgency that is stated. This court has directed the matter to be listed as on the top of the list. Morning when the matter is called, morning also there is no representation on behalf of the petitioner. And also in the afternoon, there is no representation. Accordingly, the stay granted by this court in WP number 8083 of 2023.
And 288.
WP number 28807 of 2023 stands vacated. Post these matters on September
My
11th.
my lord, one more submission. There is an arrears of 1,75,000.
That you can, what to be done now? Whatever, now there is no stay,
Okay,
whatever is
that's- okay.
available to you, please do that. Yes,
Much of it. I pray for short date.
he's appearing in all that. Yes.
Much.
Read. Adinarnare, N. Kumar.
Yes. Please use the mic. Yes.
My lord, the first document is, my lord, that the fixed deposit made in favor of daughter, my lord, one is 75,000, another is 1 lakh. The current value of the FD is, my lord, 3,05,425, my lord. The second document is, my lord, the 35,525 rupees school fee paid to the daughter. Document number 3, third page is, my lord, that the receipt showing the payment of 35,528 into the school fee.
Yes.
And the fourth document is, my lord, bank statements, my lord. They're showing some expenses made to the daughter, my lord.
Yes.
Apart from that, my lord, a 50,000 has been paid by way of cash on April 2023, my lord.
Just now you have given her.
Yes, no, my lord. Before only I sent through WhatsApp.
He has sent through WhatsApp. I have taken a printout already. Except for 135,000 fees paid directly to the school, not even to her. Spectacles, Zomato,
No.
jacket. I will just submit. This is the expenses which she has met out. Now, there is one more information this honorable court wanted to know. When did he file this NOC? It is on 8/4. That is subsequent to the order of this honorable court. So Mr. Sebastian is on record advocate for him, who has contested the matter for maintenance of 15,000 rupees, my lord. And there is one more 1 lakh rupees what payment he is telling, which he has done it. That is prior to my maintenance application itself. So that doesn't fall into this bracket at all, my lord. That is paid before 21, February 21. The maintenance application itself, as your lordship has seen, it is on 2/12/21. That is paid before that. So this court, when it's passed an order, after that, what is the payment he has done is that 135,000, which is straight away given to the school, not even to her record. Other than that, spectacles, jacket is given by the college, which he has come and given to the child. He has got one T-shirt. He has accounted Zomato also in this, that he has spent for the child for Zomato. That is all the expenses which she has met out. With this, how is she going to survive? That is my question. 12 years old child. This is from almost from 8 years. When the child is from 8 years, she's
So now
managed.
we have to take it as 2,35,000.
But that's
Fair
50,000,
enough, my lord.
50,000,
Because he paid to the
my lord,
school straight.
The 50,000 by way of cash is paid, my lord.
By way of?
Cash, my lord.
Where do you
That is
get
on-
that?
Then she has to accept that.
No, where do you,
It's not cash.
where do
No, no,
where do you
Just
speak?
I'm making submission, my lord.
No, where is it?
On April 2023. There is
No,
no
I
record. my
don't
lord. There
think
is
so.
no
I've
record.
received any cash.
No, there is no proof, my lord. There is no
No,
proof.
I mean,
But the fact remains,
why
my
they
lord,
will tell
you have
lies
paid.
and all?
My lord,
Why lies will be
Lord.
told? He is of a habit of transferring
my lord,
everything.
my lord, in the morning, my lord, they made a submission that being a father, he has not spent a single naya pay to the child, my lord.
It
That's
is
what he
sent to
expressed on the court, my lord. I filed all these statements, my lord. To show that-
My apologies, my lord. It is directly sent to the school. I'm sorry for that, my lord. Except that 35,000, nothing. I'm talking about maintenance from the date of the order, even 15,000. Order when it has done, not even 1 rupee has been paid, including the trial court has recorded 12,500 fees. If your lordship may see the order itself, that is also not paid. Actually, 2 paragraph, if I read it for your lordship can conclude this on that basis itself. Only 2 paragraphs. Your lordship may kindly take my writ petition. Just 2 paragraphs, man.
You don't have copy of the petition, my lord.
Order is there, maintenance order is there, and I'm reading the order. I'll just read, my lord. Para 13, I'm reading, my lord. Yes, please read. Yes, my lord. Per contra, the petitioner in 275 has produced 2 school receipts According to him, he has paid 12,500 per month towards maintenance of his daughter. Then para 14. It is worth to note that both the petitioner and respondent have produced similar school fee paid receipts, but there is no documents to show that petitioner, that is he, has paid the school fees to his daughter. Moreover, he has not produced the cogent materials to establish that he is regularly paying to 12,500 towards the maintenance of the minor daughter. The respondent in GNWC has contended petitioner is a software engineer, has an income of 2 lakhs per month. It is relevant to note he has failed to submit affidavit of assets and liabilities. The conduct of the petitioner is sufficient to draw an adverse inference. The respondent in GNWC has requested a maintenance of 40,000 per month. It is pertinent to note she is also working, and accordingly her statement 97,000 is her annual per month income. In this situation, it appears that she is also capable of contributing. Petitioner, being the father, is equally responsible to meet the education and other expenses of his daughter. In the circumstances, petitioner is capable of. This is the reason which I have made me to come before this honorable court for enhancement. Para 11, she also records my salary is 97,000, my EMI is 83,000, I am left with 25,000. So that is why this court has concluded on this. Second thing, my lord, if your lordship may kindly see the objection statement filed by them, which I have pinpointed annexure E, except denying that, I'll take your lordship to the concerned annexure also. Annexure E is the objection statement filed by the lawyer to the maintenance application, my lord. My maintenance application is page 71.
If you pay this 2,60,000 immediately, we'll hear this petition or else no.
Can I say something? With your permission?
You can tell your advocate not to the court.
One more submission, my lord.
Yes.
He's working in Spain. Again, he goes back. We will not be able to catch him. Every month he has to pay 40,000. One submission. 40,000 rupees this honorable court has directed. Even to get that 40,000, I will not be able to trace him. We have sent the Amina to his house. He was not found in the evening. Next day, early morning, he is gone. Then they could find him and get him to the court. This is the state of affair, man.
May I make one submission, my lord? All the way he came from Spain, my lord, only to attend the court proceedings, my lord. When the court is posted for next date, my lord.
15,000 that is granted by the court is not questioned by you. Now, even as on 15,000,
Yes, ma'am.
from the date of petition till now, which you have not questioned, if you pay that amount, we will hear, though as rightly pointed out by her, those kind of reasons which you state cannot be taken into consideration. Still, the court will hear the review petition, provided you deposit this money. Once you deposit the money, then only the review will be heard. Or else I'll pass orders right now.
My lord, this is not a review petition. He has invoked order 9, rule 13, ex parte order. This is not an ex parte. He has not even invoked 151 inherent power of the court.
Ultimately, your client wants money. Let her have it. Your client wants
Oh,
money.
yes, sorry, sorry.
Can you just hear to me?
Why you can't tell him? Please tell your advocate.
Well, he is seeking 1 week time, my lord, for payment. Be calculating 15,000 per month. 1 week.
It's already calculated.
Yes, my lord.
2,60,000, deducting is 2,35,000.
1 week time may be granted, my lord. 1 week.
My lord, he has funds. The other house, 2-bedroom house, he has let it out for rent also. He's staying with his parents' house when he comes from Spain. He has money, my lord.
We will post this matter on Monday, provided on Monday, if you pays at 2,65,000 to 2,60,000 before the court, but give a DD to the lord or a transfer, whatever it is, by the time the matter comes, that time you'll hear it.
What he does is, he gave 1 lakh rupees DD before transferring the 2 lakhs. 1 lakh DD in the name of a minor child. Minor child doesn't have a bank account.
Let us say, yes, sir. Yes.
He gave a DD in the name of minor child. Minor child doesn't have a bank account. So he says, I'll give it to the child. I don't understand.
Well, we'll transfer the amount, my lord. Transfer the amount, my lord.
No, has he received it or not? Have you received the 2 lakhs?
Then the court said you transfer to her account.
Yes.
He did it.
When this court on a red petition filed by the wife seeking enhancement of the maintenance from 15,000 to 40,000. 40,000. This court had, when the matter came up for admission, this court had permitted the council to take out notice on the counsel appearing for the respondent before the trial court. Accordingly, they have taken out notice on the counsel appearing before the trial court and filed a memo to the effect before this court. Then, even after that, as there was no representation on behalf of the respondent husband, this court had passed an order whereby the amount of maintenance is enhanced from 15,000 to 40,000. Now the present application is came to be filed. It's a order 9.
Order 9,
Rule 13.
Rule 13.
He filed an application under order 9 rule 30, order 9 rule 30 to set aside the
Ex parte.
order. According to him, that order is an ex parte order and his advocate has not he was not aware of the order or the writ petition filed before this court. And even his wife has not informed him. And in the WhatsApp chat, he came to know about the order passed by the court. This is opposed by the learned counsel for the respondent stating that it is opposed by the learned counsel for the wife stating that the notice is served on the counsel. As on the day the notice is served, he is the counsel. Now they are coming up before the court and saying that the counsel has not intimated to him. If that is the case, have they initiated any action against the advocate is also not forthcoming. She submits that only with an intention to delay the payment of maintenance. And as they have filed the EP before the court, filed the EP and the court is insisting for the payment. Now he has come up before this court. Next part. With regard to the maintainability of this petition and all, this court would consider the case of the petitioner at a later point of time. The court below had granted, the family court had granted 15,000 as maintenance. The petition was filed on 2/12/2021. Till now, till August, there are 33 months. For this 33 months, at 15,000, the amount would come to 4,95,000. It is admitted by both the parties that an amount of rupees 2 lakhs is paid to the wife and 35,000 towards the school fees. That is 2,35,000. If the same is deducted from 4,95,000, the husband is still liable to pay in amount of rupees 2,60,000 as per the order of the.
Sorry to interfere. From the date of application till today, it comes to 36 months.
36.
6 months.
It's
And it
2/12.
Yes, my lord, from 22,
about
date
8
of
months.
application.
Huh?
22/1/21. 22/12/21 is the date of application. The order is from the date of application.
22.
12/21.
How
From-
come it will come?
From there
No,
till
from-
today.
Till 23/12 is 2 years.
Yes, 2 years. And as on today, that is the date is
That is
36
12
months.
24 months plus 9 months.
9 months.
8 months. That is 9 months. That
9
12th
months.
month and this 33 months. What did you write? An amount of rupees 2,60,000. When he has not even questioned that order of granting maintenance of 15,000, is bound to pay the maintenance by this time. If the husband pays an amount of rupees 2,60,000 by 5th of August, then this court would hear the petition that is filed by the husband under order 9 rule 30, post this matter on Monday.
Submission, my lord. In the meantime, let them not precipitate the execution.
Till such time, the wife should not proceed with the execution.
They have filed an affidavit that till he solves this, he will not go back to Spain. He's filed an affidavit before the family court.
But this
The court has
separate wording, my lord.
insisted on
With
that.
respect to payment of interim maintenance concern, my lord, we undertook before the executing court saying that till the issue is resolved, my lord, we are not going to work, my lord.
The
What
court
is
has,
that till what, till when you are not
Till the
doing?
payment of interim maintenance, my lord.
till
It
interim
is
maintenance.
submitted by the respondent is present, the husband is present before the court. And on instructions from the husband, then counsel for the respondent submits that till the interim maintenance is paid, he will not leave the country.
Yes.
Yes.
Obligation.
Ma'am, one request. It's been 2 years since I've met my daughter. I am willing to pay this. And I'm telling you, last time the court granted me 3 weeks and I have, my daughter has stayed with me willingly. Okay, so I have submissions if you want me to share it. But now it has been so many times I have got an order from family court, high court, everything has been repealed. Okay, so I come here only to meet my daughter and go back. So there is no courtesy shown even to, for her to wish me on my birthday, even on insistence on a Father's Day.
He's met this
Small-
Sunday. This
small
Sunday he has
steps-
met the child.
We want one overnight.
Small steps like this.
How much lies he will tell in the court? He's met this Sunday. Child, I have the documents. He's suffering from dengue. I have the documents.
We
medical
want one overnight custody, that's all, Milord.
He says she's acting. So this is the medical records, which I have got it, which they have, she is tested positive for dengue. How can he make such a false submission? Sunday he has met the child. He says she's acting. He touched and felt she's having warm temperature. This is the medical records, which shows that she's tested positive. And how can he expect?
2 years since she has stayed. And last time I've got 3 weeks from the court. Okay, and I will submit how the time she has spent and what has happened. Okay, and even last
Monday
time.
we will see, Monday we will see.
And the
Yes.
school fees also I paid only on
Monday,
agreement.
Monday we will see. Post on Monday. 2:30 on Monday. No, whatever, all the matter that takes time, we'll take it over. Yes, next. Oh. No, please.
Matter of 230 for order, serial number 48. Then Michael Paris for petitioner. Ian.
There are two petitions filed by us. Yes, please. I'll just pass on a very short synopsis, only two.
Take that.
Same. Last time. Same. A single writ petition is filed challenging two IAs. And my brother has filed one more writ petition, that we will come to later, my lords. The two writ petitions where we are the petitioners, I am before your lordship. This is WP 14996 of 2024, challenging orders passed on IA 4 and 5. The date of marriage, as your lordship sees in the synopsis, is 23/12/2015. And then the child was born on 16. He is almost 8-year-old. Date of separation is 19. For the past 5 years, they are separated. Now, father has filed a petition under JNWC. Earlier, my lords, Annexure D may kindly be seen for a minute. IA 1 we had filed in 2021. The court passes an order on 9/3/2022, which your lordship will get in the synopsis, granting visitation from 10 AM to 6 PM, and there were other orders with regard to video. That is the order, earlier order. Now, my lords, we also filed an IA 3 for change of school. By the time that
You are appearing for the husband.
Husband is the petitioner before your lordship in this case. Then what happened, my lords? That there was an order passed by the family court allowing us to change the school. That order was challenged before this honorable court, High Court. By the time the matter came up before this honorable court, what happened was the school to which we had sought for change, that stage had gone. So the court in WP 8861, your lordship will get, this honorable court passed an order allowing us to file a fresh application because we wanted the child to go to A school, but that A school had only kindergarten. Now the child had to go to an upper level. So the court said, you are at liberty to file an application. Based on that, we filed another application, IA 5 for change of school. This is one thing. That IA 5 is also before your lordship. That has been rejected. That's why we are before your.
No,
IA 4 was filed.
The first writ petition is your writ petition.
14,996
of 24.
20.
So 14,996 is filed questioning two IAs. IA number
4
and
IA number 4 seeking modification of the visitation orders passed on 9/3/2022.
IA number 5 is with regard to the school.
Now IA
change the school now.
Please, IA 4, I request your lordship to kindly.
What is his His writ petition.
They had filed, the wife had filed, there's a mother had filed an application for maintenance. That was also rejected. All three IAs are rejected by the trial court.
No, the wife is not receiving any maintenance till now.
Not a.
Wife is not receiving, she is employed, she herself has admitted. She is getting around 55 to 60,000 rupees per month. And the husband is getting around 45,000 to 44 to 45,000.
Son's school and all.
Son's school is, we are not paying it anything. Now we are ready to pay. That's where I am before your lordship. I will submit. Till 2022 we have paid. Till 2022 we have paid. That they have admitted. Absolutely no.
And no maintenance is paid to the, at least to the child, other than this school fees.
Till 2022,
What was paid?
10,000.
10,000.
10,000 per month.
Not per month.
Apart from the court,
10,000.
Huh?
10,000 was paid.
no school fees.
2022 manors.
No, that's what.
I will
2022.
give the details. Just find out.
Hmm.
Now, my lords, IA4, your lordship may kindly see. IA4 was filed. Annexure E, page 97 may kindly be seen.
Yes.
Annexure E, page 97. Well, lords, these are the three prayers we prayed for. Video calls every day between 3 and 4. Visitation, weekend visitation from Saturday to Sunday with overnight stay, and 50% custody during the school holidays and vacations. This is what we had paid. Now, your lordship may kindly see the orders passed on IA4, which in the synopsis itself I have referred to the page numbers. Annexure A, page 30.
Yes.
Kindly see, my lords. IA 30, the sum and substance of the case made out by applicant petitioner in the affidavit filed in support of, could your lordship lay hands, my lords? IA 3 is petitioner is the father of minor child so and so. Respondent is the mother. For visitation rights was granted on 9/3/2022. Maintaining the visitation rights for every Sunday, the same visitation time granted by the court is not sufficient to petitioner in order to have the love and affection of the child, with the child. The respondent had agreed to allow the petitioner to talk with the child every Monday, Wednesday, Friday in a week. It is further contended that now the respondent is not allowing the petitioner to visit the son and she cannot deprive the right of the petitioner to visit. If the order is not modified, it will lose the bonding of the father and son and the love and affection toward child. It is further contended that if the order is modified, no prejudice will be caused. It is therefore petitioner prays. It is a contention of the affidavit filed in support of the para 2 minutes, in support of the application at IA 5 that your lordship may later come. Now the operative portion, my lords, kindly come to page 40.
No, at page number 32, please come to page 32. 32. Page 32, internal page 5 of the order. Just read the 3 lines from the top. It is further contended that
the family member of the respondent are using to influence the child with a witchcraft and black magic, etc., which affect the life of the child. It is further the respondent being.
father being a educated person, what all on this?
I'm just taking your lordship. We have never pleaded that. That's what we are respectfully submitting before your lordship. Whatever has been said in the IA that may kindly be seen, and even 3, 4, 5 my lords that we have sought for, kindly see. That's where I request your lordship to kindly come to page 40. Page 40.
Yes.
Kindly see, my lords. 4th line from top. IA 4 for the modification of the order dated 9/3/22. On perusal of the order.
Earlier, what is that is exercising by order dated 9/3/2022?
That itself is there in 40 minutes between 10 AM to 6 PM on every Sunday. That your lordship will get in page
On
40.
every Sunday from 10 AM to 6 PM.
Kindly see, my lords, below that 4th line, 6 after 10 AM and 6 PM, your lordship may kindly see. The reason shown in the affidavit filed in support of the application is
the order of the visitation right is insufficient for the petitioner. He sought for visitation right every Monday, Wednesday, and Friday in every week. We never sought this. We never sought this. That's where, my lords, as the child is school going,
Where
definitely
is that application page number?
page 97. We didn't ask for Monday, Tuesday, and Wednesday. We Wednesday and Friday.
Every Saturday morning at 10 AM and drop him back to the house on Sunday by 6 PM.
Witchcraft and all.
Yes.
Witchcraft and all.
No, you never said. Just practical
And witchcraft and all, I don't know, my lords. Our IA may kindly be seen, our affidavit may kindly be seen, my lords. This Monday, Tuesday, Wednesday, we have never asked, my lords. It will affect the education of the minor child, and it is nothing but interference in the education. And it's enough if the earlier order is retained is what is given. Now, my lords, my only submission here would be this. And your lordship may kindly see 9/3/22 order is continued. Yes, that's one thing. So 22 to 24, and the child has grown. And we have given some photographs where on Sundays when we were visiting the child, and the child was visiting the father between 6 and so on, all the photographs that we have enclosed and photographs. Your lordship may kindly see the photographs. Annexure E series is there that your lordship will get that all the photographs are there, which will evidence that we have enjoyed very happy time with the child, page 90 onwards. The child is quite old, and I'm given to understand that your lordship also had interacted with the child. So this is the time, irrespective of whatever be the allegations, my lords. Maybe I am a good father, good mother. I mean, chemistry between them is different. For the child to identify some things, we will learn good and bad from our parents. That's one aspect. That's where I restrict as far as IA4 is concerned. Now coming to IA5, my lords. IA5 is another application that your lordship may kindly see. Yeah. This, yes, synopsis I have given. My lords, IA5 is filed subsequent to the order passed in WP 8861 of 2022.
8861 or 62?
2022.
88, you said 88?
8861.
61 of 2022.
Please, my lords, it is at annexure H, page 13.
Page
13, my lords.
13.
113, my lords, sorry.
113.
113.
Yes.
Operative portion 116, your lordship may kindly see, my lords. That's enough.
Yes.
The respondent husband is at liberty to file an application seeking appropriate relief. The concerned court shall hear both the parties and pass necessary orders.
Where is this school which the boy is studying? How far it is from the house?
Dean's Academy.
Dean's Academy, that we have given a comparative file. I mean, reasons before that, my lords, I'll just take 2 minutes of your lordship. This synopsis itself says, my lords, it is a Dean's Academy Whitefield School.
No, before that, where is the school and where is the other school? The which they want to shift now.
It's 800.
We wanted to shift to Greenwood High International School,
Where
Sarjapur Road.
where is the boy staying?
Boy is staying with the mother in Whitefield.
Whitefield. So what is the distance between the school and the mother's place?
A mother,
850
page
meters and
21,
15
page 21.
850 meters is the first school where he studies and 15 kilometers is the other school.
Page 21, we have given the comparative list, my lords. Now, why I wanted the change, I would like to respectfully submit.
What is the fees in this school?
My lords, page 21 may kindly be seen, my lords, of the paper.
It's not there in page 21.
This compilation you have to give me to quote.
Petition.
Page 21 may kindly be seen, my lords.
20?
21.
21 is your,
Of the writ petition.
anyone is hockey, swimming pool, like
Yes.
something.
Complete.
Comparative table of different schools.
We have given this comparative list of all, what is better, what are the facilities that are available in different schools, and how the child can commute, and how there is a van facility. All those things are one aspect. Before taking your lordship to this, I would like to draw your lordship's attention to 2 or 3 factors. One was that me being this school, though we have made several allegations, one way of looking at is how the school may have to be avoided is one respectful submission. The other respectful submission would be that if there are better opportunities and avenues for the child and the father can afford it, and he says, I will take the responsibility of the.
What is the fees of that school?
It may be slightly higher. We have mentioned that also, 3 lakhs per annum.
6 lakhs 20,000.
Huh?
6 lakhs per annum.
What is his income?
International syllabus, not for ICSE.
Not for international syllabus, ICSE syllabus, approximately 3 lakhs rupees. Whatever it is, my lords,
No, it can't be whatever it is, because you're saying when it comes to the maintenance, what is the income of the husband and the wife, and proportionately whether he'll be able to pay it or not is also an issue.
my lords, he has given his income to be 50,000 rupees approximately for it. So it will come to 3 lakh rupees per month, per annum. And he is ready to give an undertaking that whatever be the fees come, and she is also getting 50,000 rupees per month. We are not interested in that, my lords. As far as the child's education is concerned, father will give an undertaking that he will bear the entire educational expenses of the child.
Is it he wants the boy to be changed from one school to the other because the school belongs to the wife and their family? Or that he wants to give him a better education?
My lords, that's where my respectful submission to your lordship would be. It is not that I said that. There is one way of looking at it is, I requested even day before yesterday, there was a Father's Day where the child had to go, the father had to go, but there was no information. And the child questioned him, why you did not?
That can be
That's
always,
different.
that can be always addressed. No. All that can always be addressed. Further, the remedy is not changing.
Perhaps even assuming and there are n number of complaints against the school. We have produced all the
Number of complaints by whom?
Complaints by several parents, not just this parent about the school. There is no place to pee is what there is a group of the parents of the school, my lords, and there is no toilet is not cleanly maintained. And there are so many other aspects which we have, the entire thing which we had placed along with our IA had been is placed before your lordship. I am not placing anything which was not part of the records before the court. These were the chats between the, amongst the parents of the school, my lords, as to what are all there and how much of fees they are demanding, and the reciprocation from the school authorities is not up to the mark with regard to various aspects.
Starts at what time?
His school starts at
8 o'clock.
Not the present school.
Present. That also 8 o'clock.
8 o'clock.
Other schools?
6:20. 6:20 pickup for 8 o'clock.
So 6:20 pick up, 8
8
o'clock
o'clock.
school. When is it, when the school will be over? At what time?
2:30 school gets over, the child is back by 4 o'clock.
6:50 pickup, my lords. 6:50 is pickup. Breakfast in the school, 6:50 pickup, breakfast in the school. And then the child will come back home at lunch at school and comes back at 2:30 or 3 p.m. Breakfast, lunch included.
School gets over at 2:30. He cannot come home at 2:30.
Can he come 15 kilometers by 2:30?
No.
By 3 o'clock. 2:30.
It's okay.
I will give that, my lords.
Your
I'll
lordship
give
may
the-
hear at length.
That is, that email I will produce, my lords. That's part of our records. We will produce that. We will mark it, we will show it to your lordship, my lords. Now, my lords, I am requesting your lordships to kindly see the infrastructure facilities and other facilities that are available with other schools. And I would like to put my son in an ICSE school. These are some aspects. And your lordship may kindly come to the compilation that I gave, where the interim application filed by the father along with other documents, my lords. There we had produced annexure 9, my lords. That's page 32, my lords. My lords, we had even requested the principal secretary to provide us an opportunity to allow me to meet the principal and the staff members to know the ups and downs of my child's career in the school. That was not even accepted or responded properly, because the principal secretary to the government directs the principal to consider these aspects. These are all aspects, my lords. Those are all one set of aspects. And the different chats that are there, if your lordships were to see, page 50, my lords. Yes. Page 50. Somebody says my son fell in sand area. Somebody says toilet seat is broken. Somebody says my daughter had infection due to this and refused to pee at all in the school. So many things, my lords. The washroom is very dirty. I didn't see any cleaning auntie. These are all the statements given by several people, my lords. I'm just requesting your lordships on two aspects. One is, I wouldn't say that the supposing the chemistry between the authorities and the father or parent mother could be somehow monitored or said to be like this, that's one thing. But when I can get a better education for the child, that's what I am looking at, my lords. And nowadays everybody goes, and in this, from the same area, several people go. I didn't want to put myself into the shoes of the mother also. I said, I have suggested a school. There are other schools. You can choose any other school.
Why
Better
not
school.
this school?
4 schools we have given, my lords.
Why not this school?
This school is because of all these things, and it is not at all up to the mark. And when I can afford as a father for better schooling of the child, I would rather be permitted to go. My lords, ultimately, even if let us assume and go to an extreme situation where in normal families we don't agree on sending a child to A school or B school between the spouses. At the end of the day, what do we focus on is whether I can afford my affordability and the feasibility and the child's overall growth. If
The father should also tell the court about what is the extracurricular and other activities.
we have mentioned here, my lords, we have
Not
given.
about this. On the present school, what is he doing? How is it bad for him?
My lords,
Is he not doing good in extracurricular activities?
kindly see, my lords, we have given here, my lords, 21 page, may kindly see.
Yes.
Playground, my lords.
It is not about that school. I'm asking what is happening in this school.
Present school also we have mentioned.
It's a comparison. What is that he did in the school and what is the,
That's why, my lords,
how he's
kindly-
faring in it?
Kindly see, my lords, page 21, last column may kindly be seen, my lords. Kindly see, my lords. Playground 1 used as parking, no playground, and no information against yoga, martial arts, tennis, football, cricket,
No, the
all
fact-
these
no,
things.
the- no,
And
the
then
fact- Now the fact as it remains now is father custody is not given to father. Mother is as of now, she is in custody of the child. She is taking care of the school and other things. Now, at this point of time, we'll not go into all these things. If father want an access, not to create a ruckus in the school and not to create any kind of things, if he wants to know about what's happening to the child and what is his future, and all, because mother definitely taking the photos, placing that he has that infection, that it doesn't mean that mother has no concern for the child, that it's alone the father has.
I'm not on that, my lord.
So.
There is also a
now let-
POXO
let
case
there
in
be-
the school.
Huh?
There was a POXO case and then there's so
In
many.
every place, in every place, that's going on. Now, if you want to look at a school, if you have to say that's a good school, you have 100 things to say. And at the same time, you want to say it's a bad school, you have 200 things to say. So that's not the criteria. No, there may be people who say that the school is very good. Now, at this point of time, what the court can understand is that because of whatever is the wife's affiliation to the school and the husband's distance from the school has made him for this. First of all, now the boy is into so many activities. Every day traveling about 1.5 hours, 2 hours before than the other school is not warranted as of now. If it is 800 feet or whatever
800 meters, literally
800 meters, he literally goes to the school and come back. Why should he be prone to all that?
I understand, my lords. That was the logic. If your lordships, with great humility, I would like to submit. That was the logic that we had applied earlier when we said nearer the school, the better for the child was the earlier thought. Now it is not so, my lords. We want a holistic, approach because the mother is employed.
No, let
father is
the,
employed.
let the
That
father,
it is
let
in
the
that
father,
context.
let the father appraise the court. What is that, what his son is doing other than the school? He's not doing anything.
He is not doing, the mother says, I have given the child, I have put the child to this, that, several extracurricular activities. And then the child doesn't get sleep at all. That's where, my lords, we wanted the holistic approach where in this school, all these things are covered and there is a timetable, there is a schedule where it is very well organized so that the child need not have to stress itself, overburden itself. Kindly see, my lords, in their application.
Shall we do something like that? Even in the next school also, father will not have any say in that. And that also mother will monitor.
That could be done, my lords.
The mother will only monitor, he cannot go to school. He cannot, only on a parent, except that limited access we will grant. He will not have any kind of access like how he wanted. It will not. If he is, that's in the interest of the child, let the child be joined in the school and then that school also, except paying the fees, remaining things mother will take care.
Parent teacher and regular where the father has to Father's Day, those minimal things can be done.
But ultimately, to the whatever is the control, that control will be with the mother.
Please, Manoj, that
He
could
will
be
be the
worked out.
only one who will be communicating with the school authorities with
That
regard
that
to
could be worked out.
any
That could be worked.
any
I
of
think
the.
that could be worked out. That could be worked out. Absolutely no issue. Because she is also, I'm given to understand, my lords, with all respect, whatever be the difference between that. I'm given to understand that she's a qualified lady and a counselor also in the school. I think she would play a better role and we have to respect that. We have to pay respect.
No, I've spoken to her about this. We have spoken at great length about this, and this is not the first time that such a bogus offer is coming up. Also, it has come up on multiple occasions. First of all, my lord, kindly turn to the application that they have filed. The very application that at page number 97. Sorry, not that one. The next, the IA number 5.
7.
Sorry, IA number 5. This has to do with the school.
Yes.
At page 117, your lordship will have it. May I read your lord? For the reasons stated in the accompanying affidavit, the petitioner herewith prays to direct that the minor's child's school be changed from the current institution, that is so-and-so to so-and-so, or in the alternative, to any other neutral school. This itself gives the entire game away. He is not interested in the minor's education or whether he gets a good education or not. He is interested, basically he has set up, he thinks that the school in which the minor is studying is a school that is hostile to him. And the school that he proposes to place the minor in is a school that is favorable to him. So that is the entire thing here, or in any other school. My learned friend had placed great emphasis on the fact that in the order that is impugned, the court has said that, sorry, I'm getting mixed up between the two orders, but now on this particular case, kindly turn to the application, the writ petition itself at page number 21.
Yes.
Here is the comparison between some 5 schools. Your lordship has interacted with the child. No doubt these facilities that are detailed over here are very impressive in all these schools. The lordship has interacted with the child. Did the child, in my observation, there is not a single element in their affidavit, in their oral submissions, or in anything before the High Court or before the trial court that this child is not well brought up, that this child is not well educated. Their entire case stems from the fact that this school is run by my great aunt and my father sits on the board. That's it. Anybody else would be proud to say that, yes, my in-laws family runs such a school. It has more than 2,000, 3,000 students, but no, he is very hostile to the school itself. He does not want his child to go to the school. The Learned Senior Counsel says that the children will learn good and evil from their parents. But that's not the point. The point is not that we want our son to learn good and evil from his parents. We want him to learn what is good. Now, at the moment, what are his circumstances? His circumstances are that he goes to a school that is 850 meters away from the house. My circumstances are that I can afford to pay 1,85,000 per annum for this school. They would say, and they have said, that his salary variously, they have said that his salary is some 40,000, 50,000, 60,000 rupees per month. But then obviously, he has filed a statement of assets and liabilities in which he says that his salary is 50,000 rupees. Now, what is it? Is it that he can afford a school that is 7,22,000 rupees per annum, which is way more than his salary, way more than his monthly income? Is he going to pay the entire school fees towards this monthly, is he going to pay his entire income towards the school fees? It cannot be the case. Then what is the game plan here? The game plan is simply to impoverish me. And I'll tell your lordship why. It's here. It's like this. First of all, through an order of this court, get this child moved from this school to another school, which I cannot afford. I can afford about 2 lakh rupees. So I cannot afford this new school. Then when the child pay for the school fees for the first year. And then even though an undertaking is made, don't pay the school fees subsequently. Now, what happens to the child? Learned Senior Counsel would say that everything must be done in the interest of the child, but what happens to the child? The child has gone to a new school. He has made new friends. And because I cannot now afford to pay the school fees and the father is not willing to pay the school fees, I must move him and disturb his education. And this will happen maybe not in the first year, maybe not in the second year, but it will happen when he is comfortable to make me uncomfortable. I am the target of this entire litigation. So what does he have? What is his grievance? He says that he is not permitted to come to the school. He has no access to the school. Kindly see the compilation that Learned Senior Counsel has passed over. This is a complete chat with all the parents in the class. Complete. Everything is various parents complaining about this and that. How did he come to know about it? He has access to the school. He comes to the school and he comes to the school, demands an interview with the school principal. No doubt, as a parent, he ought to. How does he know who to meet? It is because I have seen to it that he is on the school's EduFlex platform so that he gets every alert that he is supposed to get. Even today, even the alert that he said that he did not get on Father's Day, he got. He does not want to come. That's quite a different matter. The photographs that I have produced along with my statement of objections, your lordship may kindly see it's the volume 1 that I have filed. Volume 1 on page 112. It starts on page 110, the fold out page, volume 1 of the statement of objections to the first writ petition.
It is dated 15/6.
Dated 5/7/2024, my lord.
5/7?
5/7/2024, I had submitted 2 volumes.
There are 2 volumes.
Yes.
This is what the date appears to be 5/4/2024.
I'm sorry. Page, does your lordship have page 110? It's a fold out page.
1/1?
110. I think your lordship is referring to my writ petition for maintenance.
Are you referring to the photograph?
Yes, my lord, I am referring to the
They are
photograph.
there.
This is the photograph that he has posted on 110. That he has posted on his Instagram. That's on Sports Day. The next page is something that he has posted in the premises of the school. My lord, Learned Senior Counsel says 2 years ago. So be it. Let it be 2 years ago. The next page, page 112. These are, kindly see the second page. At the foot of the page, there are 2 photographs. This gentleman here is the petitioner.
Yes.
He is in the school. It's not that he doesn't have access to the school. Kindly see the next page, page 113. The gentleman crouching and taking photographs of his son very proudly is the petitioner. He is before the court. Page 114. This is the annual day on which he attended. Look, it is his posting. He says at the foot of the page, his handle is Alibaba. He says so-and-so's annual day. That's the child. Now, these are photographs and these are his postings on Instagram. These are the very same handle your lordship will also see is when he has undressed the child and posted it on Instagram. But that's not the point. The point is that he says he has no access to the school. He does have access to the school. Kindly see page 115. Annexure 15. At the top of the page, the middle of the page, my lord. On Tuesday, February 21, 2023. Look at the salutation. This is the way he addresses the principal of the school. And that is why she responds at the top of the page. The tone of threat on this email does not augur well for you. What does he expect? What does he expect? He comes to the school and tells the principal that I should be fired, that I'm an unfit mother, and that I should be fired. Learned Senior Counsel has passed over a synopsis. My lord, may kindly have a look at this synopsis, which contains what the other side has also filed. But he comes to the school, and your lordship may turn to page 4 of 8 of the synopsis and says on 3 of 8, it starts at 3 of 8. First, he comes and demands to see the child at 8:30 p.m. when the child is sleeping. Then he telephones the principal and tells her to terminate my employment. For what reason? I'm a bad mother. I do not get along with him. I have given him a khula and divorced him. All very well. But for what reason does he want my employment to be terminated? It all ties up with the fact that he wants me to be impoverished, that he wants me to come back to him begging, saying that I have no means, so please look after me. He knows that my parents are aged, that they cannot support me for a very long time. He says, he abuses me, saying that I'm a bad mother. I'm an unqualified counselor, which is quite different from what Learned Senior Counsel is pleading before this honorable court. And this is what he has done. Under the pretext of taking an appointment with the chairman of the trust, page 4 of 8, not the synopsis that I've given you. He could.
Where did you get that from?
This is in our pleadings.
What is the basis for that?
He abuses me to the principal. He slanders me. This is why I have filed an OS number 219 before the family court, and in which an order of injunction has been granted against him. He cannot expect people to be very, very open to him and very hospitable to him when he himself is hostile all the time. Now he comes to now let us address the matter of Milord of this child being the visitation that he wants. Kindly turn to the order, Milord. The other statement of objections, Milord. It's a thinner volume.
Yes.
Your lordship will find that at page number 168, he files an application that is dated 18/12/2021. This is numbered as IA number 1.
Yes.
Kindly see the prayer. For the reasons sworn to in the accompanying affidavit, it is prayed that this honorable court may be pleased to grant an order for the interim custody, visiting rights on every Saturday and Sunday between 10 a.m. to 6 p.m. of the minor son, namely Master so-and-so, now aged about 4 years, 4 months, or in the alternative interim custody between 10 a.m. on every Saturday to 6 p.m. on every Sunday. Kindly turn to their very IA at page number 97 of the writ petition. Of the writ petition, IA number 5. It is dated 24/8/2022. For the reasons stated in the accompanying affidavit, the petitioner above named prays that this honorable court may be pleased to modify the order dated so-and-so. There was an order passed in this IA number 1 that is dated 9/3/2022. Your lordship will see it at page number at page number,
Which order you want? the
179. Page number 179 of my paper book, of the thin paper book.
Has she not filed the order? No, at least both of you refer to one set of papers which are not exclusive, so that the court is easy for the court.
Very well. I'll,
Actually, the order, improved order.
not the old order, 9-3.
9322, order 47. 9322. Page 82.
82, my lord. Kindly turn to 82.
Yes.
Your lordship will find the operative portion of the order at
88.
88.
Yes. Reasons and 9 conditions.
The petitioner, the last two lines, the petitioner is permitted to visit and meet his minor son. And an order is passed, which has been followed scrupulously. I don't think in the past 160 weeks, he has missed probably 3 times, in which we have offered him alternative dates and additional dates also. He is permitted to meet the child every Saturday between 10 a.m. and 6 p.m.
Sundays.
Sorry, every Sunday from 10 a.m. to 6 p.m. This is the order. This very same order that has been ordered upon is now sought to be re-agitated once again in IA number 5. So basically they are barred by constructive res judicata.
In these kind of cases, seeking a modification is not.
If he was so aggrieved, he would have challenged that order at some point of time.
It is not being aggrieved. After some time, that keeps on changing in respect of that question of res judicata won't arise in this.
But he cannot ask for this very same relief that he has once been denied, my lord. Otherwise, I will never go to trial. That case is not going to trial at all. He will do anything and everything not to go to trial. We are at the IA stage itself.
When is the GNWC filed?
The GNWC is filed in, actually this GNWC is filed in 2021, but it was filed in the year 2020 because he filed it in the family court, which did not have jurisdiction. It was filed in GNWC 14 of 2020.
Yes. Now,
Now, my lord.
Now on the first IA is with regard to change of the school, IA number 5.
Yes, ma'am.
IA number 4 is for change, modification.
IA number 4 is for modification.
IA number 5 is.
IA number 5 is for change of school.
So what are your further submissions on change of school?
My lord, at the moment, the child does not require a change of school.
Yes.
He has every facility that is provided that the petitioner claims that he ought to have. Even at page number 21, there is absolutely nothing in this page number 21. They have turned it into some sort of beauty contest between the school that the child studies in and the school that they want the child to go to. But never mind. Just kindly look at page number 21, my lord, and just for a moment, I'll quickly go through it. The criteria by which he decides that this child should go to another school is the size. 40 acres, one school has 40 acres, another school has 4 acres, another school has 5 acres. So biggest is best. Let's go to 40 acres. It's not as if this child is going to every day do a picnic, going to do a round of 40 acres. A school may have a campus of 40 acres. No child is going to be allowed to loiter around the school. He will go to school and he will go to his classroom. He will do according to the timetable. The distance is not 10 kilometers. It is 15 kilometers away from my house. I am the custodial parent. I will have to make the child ready early in the morning and send him to school. I will have to bring him. I will have to be there to meet him and take care of him when he comes back. At the moment, what are his circumstances? I take him to school with me because I work as a counselor in that school. I bring him back with me. I am there for him practically all the time. When he goes to the school, he has no such access to me. What is the board? There are 3 boards. He himself says so: ICSE, IGCSE, and IB. There is no preference here. There is absolutely no preference here. In the schools that the child presently studies in, it's a CBSE school. Now, what do they find that is so exceptional about the CBSE?
Yes.
Nothing. There is no reasoning. Total number of students, 2,500 versus 2,000. Playgrounds, they have 4 or 5. 4 to 5 playgrounds. Is it possible for a child to play in 4 or 5 playgrounds?
Yes.
There's yoga. There is no, apparently in this school there is yoga. In my school, there is no information. There is martial arts in this school, but there is no information about my school. So he doesn't get it. So I have already sent him for martial arts in which I have detailed in my application for maintenance, which he denies. He does not want to pay. There is lawn tennis in that school. There's no lawn tennis in the school. This is the sort of application that the court below is supposed to adjudicate on. And this is the way that I'm supposed to, as a parent, supposed to decide that, yes, this school has multiple football grounds, therefore I should send him there. It's not whether he's getting the coaching or not. He does go. Your Lordship interacted with the child. Your Lordship, I think he would have told you also how well he's doing at football. It's not as if this child is not getting the holistic education that Learned Senior Counsel alluded to. He is getting it. What is it now that is at the sum and substance? What is the crux of this case? I want to control you. The petitioner husband wants to control the wife. That's all. Cricket, multiple grounds with net practice.
Yes, I've seen.
Yes.
Yes.
So this is the sort of comparison that your Lordship is expected to decide upon. How is it possible, my lord?
Yes. Yes. Then on visitation.
On visitation, my lord. He gets the child every day from 10 a.m. to 6 p.m. Sorry, every Sunday from 10 a.m. to 6 p.m. We have never denied him except 3 or 4 days. Never ever denied him. Even when the child is not well, we tell the child, please go, otherwise your father will make a ruckus. He comes there every weekend to my house. He makes a ruckus. He abuses me to the security guards. He abuses me in the vilest of language to the security guards. So now what I've advised my client is to take the child at 10 a.m. and deliver the child to his house. Even there, I get choice abuse on the streets of Richmond town. Choicest abuse. It's all right. At least it's not happening in my house. At 6 p.m. when I go to pick up the child is placed on the roof of the car so that he falls, and I am to blame for it. This is exactly how the visitation goes on. Now he wants the child to be taken to him overnight. This is their prayer. They want the visitation to be extended overnight. The child is terrified of the father, not because I have tutored him. I have sent him on every date of visitation. But he's totally terrified of the father because of what the father does and the father's conduct with the child. He scolds everybody in his house. The child says he scolds even the grandfather.
But the statement that the child is terrified by the father is not correct. It is not. It's not. Maybe that's your instruction from the client, but the boy doesn't say so.
Very well. Your Lordship has interacted. I won't stress too much on what. I leave it to your Lordship's judgment. Now, he says that one of the reasons why he ought to have this overnight access to the child is because he has been denied video calling. We have never denied him video calling. Look at his own record, own call record. Kindly turn to his own writ petition. Your Lordship will find these papers.
So call is between what time and what time?
Exactly, my lord. Exactly. Kindly turn to the video calling record, my lord. Your Lordship will have it at its
So
extent.
as for the court order, how much?
There's no timing, my lord, but look at it from page number 164. It is at any time of the day. The first video call is at 1600 hours, 164.
That is
At
not.
1600 hours, when the child would have come back from school. There should be some discretion and some application of mind as to when he is going to call the child. If he says, look here, I will call every day from 7:30 to 8, I will make the child available from 7:30 to 8. But he calls, look at the timing. He calls it first call 1600 hours. Next day call 1525 hours. The child would have just come back from
May I
school.
just intervene?
No, let me finish. You can have your say. Next is at again 1600 hours, 8:30, 4 o'clock, 4 o'clock, 5 o'clock. There is no time for his calling. He calls whenever he wants. Pages and pages of this. He calls it any time that he wants. We have not said that we will not give the child the access. The child has access, but when does he have to call? Let him suggest a time. I will keep the child available. The child has been given a phone only for this. Only for this, he has a phone. More than this, he cannot use the phone because he is only 7 years old. He has it. If he wants to come on, he will come on. If he does not want to come on, it's between he and the father. He has access to the child. He does not use that access in the way that he ought to. And then onus is placed on me to ensure that the child is speaking to him. How is this even possible? He says that he wants to have, when he has access to the child, he abuses it. And then he turns it around to me. How am I supposed to ensure that a child speaks to him? Can I bring the child before the video and say that you sit here and you talk to your father? Now you say this, now you say that. I will be accused of tutoring.
Yes.
It should be something that comes from within, from the child himself. That is not forthcoming at the moment. My lord, on the matter of maintenance. Either he has deposed falsely in his statement of assets and liabilities, or he has deposed falsely in his affidavit to change the school. He says that he has the means to pay for the school, which is even 6 lakh rupees per annum. That means he must have money to live. And he says in his pleadings that when we were living together, we have made as many as 8 or 9 trips, international trips in a year. That means there is money to live, but his affidavit itself is false. Either way, he's up for a perjury prosecution, but never mind. Let's not go there. Kindly see at page number 11 of my writ petition, my lord, the second writ petition, 18705. What is it in this writ petition that in this statement that he finds objectionable? Nothing can be found objectionable. My school fees alone are 1,85,000.
How much you sought for maintenance?
We had sought for 1,00,000 rupees per month.
How much to the wife and how much to the?
She earns 58,000 rupees per month. He runs a shop on Brigade Road. He sells bags, ladies' handbags, ladies' lingerie, and a whole lot of other clothing. He's doing very well. He does not account for all of his earnings. And he says now that he's only an employee. He's the manager of the shop. He claims that he's the manager of the shop, which he owns. At page number 11, paragraph number 11, my school fees are 1,85,000 per annum.
Number?
Page number 11 of writ petition 18705.
Another writ petition.
My writ petition. My school fees are just 1,85,000 rupees. This, according to me, is a reasonable school fee in Bangalore. Miscellaneous school expenses, I've just sought about 2,000 rupees a month. It is not his case that this child is not a well-brought-up Muslim. We have educated him and given him every single thing that he requires for his Islamic studies.
Yes.
It is not his case even that he does not go for football. The child is doing extremely well. Football is his passion. It is his case that there is no martial arts in the present school. He's getting it here. It is his case that there is no tennis in the present school. He's getting badminton here. He gets swimming. He gets art, dance, and music. Very well. Learned Senior Counsel said that I have enrolled this child in so many activities just to keep him engaged. Fine. Let him say which of these activities he does not want the child to go to, that he does not want to pay for. Medical, dental, and vaccinations, I am asking for just 50,000 rupees per annum. It's not an unreasonable sum for a child of 7 or 8 years. For clothes, shoes, and books, my lord, it's not as if he does not spend money on the child's clothes. Every time the child goes to his house for visitation, he undresses the child, makes him wear a fresh set of clothes. At the end of visitation, he changes them back into his old clothes and sends him away. He keeps a wardrobe in the house. For food and nourishment for the entire year, I'm only asking 1,20,000. All in all, it works out about 9 lakhs per annum. And this, he says, he cannot afford to pay. How is it possible that he cannot afford to pay any of this and he has not paid since 2021, even a paisa? But he wants to send his child to a school where this year the school fee is 7,22,000.
3 lakhs, sir, it is here.
Kindly turn to page number 124 of the writ petition, my lord.
Which page?
Kindly turn to page number 124 of that writ petition. It's almost at the end. This was the academic fees for the previous year. We could get it. We could not get this year's printout in time at the time of filing this writ petition. Academic fee structure for AY 2022-23. It's 1,10,000 plus 1,27,000 into 3. That's 4,92,000. Straight away 5 lakhs. This is the school that he proposes to put the child in. Straight away 5 lakh rupees on the first 4 entries. He has the money for it, but he does not have the money to pay for his child as he is today. Learned Senior Counsel said that the child will get food in the school. It's not free. It costs 45,000, 46,000 rupees per annum. That's about 50,000 rupees. He has to go to school by bus. They alluded to a bus that is available. Yes, children go to many schools. Should children go from my particular complex as far as Aditi school in Hebal? Yalanka. Children do go. It's not that they don't go. Should this child go, but were he to go, he would pay 75,000 rupees only for bus fare. All in all, he would pay 6,15,000 rupees just to admit this child in the school. Where is this money coming from? If he says he doesn't have it or his income is only 6 lakhs, Where is this money coming from and why is he unable to pay the maintenance for the child? There is no answer forthcoming. Even the trial court just dismisses it, saying that you are both making frivolous allegations against each other. You don't deserve it.
Yes. Yes. Completed?
I've completed.
Yes.
164 page may kindly be seen, madam.
164 of what?
My red petition, our red petition.
Which page I'm looking at, I'm not even able to understand.
The
Those many.
WP 14996, I'm only referring to this.
Page number?
164.
Right with 106.
2 minutes only, I'll take it.
Right with 106.
Yes.
Kindly see, my lords, the video calls my learned friend referred to. They're all calls where they are not attended to. In the first page itself, your lordship will get 164 itself, the bottommost one. Supposing it is an honored call, then your lordship will get 14 seconds like that. Could your lordship lay hands, madam?
Yes.
Like that. Next day also morning, there is 14 seconds.
No, for this, there shall be a time fixed for that.
That's
and-
not
Yes.
That-
I'll be grateful if
No,
the lordship.
that's not on
Yes,
That's one thing.
No. Coming
Now,
please come to page number 11. 11 of his papers. His writ petition.
In res judicata, constructive res judicata, I don't think your lordship will need it because
That need not.
can be modified is what the Supreme Court has said.
Yes, not required.
Please,
It's 11.
please, my lords.
No, the expenditure per month in respect to the boy, she's showing it as 76,233. Let father bear half of it.
My lords, this whole thing, my lords. That's where I said, my lords, all these things, the child is moved from one place to another place like that. It's going around. On the other hand, if we put the child in one particular campus, then what happens is all these
So
aspects are
what
taken
happens
care
is
of.
what they give you in the school, what by way of sending him to the special classes or where exclusive classes, that won't be one and the same.
Definitely, I agree. But this school also has got now, it is an integrated methodology, my lords. Your lordships
So,
are
for
aware.
example, in the school, he can have either of the activities. All these activities, even if he is there in the school also.
How many class, my lords, your lordship may kindly see here.
Is any your mother is taking, father is not taking her.
Martial arts, badminton, swimming, all these things, my lords, everywhere now, my lords.
No.
This
no,
is part of
even
the,
let us assume that the boy is joined in the school.
this is
They
part of,
they will say which activity. Either you go to this or go to that, one or two.
That's where
But
I'm-
not all 6 activities won't be there.
I,
But
I'm
these
coming
happen
to-
in his house, in his home,
I'm
in the
coming to
complex.
the same thing, my
The
lords.
complex.
This is what I'm
What it
requesting.
will ask him, which activities takes place in the house? Tell the board.
My lord,
This
except
C-
except
no,
C and
no.
D, except
He
C
has
and D,
Islamic class.
that happens in the house. D is football,
Ah.
she goes away.
Ah.
E, F, G, H,
All outside.
all
only.
are in the complex where he lives, Silver Oak gated community.
Then H is also there.
It's there in that gated community.
Hmm.
Because there are many children in that community. That's also his case. There are many children in that community.
Let the father pay. So half of this 76.
May I just,
Yes.
may I just, my lords, if the child is put to a holistic school, my lords, a school where the whole thing is taken care of, probably that would be an ideal situation. And father would undertake to pay for this, my lords.
Otherwise, he'll not pay.
Not exactly like that, my lords. I'm respectfully submitting that the child, when child has got the opportunity, it can is my respectful submission. We have to look at the possibilities.
Yes.
Miscellaneous expenditure 10,000, whatever it has, he has said food and nourishment 10,000, 76,323. She has put the whole thing per month. clothes, shoes and books, 7,000
Oh,
per month she has
everything-
put.
Everything is half.
7,000 per month is what they have put.
No, but the problem is.
I'm not
whatever the
here on accounts. I'm not on accounts.
activity is whatever he is learning that repeatedly they have to change his school shoes and all for this football and they're very expensive. Every 2 months, 3 months, they need to change.
Well, I'm not on the account side, my lords. I am on one aspect.
No, that is one aspect that I've heard that will pass. Now, as far as whatever that she has mentioned here, no, it's only half of it. Half she has to bear that she is also earning. It will come to somewhere around
38,000.
38,000.
We are given to understand, my lords, with all some of the classes are stopped is what the child has told the father, that some karate school classes and swimming classes, maybe the child doesn't go for, I mean, once the winter starts, it's quite common with the children not going to some classes and other things. This is one part of it, my lords. I would submit, my lords, let the child be admitted to a good school and all other expenses can be either taken care of by the father or with the mother. The first important thing for the child, even without consulting the client or the instructing counsel for the client, I would say, let the child go to the best school and all other things can be worked out in a very, and the mother can be asked to take a call as to where it should go.
Lord, I just my one last submission. Kindly turn to page 118 of my writ petition, my lord. This is the statement of assets and liabilities. It's not as if he's an ordinary person. He's an income tax assessee. He has produced his returns. His employer is Classy. That's the name of his shop. He is the manager operations of a shop. He says he has a monthly income of 50,000. That's 6 lakh rupees per annum. And that's it. That's the extent of his income.
He has not filed income tax returns.
He has filed it before the trial.
That also like.
That also like this one.
In line with it.
Yes.
Please come.
And our 50 lakh rupees for jewelry, which they had admitted is with them only. That's all. I mean, even that is one of the things that we had mentioned. That 50 lakhs jewelry is with them. If that is kept, that family jewelry is used, even according to them, they have admitted somewhere. So if that is used, we need not have to even worry about anything. Let us leave it at that. Only request is to see to it that the child is sent to.
You can use it for the child.
Yeah.
Let them show where it is admitted. We have not admitted anything of that sort. There is no jewelry that we have taken. We have been kept outside the house on 19/6/2019.
Mail.
Bag and baggage, we have been kept outside the house. And we have been told to leave without the child. 2 hours later, he comes and dumps the child in my father's house. And now then he moves a GNWC petition.
File it if there is. File it if it is there.
She has mentioned this, nurse.
Let them file it.
Let them file. If
Let
you
them
file
file.
it, if you file it and now if you say that with that whatever that can be done, then it will be
them file it.
sufficient.
No, there's a.
File those documents. File those
Let them
documents.
file
by
it
way
under
of an
affidavit, then it's.
No, what I'm submitting is that
Or they
50
cannot?
lakh, no, I'm with you,
submit
I'm
it
with
as an
you.
affidavit.
That 50 lakh rupees jewelry is taken by her.
If it is there, if it is admitted, if it is there, then let that be used for the school, child's education. And then
With the schools change and other things they can use.
Everything is on a condition. This is exactly my point, my lord. Everything is on a condition.
just to fall on facts, it should be clear. Please ask your client whether she accepted or not.
No, my lord, we have not.
Ask her.
I have spoken at length about this. These are not new allegations. These are very old allegations.
Then even that email and anything that
Let
is.
them file it, my lord.
Where
Let
is
them
the
file it
admission?
under-
No, I'll record that you're saying that your client has never
No,
said.
we have
so.
not.
I'll record that then.
Correct, sir. Where is the jewelry? Where is it? That you put on.
Let them file it under affidavit.
Where is that? The second part.
We have been tossed out of the house. There's no time to take jewelry and leave.
He has received. Confirms that he has received. Where is that? Email you.
Okay.
Fine. I will get it.
Do you find anything?
I couldn't here.
Hmm.
Here in this document, I couldn't find. I am asking him to take it out.
Then what to do?
Well, it's leaving that, our submissions may be
No,
taken.
the court is no, not passing any order as far as the change of the school is concerned.
Hmm.
And number two, as far as the maintenance is concerned,
Hmm.
if you're only for that purpose, court wants to know about the jewelry. If you say that we don't have to pay the maintenance, otherwise half of the maintenance has to be paid.
For the child,
The child,
for the child.
not to the mother, to
Not
the
to the
child.
mother. Fair enough.
Whatever the expenses, half of it she'll bear, half of it he has to bear.
Visitation, your lordship will independently.
Visitation
Yes, sir.
will.
Will
And now, for this visitation, now the boy, it seems he goes to all the Sunday, the right from morning and all.
Father will take care.
No, instead of mother, father will let father take him to classes and all.
And she should not
Because of
put
football.
unnecessarily the child, so to avoid father, she should not put the child to.
No, let the father take him and spend time.
Fair
with
enough,
him.
my lords.
No, he
What
has threatened
happens
the
is-
coach.
What
threatened
happens?
The coach saying with legal action I'll have, you are in contempt of
My lords,
court.
This is too much. my
No,
lords.
no. If this is the case, I will put it on affidavit. Kindly pass over. I'll put it on affidavit.
Kindly.
He has threatened the coach with the
No,
contempt of
what
court.
we say that it shouldn't happen. It shouldn't happen.
Let him take.
No, it is even, wife can also like, one responsibility, let him also share in the
Definitely.
morning, take him to the class. That day, like after the class, let them have, spend time.
Definitely.
That's how it can
After
be.
all, what he does, he takes him to Airlines Hotel, he takes him to Kaban Park or his shop.
Yes,
What do you see?
on,
On Sunday, he can take him
On
for
Sunday,
football.
the birthday would be not pay.
Offered him. Every time there's a tournament, I have given him the option. I said, come and attend the match, at least do something that your child likes. He withdrew him from the tournament.
No,
He benched him
no.
15 minutes in the
No,
match.
all that you told me the other day, that's not the point. No, on a Sunday is his class, every Sunday is.
Every Sunday.
He doesn't have to, he has, when the matches happen. They
Not
usually
regularly.
happen. Not every Sunday.
Not every Sunday.
Not every Sunday.
None of these classes are on a Sunday.
We are generally kept Sundays free for this.
For him, only sometimes tournaments happen. For 3 months, maybe there'll be Sunday classes, which I take him in the
So
morning.
whenever the tournaments and even in between also, like, if not on a Sunday or some other day, if the tournaments goes on and all that
I'm
stuff,
happy to tell him.
he'll let him also go.
I will let him know if, I would rather he sees the activities the child is happy doing.
But let him not abuse her in public.
And
Let him not abuse her.
the tournaments when I'm. He's abused me in PTA meetings in front of the teachers. He's abused me in front of my son. Mama, you know what dad said.
No, as far as that also is concerned, no, on every activity of the child, no, this is whenever he's having football matches, the father can accompany. And on a Sunday, from morning to evening, he can spend time with the boy. Because with all this schedule, let him have, what will happen is, what he is also not understanding is, whole time, even if both mother and father are together, if you expect the boy to sit with you the whole day, will you sit? He'll not sit.
Weekends.
That's what, Saturday, what will happen on a Saturday, all these classes and other things he'll have. If he wants to participate, be part of it.
Father will take care, my lords. Saturday to Sunday, now the child is growing, my lords. One thing is, my lords, one thing that we have to, I mean, with the great respect, I would submit that the either of the parents should not be a visitor in the life of a child. That's one thing.
That's what.
Unless I sleep with my parents, unless I sleep with my parents, I sleep, I mean, under the same roof. I stay under the same roof. I don't get that comfort feeling, which will be something that will be too missing for the child alone. I would like to say that. That's where, my lords, as the child grows, your lordships are, of course, even with us also, how many minutes have we spent with our parents every day? 10 to 15 minutes we might have spent. But the subjective satisfaction that it gives to the child is something different. The child has to bond with both the parents, both the extended family members. That's where the overnight custody cannot be avoided at all at this age. And what happens is, as the child grows, it gets used to one type of routine, and that clock cannot be unturned at a later stage is what I would like to submit here with all.
My lord, one does
That's
not
where
follow
my
the
lords,
other.
I'm not an adversarial fight in this case. I'm
Learned
not.
Senior Counsel's line of reasoning, one does not follow the other. Unless the child is with the parents, he will not have any familiarity. One does not follow the other. He has to make an attempt and he has to first access the child. He has generous video access to the child. He does not use it. Let him first make an attempt. Let him first use what he has before saying that I want to have every say in the child's life. This is all about I, me and myself. It's not about the child.
No, apart from this, she says that.
She says that if he does not sleep in the same house, he will not have any.
Please,
This is a choice that he has made.
No, your client says that she wants the father to be part of the
Yes.
son's life.
Yes.
So what else are what are the other activities?
These are the activities that he goes
No,
to.
no, where the father can join.
Let him come forward.
Because she has to tell the court.
Which other activity?
There has to be.
Everything that happens outside the house, everything else is inside the house. In our community, it's a 4-acre property, so swimming pool, indoor badminton, all that happens inside his martial arts class. Whatever happens inside the society. Football is something I take him. He wants to come for that, he can come for that. His tournaments happen, let him come for that. School, whatever he wants to be involved in, let him be involved.
And that also he says now he's going to this Barca club. You should change him to SUFC. There's no logic in this. He has been admitted. He has been enrolled in one particular club to play. No, you change him to something else.
See, we will not agree. There is no question. If I say it's day, he will say it's night. There's no there's no way. Please, and don't tie my hands. I should have the freedom to parent my child.
Annexure Q, Your Honor. She has threatened the Football Association, where he was my child. She writes in Annexure Q, if you should have a spine, she tells them, the Football Association. She has refused to give the father's name or the contact number. I get to know my child is going to football after a few months. That's when Apan told me, my son's name is Apan. December 2020 to March 2022, she cut all access to my child, number one. Number two, this school, why we want a change of school is not only because of infrastructure. Infrastructure is what makes the child what it is today. They have also been witnesses in the false dowry case that she put against me. Her father, her uncle, employees of the school. When I go to the school, Your Honor, I think the WhatsApp chat is there, Your Honor, and think her cousin threatens me. Then the other cousin apologizes to me. It is there in the petition. My lord, please. My lord,
No, I think
This will not.
the place where.
Kindly
let us
turn to
get
Annexure
fight.
Q. Kindly turn to Annexure
Yes.
P and Q.
Please
Kindly
come.
turn to Annexure P and.
Please come.
Enough.
Agreed with orders passed in.
Stay there. Enough,
Agreed with
Mr.
orders
Ali,
passed in
please
I
stay there.
number. I number 4 and 5. And maintenance is 6, sir.
Yes, ma'am.
I number 4, 5 and 6. Both the wife and husband are before this court. The I number 4 is filed by the husband seeking modification of the order dated 9/3/2022. And I number 5 is filed by the husband to change the school of the boy. And I number 6 is filed seeking maintenance of an amount of rupees 1 lakh, which is filed by the wife. The court by orders impugned had dismissed all the 3 applications by order dated 27th April 2024. The facts of the case are the differences between the parties. The son is staying along with it is the custody of the mother. Father had filed GNWC number 53 of GNWC in the year 2020. And later, the same was transferred and numbered as GNWC number 53 of 2021. Earlier, he has filed an application for visitation, and the court had passed an order on 9/3/2022, wherein the father is granted a visitation rights on a Saturday or Sunday. Sunday between 10 a.m. to 6 p.m. And in a day, how many days in a week? Video call.
Any day. Any day.
The father can speak to the child on a video call any day of his choice. Thereafter, this present I number 4 is filed seeking modification of the said order, whereby the husband sought to speak to the son every day between 3 p.m. and 4 p.m. and also have overnight access to the son by picking him up on every Saturday morning at 10 a.m. and dropping him back to the mother's house on Sunday by 6 p.m. and 50% of the interim custody residence rights to the father during all school holidays and vacations, either in the first half or in the second half. The court, while dismissing these applications, has observed that the husband has sought for interim custody and also sought visitation rights of his minor son, who is in the custody of the respondent. The court observed that because of the indifferences between the spouses, the child will be made to suffer and will be deprived of the love and affection by either spouse. The father is having equal right over the minor child. As the age of the child, as on the date of filing of the passing of the order, is 4.5 years, and he is in the care and custody of the wife, unless the child attains certain age, the custody of the child with the mother is appropriate. Later, the custody of the child is to be decided consistently with the wish of the minor. And accordingly, the claim of the husband with regard to the custody is rejected and is permitted to visit the son on every Sunday from 10 a.m. to 6 p.m. and is permitted to take the child outside the residence of the respondent. And the wife and the family members are directed to permit the husband for visiting his son. And also, there was a direction to behave cordially to the husband, towards the husband. And further, the father should see that the visit would enhance the overall well-being of the minor son. When it comes to the changing of the school, earlier, when the court has allowed the IA for change of the son, is it correct?
Change of the school.
From the present allowed. And the wife had questioned the same by filing WP number 8861 of 2022.
But it was for a different school.
Huh?
It was for a different school.
Change. I said
Change was for a
of
different
school. Not this school. I said in a change of school she asked earlier.
The earlier one was for a different school.
When they have asked for a change of school earlier, and the court has permitted, the wife had to challenge the same by filing the WP number 8861 of 2022. Then this court had disposed of the writ petition as by the time the time frame to join the school is already crossed. The court had disposed of the writ petition, giving husband to the liberty to file an application seeking appropriate relief from the hands of the appropriate court, and the court was directed to hear the matter. Thereafter, the present application came to be filed, IA number 5. The relief that is sought in the present application is the minor child school be changed from Dean's Academy, Whitefield, to Greenwood High International School, Sadzapur Road, or in the alternative to any other neutral school as prayed for in the affidavit. An affidavit is filed in support of the same, wherein he had stated about the wife and her connections with the present school where the son is studying, and how in collusion with the employees, cases are registered against him, and the employees or witnesses in the criminal cases filed against him, and how the request of how his request was not honored by the principal when she wanted to meet her. And he has narrated about how the school and the employees therein were hostile to him. It is stated that he has paid the fees for the Dean's Academy from UKG till April 2021 until she cut off the access of the petitioner from the school. And it is his case that he has no access to this present school, and they have not shared any details with him. They have a software called Eduflex, which is an online software for parents, which updates the parents on the development of the child. And he has been purposefully blocked by the respondent and Dean's Academy, Whitefield, from the online access. According to him, the school is exhibiting a lot of carelessness while treating the injuries of the children, and he has not been intimated about the important school events. And the Aadhaar card is also changed. And it is stated that while choosing the school for the child, he has kept in mind the infrastructure of the school's campuses, and the school which he wants to change is facilitated by the world-class infrastructure for academic and co-curricular activities. And they are aesthetically and ergonomically designed classrooms, make learning easier by removing physical hindrances, and ensure that students are focused on learning and the comparison between the current school and the intended school, wherein he has mentioned about how this school is better than the other school. And also, apart from that school, he has given about some other schools which are good for his son. The court the wife had filed her objections, and she has also narrated about how she has been thrown out of the house and how the husband has treated her. And she had stated what kind of extracurricular activities are there in the school. It is the case of the wife that petition, the husband is part of his activities and all updates is part of it. And all the allegations or all the averments in the affidavit, she has filed a reply, she has filed her objections to that. The court below, by order impugned, had dismissed the petition. Where is that order?
Annexure A itself, madam, in the first appellation that I had given. All the three.
Where is the discussion in that? Huh,
No discussion at all. Straight away. Here, with regard to, from para 13, page 40, from page 40, this goes. Page 41 is with regard to visitation. Already granted is okay.
court observed that paramount consideration is the welfare of the child shall be looked into and not the personal inconvenience of both petitioner and that of the respondent. For the better convenience, both the father and mother are required to sacrifice their needs and more particularly their ego and prestige. If really both of them intend to take care of the welfare of the minor child, they shall sit together and decide what shall be the best for their child. And it is also pertinent to note that by disturbing the school, it would affect the education style and syllabus, also the quality of education. And the safety shall be given to the child, not the prestigious atmosphere. And the prestige and ego of the father and mother, the child should not be suffered. Just because the father is not having a good rapport with the school and they are not permitting him to enter into the school, that would not be a ground for changing the school. And there must be cogent and conniving reasons. The said reasons are not the reasons for changing the school. And accordingly, the said application is dismissed. And the court, even on this also no discussion on maintenance also.
14, para 14 is
14
the only short mail.
And the wife has also not made out any grounds seeking maintenance and dismiss the application. Agreed thereby, there's 3 writ petitions are filed. The senior counsel appearing for the petitioner, husband submits that the father wants to, is for the child should be given the best of education and the best of facilities. And the father is ready to pay bear all the school expenses. And the school, what is that? Greenwood School?
Greenwood High, Greenwood High International School,
Greenwood?
High International School,
Or any other,
Greenwood High.
High,
we will
High,
write.
Greenwood High School. Greenwood High School is the best school in Bangalore. And where he'll have all his extracurricular activities and all the facilities. And as per the comparative table given, it shows that on all counts, the school is a best school. Also, the senior counsel has drawn the attention of the court to some of the charts in the school group where the parents have complaints about the hygiene and other aspects. It is also submitted that when the petitioner wanted to meet the principal, when there was no permission granted, he has in fact complained to the principal secretary, and the principal secretary in turn has directed the principal to address the grievance of the petitioner. It is submitted that the court, and it should be the endeavor of all the parties to see that the child gets the best education, and it should help him in this overall well-being. When the father is ready to pay, and when the school is the best school available, the mother should not have any objection, and the differences between the mother and the father should not weigh in taking a decision about the change of school. It is further submitted that the father never had the overnight custody. When the boy is with the father, both of them are sharing a good bonding, and to develop the same, he needs to have overnight custody, which was never granted. It is further submitted that the video calls, the list that is placed before the court shows that hardly he could speak to the boy on a video call. It is submitted that the court, without considering any of the grounds that are raised, either for change of school or for the visitation, had dismissed those application. Now the father will not get an opportunity to develop bonding with the boy unless and until a overnight custody is granted. It is submitted that the father is permitted to change the school, and also he may be granted overnight custody. Next, the counsel appearing for the respondent wife submits that as per the order of the court, all through, except on 1 or 3 occasions, except on 3 occasions, he was exercising the visitation, and mother was always cooperating. When on 3 occasions we could not, later the same was compensated. The mother always wants a father to be part of his activities, but the father had never showed interest, and it is the complaint of the mother that he has been abusing her, either when he comes to pick up the child or wherever in the public places she meets him. If the wife is working in the same school as a counselor in which the boy is studying, and there is no dispute about the fact that that school is owned and managed by the close relatives of the wife. It is submitted that the husband had filed a statement of assets and liabilities wherein his income is 60,000, and when counsel submits that his income is 50,000 per month, and when counsel for the petitioner, the respondent submits that the school fees for the Greenwood High School is 6 lakhs. And according to the father, it is 3.5 lakhs.
No, by their own calculation, it is 5.5 lakhs. By their own, what they have produced before your lordship.
It is
5 lakhs 52,000, what they have produced.
As per their calculation,
It's 3 lakhs 20.
5 lakh 52,000. And it is submitted that either when the father, his income itself is according to him is 6 lakhs. If he says that he's able to pay the fees of the boy of an amount of ₹6 lakhs, either the statement that is made before the court is not correct, or the statement of assets and liabilities filed by him before the trial court or not, the statement is not correct. It is submitted that the boy is, there are so many extracurricular activities wherein the boy is part of it and mother is taking care of it. and father is not paying a single pie towards the maintenance. When the mother has, by way of a table, has categorically stated how much money she's spending for all the activities, absolutely there is the court below failed to consider the same, and no maintenance is awarded. It is submitted that as per the application, very same relief, and the order was passed on 9/3/2022. Now they are seeking an order by modifying the said order. He submits that is barred by res judicata, and they cannot seek such a relief from this court. It is further submitted that the visitation that was going on, where the father is not making his best efforts to have the bonding with the boy, and this is not the right time where the overnight custody can be given to the father. It is submitted that the court had rightly dismissed the two applications, IA number 4 and 5. 4 and 5. And 4 and 5. The court below ought to have ought to have granted maintenance when the salary of the wife is how much?
58,000.
Salary of the wife is 58,000, and the entire expenses she has been bearing, and the father has an obligation and the responsibility to take care of the child. He wants the visitation rights, but he is not contributing and taking care of the responsibility and the duties he has to. Next. And he submits that there are petition filed with our husband needs to be dismissed, and wife should be granted maintenance. Next. I will hear the counsels on either side, peruse the material on the card. When this matter came up, on 18/7/2024, this court had directed the parties to be present, the parents along with the boy to be present in the chambers on 22/7/2024 at 5 p.m. On that day, this court on 22/7/2024 has interacted with the mother, father, and the child. As it is stated in these petitions, both of them have so many complaints to say against the other, and both of them have put forth their respective cases. This court has interacted with the boy. The boy appears to be very confident, and he is involved in different activities, and with a lot of passion, he was telling the court about the football and other activities which he is learning. On a query from the court about with whom he wants to stay, with whom is more comfortable, the boy has answered that. And when he had heard both the parents telling the court, when the court has asked him who is right, he has very maturely, he has answered that both of them have a point, but he likes both the parents, but he likes to stay with the mother more. As in the house of the father, only the grandfather stays, and even he likes to be with the grandfather, but for a long time he gets bored staying with the father, and sometimes he takes him to his shop. Sitting there in the shop is very much boring for the boy. Then the matter is posted today for arguments. Both this court at length has heard the learned senior counsel for the petition and also learned counsel for the respondent. The mother is taking care of the child from the day she has left the home, and the boy is joined in Dean's School. What is that?
Dean's Academy.
Dean's Academy.
Dean's Academy, Whitefield. And that school belongs to is managed by the father, and the school belongs to the relative of the wife. In view of the differences between the parties and the several criminal cases that are filed, father has some sort of a complaint against the school and the employees working there. And he has stated before the court some of the instances where he has been put to inconvenience. And the prayer that he sought in the IA that is filed, that is IA number 5, to change the school, where he says about to change the boy to Greenwood High School or alternatively any other school, which shows that the father do not want the boy to be in that school because of the experiences he had with the employees there, employees and the management and the principal. The court below had rightly observed that just because the father is having a difficulty or a mother is having a difficulty with the school, that itself cannot be a ground to change the school. The mother is working as a counselor in the very same school. And as the school is managed by by the close family, definitely the boy would have a advantage of it, and that is very nearer to the school. The mother is staying very near to the school, and when the boy is in custody, and when regularly she can take him to the school and get him back, which makes it convenient for her. Except stating that about a conversation in the WhatsApp group, nothing has been placed before the court to show that Teens Academy, Whitefield, is not a good school. And when this court has perused the comparative, the comparison, the table that is given in that, even this school is having a strength of 2,000 when compared to all the other schools. And the conversation on the WhatsApp that is filed before this court, that cannot be a reason for the court to come to any conclusion that the school is not good for the boy, as when it comes to there are in every institution and organization, there will be people who are happy and unhappy, and only a few of it, if it is placed before the court, that itself is not a ground for the court to say that the school in which the boy is studying is not a good school. Mother being a counselor there, and as no other material is placed before the court except the WhatsApp chat, that the school is not good for him. And looking at the extracurricular activities he is learning, and also how and he being good at basketball, football, good at football. Considering all this court is of the view that as of now his school and his other activities are going in a proper channel. Hence, this court is of the view that the IA that's filed by the father seeking change of the school is rightly dismissed by the court, and this court finds no reasons to interfere. Then coming to I number 4, the visitation is granted on a Sunday between 10 to
10 to 6.
10 to 6. Is granted between 10 to 6. The boy.
Vacation and other things are not considered.
That the court had granted it, and in that the father has also asked for the vacation, 50% of the vacation, 50% of the vacation. The court had only granted the visitation and also a phone call. What about the phone call, video call?
That the court is not.
That not granted.
But anyway, it's there, so.
It dismissed in total.
No, but that is not mentioned. The court, even as for the video call also, which she was exercising earlier, that was not mentioned. And
97.
totally the application that's fine. Only to that extent, IA number 4 is ordered. 4 is ordered. In the interaction with the, with the boy, this court has felt that the boy is comfortable with the boy, with the father. Now, the visitation that is granted is between 10 to 5,
6 p.m.
10 to 6, on every Sunday. And coming to the video calls, on every day, the boy between 7 and 7:30, the father can talk to the boy on a video call. And the mother should see that the father, the father gets, the boy attends to the phone and also speaks with the father on a video call. Then coming to the overnight custody is concerned, as he is coming on a Sunday, the father is picking him at on a Sunday at 10 o'clock, once in a month, on Saturday at 8 o'clock, he can pick up the child and leave him back at the 6 o'clock on Sunday. This should happen once in a week. Can we, once in a month?
8
Can
a.m.
we-
my lords.
Huh?
8 a.m. 8 a.m. or 8 p.m. my lords.
6, evening 8 p.m. Friday, Saturday 8 p.m. Saturday 8 p.m. and he shall be dropped back at 6 p.m. on Sunday. This overnight visitation is once in a month, and it can be as per the convenience of both the parties and looking at the child's other activities. But it shall be exercised once in a month. Next, and when it comes to the vacation and other things are concerned, anyhow that stage, the vacation. Now, when is the vacation?
School
April.
holidays and vacations.
April, May.
April and October, December, October. She has.
Sarah,
And when while the boy is like this, how this overnight visitation goes on, basing on that, they can renew the request before the court below at an appropriate time. Next, when accordingly, I number with the above observations, the order on IA number 4 is modified. Then IA number 6 is concerned. The mother had sought for maintenance. Where is your that page number calculation?
Page number 76. Annexure D
76 of what?
of writ petition 18705.
One eight,
705.
page number?
76.
No, in that change of school, Suvarna, in the change of school, the father shall be permitted to have all the access with regard to the child's development and other activities in the school. And whenever the parent teachers meeting and other activities where all the parents are permitted, where he shall be permitted to attend, and he should be, all the details pertaining to the child should be known to him. Next, the custody as on today is with the mother. Any kind of instructions or directions or whatever on behalf of the child, the father cannot give to the child, to the school, and it should be through it is mother alone who can take care of all that. Where is that? 70?
Page number 76.
Husband, the wife had filed IA number
IA number 5. So IA number 6. IA number 6.
No, this is application.
This is IA number 6 in the GNWC.
She filed I number 6, seeking maintenance of an amount of rupees 1 lakh. And she had furnished the details with regard to the amounts that are spent for the boy, right from the school fees to the extracurricular activities. According to that, he is spending an amount of rupees 76,233 per month and per annum 9,14,800. It is a grievance of the land council for the petitioner for the council for the wife that the court had failed to consider all these aspects and had just dismissed the petition. And the mother is made to bear all the expenses. The council submits that when the husband is able to pay the school fees of 5 lakhs and or 6 lakhs, he can as well take care, he is as well has to pay the maintenance that she is incurring for the boy. Next one, senior counsel appearing for the respondent submits that some of the activities, according to what the father knows, that the boy is not doing. And instead of having all these activities and he has to go around, the same can be if he is joined in the other school, all things will be taken care of by the school. This court had perused all the activities that the boy is learning, except the Islamic studies classes and the football. All other activities are in the very same complex where he is staying.
Only football.
Huh?
Only football is outside. Everything else is in the complex.
Oh, that's what. Not the Islamic classes.
That was also in the complex.
Except football, all the classes are taken with the couple of other children. All these activities are done in the is undergoing in the very same complex where he is residing. The court has perused those expenses that are stated along with the IA. It comes to 76,233. Admittedly, both the parents are working and is ready to spend an amount of rupees 50,000 at least approximately per month towards the school. If the school is, if he is shifted to the Greenwood High School, considering all the extracurricular activities and considering the fact that both of them are earning, this court is of the view that the amounts can be, both of them have to bear 50% of the expenses. Hence, this court deems it appropriate to direct the husband to pay an amount of rupees 35,000 towards the maintenance towards the maintenance of the boy. Accordingly, IA number 6 is disposed of.
May I just intervene?
From the date of the application.
Date of petition. Till
From the date of application.
application.
May I just, this Saturday, your lordship has said, could it be made that it can be on Saturday itself between either on second Saturday or third Saturday, so that would be, there will be clarity. Otherwise, again, let them not have any this. Your lordship said once a month Saturday, that could be second Saturday or third Saturday is one thing. And then pick up at 8 PM. From there, it would be, it can be.
Just write it again. The overnight custody on a second Saturday, the mother shall drop the child.
At 4 PM or 5 PM could be better, my lords. Because
The whole Saturday would
The whole
be gone.
Saturday is gone.
Whole Saturday would be gone. That's why I said overnight custody, 8 o'clock, the Saturday. And again on Sunday evening at 5 o'clock, 6 o'clock, the the mother can pick up the child, and both the parties shall adhere to the time limit. 3, the father, it is cautioned that if any material is placed before the court showing that at any of the place, if the father is abusing the wife, the same shall be brought to the notice of the court, and the court below shall pass appropriate orders on that petition.
Not direction in the matter.
Hmm?
Direction to dispose of the main matter.
The GNWC shall be disposed of as expeditiously as possible.
Excuse me, Your Honor. Can I approach you?
They are there, why you have engaged so many of them?
One second.
Please, people.
Once yes, with regard to jewelry, your lordship had, I understand the emotional turmoils the parties will go through in this case. With regard to jewelry, your lordship had raised a question, and then we were searching here. So he wants us to, because I said the jewelry is with them.
You found it?
Yes.
Please, that's where he says that it could be placed, because this is the email, my lords, where she had sent it.
Give it to their counsel.
She had sent a Kulla format where she said it had to be signed by him. He did not sign it.
Give it to
There,
that particular thing.
she had agreed. She said that under the Kulla, she said these jewelries are with us. As per the demand of the husband, I am ready to and I have returned this, is what she says, but it had to be honored by both. But instantly, he did not sign that. That's where there is an agreement.
He has sent the mail to my previous lawyer.
That's the mail.
Worth
Please,
1 crore that jewelry today, Your Honor. It's my mother's, my grandparents' jewelry which she has robbed from the house.
Wait, sir. Wait, sir. Wait, sir. She has said.
No, we have sent him the Kula. He can show the Kula.
Not the Kula.
Kulla,
Just now about the jewelry, you said she is not having anything.
No, this is a part of the Kula. He can show the Kula itself.
Yes, this year.
What
No,
did
this is
she
not
say
it.
about the
They have
jewelry?
sent it- They have sent it to the, my lords.
Hmm.
According to us, there is no Kulla,
I
because
showed
we
you-
did not sign
No,
it.
we'll not go into that. Only,
That's
I'm only, this code is only concerned with that
That's
statement.
what, that's where I did not
And
even want
only
to
to
get
that
into
extent, please respond.
We don't have it.
I can open the email right now and show you.
We don't have it.
It's
We
your
don't have
email,
it,
sir.
and we don't have the jewelry. She says she doesn't have the jewelry. And also,
No,
What-
what you do is, let this order as it is, let it be there. You file it, let them file a reply to that. Then the
Then your
same
lordship-
order will
the
continue.
Lordship can
And as
modify.
for that, we'll make we'll
Yes.
make an observation in the order. Let it be, the post this matter on, today is Tuesday, post this matter on Thursday. The Learned Senior Counsel submits that an email is addressed to the husband, wherein she admits about the jewelry belonging to the husband being with the wife. Which is denied by the land council for the
Well,
response.
Agreed to be, agreed, Andre, this Kulla she sent, my lords. This is one thing I would like. She sent this mail to the previous council on record, stating that this is how the Kulla thing will be there. In that, one of the agreement terms was that she would hand over the jewelry.
Where she had, stated that she would hand over the jewelry.
As
to
per
the
The
husband.
draft that they are showing now.
No,
Yes,
that's
yes,
what,
that is the
you can
draft.
also, you will get an opportunity, which is when in the court, when this court has specifically asked the party who is present, that whether the jewelry is with her, both the council as well as
Asking
the
for perjury, let perjury be-
both the council and as well as the party has stated that no such jewelry is with her. In fact, she has been legged out of the house and there was no opportunity for her to take any jewelry with her.
Yes.
There was no occasion for her to take the jewelry. By tomorrow, that said, the email by way of an affidavit shall be filed before, by way of an affidavit shall be filed before the court, and the respondent shall file their reply. We'll have it on Monday. Please, miss.
Obliged.
Let order as it is, you type it.
That's fine. Grateful, my lords.
There are- 1 minute, I'll call. 22 who appears?
Yes, my lords.
Huh.
The thing is, parallelly, respondent number 12 has filed a review petition. He has not brought to the notice of this honorable court. And both may be connected because it is parallelly running in the, it is parallelly filed by the respondent number 12.
Oh, the difference.
Yes, review petition number.
Files a review, he files a appeal.
Yeah, he has been attending this court in MFA 4847. An order is passed in IA number 2 of 2022. And against the order of this honorable court, he has filed a review petition, RP.
This can't be tagged on to the review. That is, the court should have the roster. That learned judge should have the roster. So it can only be deferred till that is, that review is heard.
I'm ready for my submission. Even if it is posted for tomorrow, I'm prepared, my lords. Otherwise,
When is it coming up?
no, there's no date.
Pose this
Given
matter-
as
pose
such.
this matter after 2 weeks. It is submitted that against an interim order, a review is pending, huh? Which way? Tomorrow we're not here. Yes, pose this matter on 14th of August. Yes, next.
Obligement.
23, I think adjourned.
I wanted an adjournment, my lord said.
What has happened?
Will be taken up.
Where is the other, have you informed the other side?
Yes, my lord, I will.
When do you want?
Next week, please. Any date next.
Post on 7th.
Interim
The
order. has to
request
be
of learned counts for the petitioner, interim order earlier granted is extended till then.
exercised.
Representing the respondent, my lord, pray for short accommodation, 1 week. As we filed a NOC wakalat on last
The
day,
request of learned counts for the respondent post this matter on 21st of August.
my lord,
20
one
25, my
request,
lord.
not on 21st August, it can be a posted 13 or 12 because senior will be not available.
If, but the court is also, court has some difficulty.
When is the
for,
court convenient date
when
for
it
last
Post on 27th of August.
Acha,
Yes.
Number 25, my lord, appearing for appellant, my lord, then. My lord,
20
matters before
27.
trial court, my lord. Tomorrow, there is an execution petition before trial court, my lord. It's an urgency, my lord. Date was fixed for today for admission point.
Who has asked?
Without intimating us, my lord, since from morning, we are waiting.
Post tomorrow.
Much obliged.
No, in spite of asking, I must have asked, I must have recorded in the order also.
Yes, ma'am.
That is informed to the other side.
Since from morning, we are waiting here, my lord, for this matter.
Tomorrow, I think move, already that is signed and the file is also.
Because, my lord, there is a warrant before trial court.
Friday. We'll have it on Friday.
Much obliged.
Post on Friday, 25.
26, my lord, I am per appellant. And the 2 appeals, my lord, the not alienate, not to change the nature of land. In the 2 suits, my lord, we are the appellant representing. And the last date, my lord, on Friday, the respondent advocate undertake not to alienate the properties. There was an video record, my lord, in this, the 20 code. Before.
I appeared, my lord. This honorable court has advised him not to precipitate. Advised. But my lord, it's a honorable submission was made, my lord.
Yes, day after tomorrow, these 2 matters.
On, my lord, 8th, my lord, your lordship,
On 8th,
please.
4 matters, my lord, connected.
8th, all the 4 8th. Yes.
27 appearing for the appellant, my lord, kindly have it on 7th of August.
7th of August. Yes,
Obliged.
at the request of learned counts for the appellant.
29. Kindly have it tomorrow, my lord. There is some extreme urgency in this matter. Now the matter is posted for hearing.
Tomorrow,
Very well.
yes.
Hearing for the petitioner, my lord, matter is posted for admission. Can we give
Notices
it-
are served. Yes, post this matter on 6th August,
Much obliged, my lord.
30.1, I think. Yes, 31. Let it be tomorrow. I think this memo is also moved. Yes.
Tomorrow, my lord, respondent. Tomorrow.
Maybe taken up any
With Amar.
Friday, not
Stays there.
stay there, we have deposit the amount. So you are also
I think
received.
this matter has come up the other day also. You requested.
Yesterday, some settlement still going on, but have some difference in the amount.
Day after tomorrow, my lord.
Day after
Vacate
tomorrow.
the stay, leisurely take the settlement.
ಇಲ್ಲ ಇಲ್ಲ, there is no such.
Settlement ಮಾತಾಡ್ತಾ ಇದಾರೆ ಸ್ವಾಮಿ, ಏನು settlement ಆಗಲ್ಲ. Kindly take it up day after tomorrow. sir.
ಆಗ್ಬೋದು. It may be taken up day after
Day
tomorrow.
after tomorrow.
Post on Thursday.
One night.
Next week,
The report.
What has happened, this report from Nimans?
reports, normal reports.
Huh?
I have not seen a copy of the.
No,
husband's
not
report.
about like, I think that the wife has also has to go. Did she go?
She went, my lord.
I think her report was not there on the last occasion.
Husband's report was not procured.
Husband's was not.
Now
there.
he has undergone the, this investigation. Report is,
Both reports
produced
are
before
kept,
the
my
court. Both reports are available.
So why you're asking for adjournment in the morning?
I'll file a formal objection to the writ petitions.
No objections are required for the writ petition. They are not stating anything new facts, sir.
Subject to the verification of the medical report, my lord.
But then
Matter
that
may
further
kindly
we
be
have to see.
disposed of.
This matter day after tomorrow. Yes, 34.
Interim order may kindly be
If
accepted.
interim order there, extended till that time. It's 34.
My lord, one submission, we may permit you to peruse the report.
Not, it's not possible today.
Not possible.
Yes, we'll see.
in
The next
the-
time when the matter comes, we'll see.
Appear for the petitioner appear
Will be
for the
taken up on
petitioner.
Monday, man.
And the last date of hearing, your lordship directed the respondent to produce the passport, Xerox copies of the
Copy. It is
passports.
ready. I'll furnish. It is ready.
It's ready?
It's ready.
Thursday,
No, Friday, Monday, madam. Because
Monday.
ಅಲ್ಲ, ಇವತ್ತು ಕಾಪಿ ಕೊಟ್ಬಿಟ್ರೆ ನಾವು ನೋಡ್ಕೊಂಡು ಬಂದಿರ್ತೀವಿ.
Oh, this is with that coffee plant.
ಕಾಫಿ ಪ್ಲಾಂಟರ್ಸ್, yes.
passport is ready, madam. I'll furnish.
ಅಲ್ಲ, ಪಾಸ್ಪೋರ್ಟ್ ನಮಗೆ ಇಲ್ಲಿ
Yes. All these dismissal matters, let it be on Tuesday. Which one? 37, take that. The other two matters, no, let it come on Tuesday. Tuesday, that is on 37. A memo is filed stating that the main GNWC itself is disposed of on 1/4/2024. Hence, the memo of withdrawal is filed. Memo is taken on record and dismissed as withdrawn. Yes. 38? In which case?
Number 39.
Yes. Interim maintenance. In this also interim order is there? Not there? Yes. Poses matter on 14th of August. What is this? What office objections on withdrawal? You want it on 16th? 16th, yeah, okay, I think the 16th is, we'll have it on 21st. 21st. Yes. You that, what are the office objections for the withdrawal? Memo of withdrawal is, memo of withdrawal is filed stating that that in view of the approval of the competent authority for implementation of the arbitral award, they want to withdraw the appeal accordingly. The appeal is dismissed, the memo is taken on file and appeal is dismissed as if nothing happened. No, but that their party's signature is there, seal is there. Yes, next. 41.
It's appear for appellant in this case, please. Any day next week.
6th.
So there's an interim order that may take.
6 interim order earlier granted is extended. Now it is a 2023 interim order is there in your favor. And then post this matter on.
My lord, your lordship may have it on 6th, my lord.
You are there.
Yes, I am here.
Post on 6th, yes.
Much obliged.
RPSC of 2022, post on 27th of August.
Your Ladyship, I'm appearing for the petitioner in this matter. With
I'm
the leave
appearing
of
for the respondent.
the leave of the court, I complied with the office objection, Your Ladyship. There's one more office objection pertaining to service of copy upon the respondent. I'm doing so.
Office has raised two
Yes,
objections.
Your Honor, I seek for
One
time to
is
file my objections out of
regard
the
to
same, Your Honor.
The service of the serving the papers on the counsel for the respondent, and also the other office objection without tying of the papers.
Regarding the page number had to just be
With
stitched
regard
the
to the
other way
page
around.
numbers, the petitioner has complied, you submitted that the petitioner has complied with both the objections. Yes,
Your Honor, I seek for time to file my objections to
no
the same.
objections are required in writ petitions. Post is
All right.
started tomorrow.
Much obliged, Your
Yes,
Ladyship.
Not in this matter.
Await service of notice,
But,
post after service.
We have actually served it
Oh.
by hand as per the order.
Your Honor, I'm really sorry, Your Honor. There's other matter as well. So, can this be posted in first week of August, Your Honor?
They have some
yeah.
urgency, they're saying.
I
On
have
the
not had
7th.
visitation for over 18 months.
It can't be.
Can-
We'll hear. Yes, next.
But for 45,
45.
45 in this matter, actually we have served the copy to the trial court advocate, but by
Hmm.
oversight it could not be filed in the counter. It's served, my lord, to the council.
You have to file by way of a memo like that. you
Yes, yes,
can't
yes, yes,
file.
yes.
File a memo to that
I'll-
effect.
I'll- I'll-
Yes, 46.
46,
At the request of learned counsel for the petitioner pose this matter on Thursday.
46, my lord.
Uh,
This is, my lord, disposal in the MC petition, my lord. It is not possible to serve the advocate on record. Therefore, kindly issue notice to the respondents. I will
the
pay the PF,
petition, the registry is directed to issue notice to the respondent.
please.
Yes, this 47 posted on 28th of August. That's there or
But I appear for the appellant in this matter.
There for the respondents.
2:30 matter. It is not called. Oh. Then tomorrow, 2:30 list, let it be.
Other than tomorrow, day after tomorrow, if it is.
Day after tomorrow, 2:30 then. Yes, signatures.
And the date has been given for sale of 20. Well,
26?
27,
Ah,
33,
ah, read. 33, 33.
39,
39.
43,
3.
45,
45. 45.
47. 46, madam.
46 madam, yeah. 46. Oh, madam, yeah.
47,
47. Okay. What is the banana? Wait, another banana, 45. Ah, 45 ಕೊಟ್ಟಿದ್ದೀನಿ. ಅಷ್ಟೇ. ಇದು ನಾಳೆಗೆ ಅನ್ಬೋದು.
ಅಲ್ವಾ? ನೀವು ಬರೆಯದಿದ್ದಿದೆ.
ಇನ್ನೊಂದು 9.
ಮಾತ್ರ ಎರಡು ಸೇರ್ಸಿದೆ.
So, ಅಲ್ಲ ಇದು ಎಲ್ಲ ಬಂದದ್ದು. ಮೂರೇ ಡೇಟ್ ಬಗ್ಗೆ ಮೇಡಮ್ ಆಗಿರೋದು. ಇನ್ನೊಂದು ಡೇಟ್ ಮಾಡಿ ಏನಾಗಿದೆ ಟ್ರಾನ್ಸ್ಫರ್
ಮೇಡಮ್ MFA ಗೆ ಅಡ್ಮಿಷನ್ ಬರ್ಬೇಕಾಗಿದೆ ಸಬ್ಮಿಷನ್ ಕರೀತಾರೆ ಅಥವಾ ಆಗಿದೆ? MFA ಅಡ್ಮಿಷನ್ ಗೆ ಮೆಮೋ ತಂತ್ರ ಸಬ್ಮಿಷನ್ ಮಾಡಿ ನೋಡ್ಲಿ ಮತ್ತೆ ಮೂವ್ ಮಾಡಬೇಕು. ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಬಂದ